to ensure compliance happens under this act. So with that context, let me just give a short overview of what the law has in terms of the rights framework, and it interestingly also accompanied with the duties framework, right? So you have the right to access information about the personal data that's being processed. You have the right to correction of the personal data that certain data fiduciaries have with you. You have the right to erasure of your data. And we'll also be discussing how this relates or is unrelated to the right to be forgotten. And we have a right to grievance redressal and a right to nominate, which is not usually seen in a data protection legislation. Now, the duties that accompany this, this rights framework is that the data principal and the individuals whose data is being processed will have to not impersonate another person while providing personal data. How will this affect, online anonymity is a good question that we will be covering today. There's no suppression of material information when you're submitting personal information to the state for, getting an identity document or identity proof. No registration of false and frivolous complaints. This is an interesting provision we've seen in other legislations as well, but it's unique to have it in the data protection legislation. And we'll be discussing why and how this will be affecting both fiduciaries and data principals. Well, the duty to provide authentic and verifiably authentic information while exercising the right to correction or erasure. And you also have the duty to comply with provisions of all other laws while exercising your rights under the framework. Now, given this larger overview of the rights and the duties framework, we also understand that this is a legislation that has evolved over time. There has been a lot of other rights that existed in previous versions of the bill, and some rights that exist in comparative jurisdictions, like such as the right to data portability, which isn't featured in the bill, or the act anymore. And one of the reasons could be that the way the right to data portability is viewed is more as a competition issue and not so much as a personal data or a privacy issue. And we'll have a discussion around this as well. Now, given that this legislation has changed over time and there are rights that existed previously and there are the rights that exist today, and there is an explicit duty framework that exists, I want to invite all of my esteemed panelists today to share their opening remarks and what they feel about the existing framework and what's the positive aspect of this evolved version of the act that we have today, and what might be one particular challenge or a highlight that you want to focus on today's discussion. We have a panelist who is remotely joining us, and I want to start with him, especially because he's not visible otherwise on the stage. So Amol, if you can hear us clearly, please get started and we'll start with you. So Amol is from Kutch. Please give a brief introduction as well.
Thank you, Ramgesh. I hope I'm audible and visible.
Loud and clear.
Okay, great. It's a pleasure to be part of this panel amongst these expert speakers and participating to speak on this very, very important issue. As you have indicated that the issue of user rights and obligations is a twofold. It's not only about what are the rights which are mentioned in the law, but how they will be enforced and what are the mechanisms around that and how that would impact data fiduciaries. So I think and just before I sort of move to my opening remarks, I represent CUTS International. CUTS is a consumer-facing research, advocacy, and capacity building organization. We have done a lot of work to understand consumer perspectives, perceptions, experiences, and challenges across sectors, including the digital economy. And some of what I would speak in this session is basically trying to highlight the voice of consumers who are otherwise unheard and dispersed and unable to voice their opinion so effectively. So with that, I think one of the major issues, as you said, is that it's good that we finally have a law after so many years of deliberation and discussion, and which clearly recognizes what are those rights which are there, which consumers and citizens and data principals have. However, I think uh, some of the key issues which I would like to focus on is that have we learned enough from our experiences of enforcing rights under other laws, both sector neutral and sector specific. So there was a Consumer Protection Act under in 1986. It was replaced by a Consumer Protection Act in 2019. There are several sector specific regulators in financial sector, in electricity sector, and whatnot. And within each of these sectors, there have been some rights which have been provided to consumers and citizens. And we have a whole lot of jurisprudence and experience with respect to what are the challenges and mechanisms through which consumers and citizens in general enforce their rights and what are their experiences. What I would have liked is that this law should have tried to learn from those experiences. Some of them are good, like the Right to Information Act and the journey around that, and which also is being impacted under this law. And there is a lot of scope for improvement in other laws as well, in respect to limited levels of awareness, limited capacities, role of civil society, and consumer organizations and grassroots organizations. And how do we create an environment of effective enforcement of rights so that data fiduciaries and data principals do not necessarily see each other as adversaries, but as participants in this whole digital economy, so that we have a secure digital ecosystem in place. And with that, I think we should look at this session. Obviously, I have more things to talk about, but perhaps this is enough for the opening remarks. Thank you.
Yeah, thanks, Amol. I think there was a sort of a positive undertone to it, and I'm really looking forward to discussing more on the learnings that we have from other rights enforcement seen in the sectors that you just discussed. Can I bring in Brinda next to sort of share her opening remarks on this?
Yeah, hi, my name is Brinda Bhandari and I'm a lawyer and I practice in Delhi. So for me, so I agree with what Amol said in terms of, I think it's very important that we have a data protection law. Whatever form, whatever, however it is, it's important that we need a law. I think there are some very problematic provisions in the law that are potentially also unconstitutional. But, that can always be challenged and will be challenged. But I think the fact that we have a law is really important. One of the things in terms of user rights that to me is a very positive consequence of this law is actually the data retention obligations. So if you see section 8(7), which says that any, I'll just read it out, a data fiduciary shall, unless retention is necessary with any law for the time being enforced, erase personal data upon the data principal withdrawing consent or as soon as reasonable to assume that the specified purpose is no longer served. So generally, if you see any privacy policy today, it always says, you can process the data for as long as the purpose is there, which is a very vaguely worded kind of obligation and effectively means that companies are allowed to keep your data for however long, they believe that purpose is served. But what is interesting in this law is actually section 8(8). So the next clause, which says that how you interpret this as soon as shall be, deemed to have no longer be served, is if I approach the data, if you have not taken any decision based on that data with me within a certain period of X months, or if I have not sort of benefited in any way in a certain period of X months, and the government will notify that X months, then that purpose is deemed to be served. So this actually is bringing in a very hard retention obligation. If the government actually introduces these timelines and says that this timeline is 5 months, 6 months, 1 year, 2 years, 5 years, and that effectively means that if I have not approached the data fiduciary within, say, 5 years or 4 years or 3 years for this, any performance of this function, then that data is deemed to have served its purpose and has to be deleted. I think the fact that this data retention obligation is going to be there will mean, it will be work for companies because they will have to update and review their records regularly, but it's also in line with other Indian laws. So in the Aadhaar judgment, one of the things that the court struck down was actually some of those provisions for under the Aadhaar authentication regulations, which said that you can store your data for 5 years, these authentication transaction data. And they said, oh, you don't need it for that long. So I think it's very interesting that what we were seeing in the jurisprudence is also now being reflected in the law. So for me, that's a very big positive. In terms of how will we operationalize this and what are some of the challenges, I think you can't just look at the rights of users just in terms of the section which says, let's deal with this chapter of rights of users. How the users' rights will get interpreted in practice will depend a lot on the Data Protection Board, the constitution of the Data Protection Board, which, as I've spoken before, and many people have pointed out, is going to determine everything. If the Data Protection Board today is going to be decided completely by the central government and it is weighted in a certain favor, if the people who are there are very sort of not necessarily, if they have certain bents of, thinking, then that will mean that your entire obligations or your entire rights vis-a-vis the state will effectively become nullified. How your data rights will work as a user will also depend on how the exemptions are notified, not just the exemption in terms of whether state is allowed to exempt any, state instrumentality, where the central government can exempt any state instrumentality from the application of the entire law, which I think is very, very problematic, but also that the government can notify any class of fiduciaries and exempt them. And we don't have any basis that is currently provided in the law to give you a real understanding. Like when you say, nature and volume, do you mean it should be a very big volume, it's very small? So we don't really have that thinking. And that's something I'd like to discuss further. So just in terms of, and these are, I think, the big problems with the law, which is that the operationalization will depend so much on what is not there in the law or how the law will be implemented, which is specifically the powers in terms of the exemptions, the constitution of the Data Protection Board, these provisions in terms of, blocking, etc., which have been introduced, which according to me don't need to be introduced, and also the application of the law itself. So the fact that any data that is publicly available, if that gets exempt from the data protection law itself, how will that work? And that's also something that I'd like to discuss.
Sorry. So thanks, Vrinda. I think especially for highlighting how sort of looking at the rights of users is not just about Chapter 3 in the Data Protection Bill, because there are certain rights that are stemming from data fiduciary obligations and general rights that have been flowing from, say, the Puttaswamy judgment as well. So I think we'll have a lot more to discuss, especially in that interplay with other sort of existing legislations. But Swati, what's your take on how this framework exists as of now?
So I quite agree with what Vrinda and Amol and you yourself, sort of, Gangesh, were speaking about, the overall feeling that we have, that we finally have a law in place. We've been in this space for a while now and, been a part of the conversation going on around data protection, privacy, and finally having something concrete helps us, I think, move the needle forward. Of course, there are a lot of issues, buts and ifs around it, but until you have something going on and, peg to, okay, fine, this is what we're doing and this is where we're finally looking towards, then you keep beating around the bush, I think. So we know that what are the problems, what are the challenges, and we know what's unclear and what's specifically and categorically clear and might be a problem. And I think there is scope in terms of codes of practice coming in and those kind of delegated legislation still coming in, that there is a lot of room for us to still maneuver and sort of make things correct. So I'm very hopeful about the current state of play, how it's sort of panning out. In terms of, I think, rights, yes, there are some very interesting rights that, you have and you've borrowed from GDPR. You've also borrowed some facets from other laws. I see some clauses verbatim from Singapore and, there are some clauses which have an inclination towards Indonesian, data protection laws. So we've been studying at CCG. So CCG, I work at CCG, and that's an academic research center housed within National Law University. And we've been looking at data protection, data governance, platform governance, and all this panoply of rights and internet governance space for more than a decade now. And one of our understanding of the data protection, data governance space is to keep looking at other jurisdictions, not within the global south, in the developing belt, but also Australia and GDPR, to sort of understand, okay, we need to understand where we align with in terms of our contextual realities, and then what is the gold standard, so to speak, like GDPR, that we should be looking at in terms of principles and stuff like that. So we might not have specific principles outlined in this law that we all know, but I think they're implicit in many ways, like how Vrinda pointed out about the data retention thing. We do have some very strong principles showcasing through certain clauses, and then we have some interesting rights like right to nominate, which I think, and I'll speak later more about, is it's not to be very excited about. At least I'm a little cautious about how that right to nominate will looks like at this point. And then we have duties for data principals. Again, I would not be worried about a right like a duty like that, because it's a duty for a data principal, because I think in life you have rights and duties often complementing each other. The issue over there, and what Vrinda was sort of speaking about this earlier, is that how do you intend to implement that? For example, you have a lot of duties for data fiduciaries as well, but how do you intend to check on that? You don't have data protection impact assessments for the data fiduciaries, mandated for anybody and everybody. You have in other laws, even in the Singapore and the Indonesian laws, you have for deemed consent, you have for ADMS, which is automated decision-making systems. You have the processing, which sort of entails some potential risk. You have for things like that, impact assessment as part of it, but you don't have it in India unless you're a significant data fiduciary. So if I decide not to do something, being a data fiduciary, if I decide not to do something, whether intentionally or not intentionally, who's it going to check on me? Because I do have a voluntary undertaking, but until the rules sort of come out and they clarify, okay, you really can't do this beyond 2 times, 3 times, and there is some sort of like naming and shaming, which pushes a person to not do that act again. How are we trying to curb or curtail or enforce that voluntary regulation that you have? I mean, voluntary undertaking is one part of it, but how do you have that self-regulation coming in, because there's no data protection impact assessment?
Okay. Thank you, Swati. I think couple of things that have come out from a lot of these opening remarks. One is this set of variations from either global practice or from the previous versions of the bill, and what might be the impact of that. And the other is trying to look at whether these variations are, a positive spin. And the challenge that comes with a varied practice or a new introduction, this thing is we don't have a blueprint to really look at. And that's what I think makes me excited about the right to nominate, because that I feel is going to interplay with a lot of other existing sort of laws, and also be a challenge for implementation because there is a lack of familiarity. And that brings me to the other aspect that I think Swati also discussed, in the fact that there are elements in the practice of data protection, governance and regime, that are not exactly hard-coded into this law right now. And they rely on sort of the voluntary behavior that will come in. So one of the aspects that came in yesterday's discussion was also, the right to access information about personal data is restricted to data that's being processed based on consent or on the voluntary sharing under certain legitimate uses. It doesn't really extend to the other certain legitimate uses that are there. Now, I was thinking, would it be possible that companies will take that as a good practice or a behavior to share that data, even though, share that information about processing under other legitimate uses, even though they're not obligated to do so per se? Would it build towards better transparency and fairness? Or are we looking at burdening a data principal who's already overwhelmed with the amount of information and awareness that we're looking at? So I want to sort of bring Amol back into this discussion, and if you could share some insight on how consumers have been dealing with enforcing their rights in other sort of sectors, and what might be a particular challenge coming in from the data protection perspective. Amol?
Sure, thank you, Venkatesh. And I agree and appreciate a lot of things which both Vrinda and Swati talked about. And particularly with respect to your question, I think there are some examples in other sectors wherein we can learn from, particularly on rights which are specifically provided in the Data Protection Act. For instance, there is a right to edit and correct our information. Right. And recently, actually yesterday, RBI released a circular that all financial consumers have the right to get their information corrected with the credit information companies and credit institutions. And if that information is not corrected within the specified period of 30 days or so, they are they have the right to claim compensation for delay for 100 rupees per day of delay. So that is something which is there. Similarly, I think there was some discussion on right to erasure and retention of information. Another RBI guideline says that, for instance, there is a property document which is taken by a digital lender or a lender to provide you a loan, and once the loan terms ends, then the lender is obligated to return the original property document after the purpose is served. So basically, once the purpose is served, you need to stop processing that information and stop using that data. Something on similar lines. And in case you do not return that property document within the timeline prescribed, then the consumer has the right to claim compensation to the extent of rupees 5,000 per day of delay. The Consumer Protection Act also talks about product liability and compensation for service compensation to consumers in case service providers do not adequately disclose the harms which the product or service may result into. So we have that whole consent provision, and it provides for different things notice needs to talk about. And in case the notice does not adequately discloses what could be the potential harms, or if the data fiduciary is unable to explain who other data fiduciaries are processing and how the data is processed and what are the potential risks, then under the Consumer Protection Act, there is a similar provision which talks about inability to disclose could lead to compensation and product liability violation. So I think it's our failure to perhaps see that there are inspirations across sectors in different laws in India, and we have had experience of, unfortunately, not effectively using these provisions to consumers' benefit because of lack of awareness, lack of options. Because if we file complaints against particular service provider, there is no competition in the market and there is no alternate service provider. So that is also a problem, and lack of intermediaries who can help consumers navigate the whole ecosystem. So there are these challenges, and also I think while there is a right to grievance redress under the law, however, it says that the data principal shall have the right to have readily available means of grievance redress. Now, what does it mean by readily available means of grievance redress? I'm not very sure, because it's the term which is not being utilized anywhere else. There is no clear clarity on what is the role of the data protection board in enforcement of some of these rights, including grievance redress. Neither there is any discussion around enforcement of rights at state and at district level, because we have a three-tiered consumer grievance redress mechanism. So how does that interact? And last but not the least, while there have been a lot of stringent penalty provisions under the law, but how is consumer or how is data principal benefiting from such stringent penalty provisions? Is data principal getting some compensation of the penalties which the board will collect, or would the amount go into a data protection fund which can be utilized for awareness generation, capacity building, and supporting consumers and data principals to enforce their right? I think some of these were there in some of the previous versions of the bill, and we have been highlighting the need for some of such provisions across the comments we have made in different versions. However, we don't see that effectively being included under the law, and therefore the whole enforcement bit is dicey and ambiguous, and there is a lot of work to be done on some of those issues.
Right.
Can I just
Thank you.
jump in? Sorry on that.
Linda, please.
In terms of this, picking up from what Amol has said about grievance redress. So currently, if you see the level 1, it's that you have to go to the data principal. And my hope is that when they say the right, that it should be readily available, it could be something, hopefully it would be interpreted as something that, it's very obviously given on the website that this is what the grievance redressal officer is. These are the email, these are the contact details, and this is how you will give a complaint. And I would hope that they would interpret it this way, because it's also clear from the Act where they say that the data principal shall exhaust every opportunity. Before going to the board, you have to file a complaint with the data fiduciary. So this is how I would hope that the government would interpret it. I think what is interesting is what happens in an offline setting. So if you're going to a hospital where your records are digitized, right, you're then covered under the law. So I think in an online setting, we're all sort of used to, you go to the contact us, it'll say for any grievances, or in the privacy policy, it'll say contact the grievance redressal officer. I think it'll be interesting to see how that will happen in the offline setting where the data is digitized. Is it that they are, if you go to a hospital, does it have to say that for any grievances or for any details, contact so-and-so? So for instance, you see all these notices under the Prenatal Diagnostics Act, where you go to any ultrasonologist and they say, they have all these big posters that are put, which is that for any violation, this is what happens. They have a copy of the law, etc. given. So to me, that's actually very interesting, because intuitively, people understand when you're giving data online that there is some collection online. But if I'm giving my data, sort of I'm going to a hospital, I'm not sure how many people will realize that that data is being digitized. Yeah.
So this reminded Vrinda of something that happened to me. I'd gone to DLF in Cyber City, and they wanted to scan my ID to allow me entry into the building. Cyber Hub is different. Cyber City, where offices are, they want to scan. So I asked them for their privacy policy, and the guard at the gate was like, "What?" And then I asked, "Okay, what kind of security standards do you have? How long do you retain the data?" He's like, "मैं आपको basement में ले जाता हूँ." So he took me to a basement office where there was a head of security sitting there, and he had no clue about whatever I was asking for. The point is, the number of instances across this country where not just ID scans, but also facial scans.
Entry of malls.
I mean, they put up those cameras and screens for temperature checking. Now it's just, they still have those. Right. So is it realistic for us to expect that this will be like notice and consent will be implemented in an offline setting where digital data is collected? Do we even see anyone going to court or challenging the fact that this has not been implemented?
So actually, to me, that is like I was saying, that to me is the more interesting question, because everybody speaks about the online, like the fintech, and
the biggest and the thing that nobody talks about and everybody talks about privately is MyGate.
Yeah, that would be my next.
So what happens in those settings?
So I actually think the success of the law in some senses will depend on the everyday consumer taking up these issues, because in some ways, we all have the opportunity to shape the law, right? The next 2-3 years is when the jurisprudence of the Data Protection Board will be built. And that means, you file complaints, like in your case, you go to them and you say, you've not provided me this information. So here is my complaint to, Cyber City, and say, what is your data privacy policy? Where is it mentioned? Why is it not, publicly available? Why can't I see it? Why does everybody not know about it? When they respond, or if you're unsatisfied with that response, then we go to the board. And I think in some senses, and that's why the board is so important to me. The board is central to the success of the law. How easy it is to approach the board. Do you always need lawyers? Because at the end of the day, fortunately or unfortunately, you'll see this in the consumer context as well. It was built with the idea that consumers can come on their own.
I have a tricky add-on question.
Yeah.
Sorry for jumping in the gates, but these are like, so since you've taken this offline, does a requirement for verifiable consent also exist offline where there's digital data collected, so that they're not collecting data of children?
I mean, I think, well, in an offline setting, it's kind of easier to see if like you're a child and if the parent is with you. So, but yes, I mean, the law does not distinguish between what happens, right? In it completely, like, because the law applies in the same way. It doesn't say this is how it's going to apply separately. So to me, it would apply in the same way. It would mean in practice that if you're taking your child to the pediatrician's office and all that record is being digitized.
One more tricky question. Yeah. What happens in case of, we're exploring here.
I know.
What happens in case of ambient data collection then?
Ambient data collection in
CCTV cameras collecting data of children.
So, I mean, all of that is covered under the law. To me, that's very clear, because the data is being digitized. If the data is being digitized, it is collected. That means you have to, in some senses, well, how it would work. And that's why, to me, how children's data is going to work is going to be extremely contentious. I don't think they've necessarily thought through. I think it's easy when you think through like, okay, EdTech, right? That's how it's going to work. And that's one use case. But when you think about how the law is going to apply across, I don't think the law has prepared for these kinds of situations wherein, like, I mean, in terms of what is the level of consent required. Now, if you're going into a mall with your parent, is the consent going to be that I'm entering into the mall, that they will say that here's the CCTV, this is the entry. And if you have gone with your parent, then that's consent. And that's
Okay. I want to sort of,
one last thing.
Nikhil, I'm going to bring this one particular aspect in here.
Does the exemption for publicly available personal data apply to children?
So, Swati, you wanted to come in on the nomination part. Okay, but let's just wrap this sort of
Gangesh is like, give me my panel back.
No.
go ahead, man.
No. But this is an interesting.
I don't think so, because to your answer, because the photographs of children are not publicly available data necessarily. So, for instance, in my case, my children's photos are not online anywhere.
Yes, but if you've taken them to a mall and there's a CCTV camera there, that's publicly available facial information of a child.
So this is what I want to sort of come back to, is that there is a scope of the applicability of the law that completely excludes a lot of instances where your privacy might be a threat. Now, what rights do you have where your privacy is a threat, but it's not essentially protected under this law, right? The scope of this law is going to exclude publicly available data. It's going to exclude non-digital forms of data. But there are privacy threats to it. And I think, some of the panelists also spoke to elements in the ecosystem that play to build this role and building a culture of privacy. That's not just about complying with this law or adhering to the legal aspects of this law, but also building a culture of privacy. So is there any suggestions that you can bring on board to see how data fiduciaries or principals or even, the government can improve in terms of awareness or passing guidelines? And the second aspect is, you talked about how important the data protection board is, but the fact that it's been drastically disempowered from the previous versions of it. And by disempowered, I don't mean, just holding data fiduciaries accountable or suo motu powers, but also simply in terms of building awareness and, engaging with the community on understanding and, providing privacy education. So your views on that, Swati, you can go first?
Yeah, so I think, even in the GDPR's digital vision, they talk about moving from digital skills to a digital culture, right? We are not even at the point of digital skills. We're right now talking about infrastructure services.
We wait for one to happen. We can't really wait for one to happen for the other, right?
Yeah, and that's why I think one of our pillars is digital literacy right now. We don't speak of skills in our vision document. We say there's infrastructure, there's services, and then there's literacy. But the point is, what are we really doing about that? We don't really know even the markers of what digital literacy should look like. For example, I was speaking to Nikhil before this panel, the fact that I might be a literate person, but I'm not financially literate. I don't consider myself a very highly rated person on financial literacy. And I think that's a whole lot of population. Even in UK, you have around 60% of financial literacy, where the general rate of literacy is very high. So I don't know what the number stats for India in general. So in terms of digital literacy, I think we've not even started that, okay, this is how we're going to assess digital literacy. Because there can be a person who's financially literate, but is not literate. We have those sort of people and situations in India. So I'm sure there are people who are on the digital medium who are not literate, and they might have digital literacy. So how are we going to gauge that? I think that's the starting point for that, to then start working on what kind of skill developments or programs and policies we need to build in that sort of space. Another thing, coming back to the notice consent thing, you need awareness and you need that understanding for people to take conscience of, okay, this is what they're saying. But in the current scheme of things, you really don't have anything talking about third-party sharing information. You don't have how long the data is going to be retained, like how in GDPR, they have to give something that it's, if not something specific, then a roundabout approximate figure, you need to give that. Or you need to give contact details of data fiduciary, like a data protection officer, which we do not have at this point. So you kind of, leave.
Why would you say we don't have that?
We don't have this mandatory thing in the notice
You're
consent
supposed to
format.
provide details of how to have exercise your rights or your grievance redress.
So you have that you need to tell the person these are the rights and everything that you have, but
how
there is
you
no
exercise
contact.
those is also
You can reach to them to sort of, it's not given in the notice, not a mandatory thing, but you can reach out to them to then sort of they sharing details about that. But it's not like a mandatory part of the consent notice, what I understand. I could be wrong, but that's what my limited understanding is. They will sort of talk about giving past data collected and how you have the right to withdraw consent, which is akin to GDPR in some way, right? And of course, mentioning all other rights that you have. What other than this, that you have something unique is the linguistic choice, which is unique to India. But I think that could turn out very problematic is because it's not easy to translate language, and who's going to be responsible for going wrong in that sense. So when you translate something from English to Hindi to French to some other regional language, the bhav is usually not the same. Who's going to be responsible for that? And how are you going to ensure that the other person is, able to understand the same thing in the same way? That's, I think, going to be extremely tricky. Another part of, I think, rights as a bouquet of things, I'll just quickly talk about the right to nominate, because I feel it looks like it's a unique right, but I feel generally you do have right of legal representation as in GDPR and general laws, you do have that. This right to nominate, how I understand, sort of kicks in when you, in case of death or incapacity, and which incapacity further leads to either it's unsoundness of mind or physical disability or something of that kind. But it doesn't really factor in the concept of incapability of skills and knowledge and understanding of the digital space, which is going to be the large section of this country, right? And then at the same time, in case of the incapacity, how the law reads it right now, you are assigned a guardian. And that guardian is the one who will now exercise the right to nominate, or is the one who is the nominee by default. There's no clarity over there. And another point for right to nominate is that in one sense, we are acknowledging that you need consent managers and that whole ecosystem to practice your, the digital consent management and all of that. But then you are assuming that people would know how to exercise their rights. So I think that linkage needs to come across through codes. And I think the most important thing is the codes of practice or the general technical codes, how we push the companies to build into building a responsible technology and the kind of ethical system we build through these codes of practice. I think that's the most important part.
Right. So that again is going to rely beyond the rules that the government is going to put forward. Nikhil.
Move to questions.
Yeah. So Vrinda, you want to respond before we go to questions, or Amol, checking in on you? Anything you want to add right now?
So just for two small things, if possible. Sorry.
Please go ahead, Amol.
Okay, so there's just a couple of things. So on grievance redress, I note what Vilda say, but we have this specific mechanism of going to the service provider, exhausting all the sort of that forum, and then going to the regulator across sectors, particularly in financial sector, and that has failed miserably because you write a complaint to a financial service provider and you will not get a response, and you don't know if that is the correct financial service provider, because there is a chain of financial service providers, including intermediaries in between, and that service provider will automatically direct your complaint to somebody else and will mark the complaint as resolved. And the next time you will file a complaint, it will be marked as frivolous complaint. So that is the risk which we are dealing with, having seen how grievance redress operates in the real world in other sectors, and now there is an obligation of not filing previous complaints. So how does that brings consumer interest down? The second point on right to nominate, I think right to nominate also, there is a whole obligation of naming nominees in other sectors, including the financial sector, and there are unclaimed deposits to the tune of 1 lakh crore in our banks. And one of the major reasons is that people have not nominated somebody, and because of death or incapability or moving on, there is no clarity on who are the legal heirs or nominees. And given that there is such huge distress in the financial sector, and there is quite a high recognition that this right of nomination in real money sense is not being enforced and implemented effectively. So how do we think that this will be implemented in a digital data protection scenario? Thank you.
Thanks, Amol. I think excellent considerations. Vrinda?
Yeah, just actually, so Amol, I agree with you in that I don't think necessarily the first level of data protection, like the data fiduciary responding, will necessarily be effective. In fact, the point I was sort of also wanting to make originally is that you see, so there's two examples that I think are interesting. In the media broadcasting space, the NBDSA, the National Broadcasting Body, the kind of code there is you have 15 days to respond. If you're unsatisfied by the response within 15 days, then you have the ability to file a complaint with the board. So the level 1 is with the broadcaster and the level 2 is with the board. And so there's a specific timeline. And that's worked well in the extent of at least people are then sort of very fast moving to the board level. And then you wait for the board to have a hearing and give a decision, which is where sort of the time lag happens. And then at the same time, you see on the intermediary rules, you have the ability to file a complaint or a request with the intermediary. And I've done this for a bunch of clients, and actually the response you get is that automated service response. Like you get an acknowledgement of the complaint, but you don't really get anything substantive. So I think in the intermediary space, for instance, it hasn't worked that well at all. And that's why, again, to me, everything sort of lies with, if everybody is going to the board, does the board have the capacity to handle these kinds of complaints? How, just in terms of the volume, right? How is it going to work? How is it going to work in terms of, is it going to be an office located in Delhi with branches in, like physical branches in other parts? Is it only, I mean, it's digital by design. So does it mean that they're encouraging only digital complaints? Because as we know, the number of people who are digitally literate is sort of very low. So I think a lot will depend on also, how are we going to staff this board? How is it going to work? And so like if it's based in Delhi, our complaints, in some rural sector, forget even rural, semi-urban, etc., in southern parts of India may have that distance, and that makes a difference because you don't know a lawyer there, you don't know how to approach them. So that to me is also going to be an interesting practical implementation problem.
Okay, questions and comments.
So two things. One on the nomination part. I think when it comes
Dr.
to finance,
Maheshwari, do you want to
Yeah.
introduce yourself for the
okay,
online
I'm
audience?
Deepak Maheshwari. I'm a senior visiting fellow with the career. So one point on nomination is this: when you look at tangible assets, so whether it's a, let's say, immovable property or financial deposits, as Amol just referred to. Now, for those type of things, yes, there's a process. So you get the legal certificate, and then there's a certain process already there. And there you do have divisibility of that particular asset. So suppose there's a property, and if there are 4 heirs, and assuming that, okay, all of them have equal share, it can be divided like that. When it comes to digital domain, it's going to be another challenge. Suppose there are 2 nominees. That's point 2. Even if there are just 2 nominees, and both of them are equal, let's say equality in terms of as a legal heirs. Now, who gets what of that digital space and what rights do they exercise? I think that's something which people have not really thought about. While they've given this right to nominate, that's fine, but not really gone to that extent. And the other thing I just want to mention quickly is definition of data subject from another law, not from India. Data subject means an identified or identifiable natural person, alive or deceased, to whom the personal data relates. And this, by the way, is from a neighboring country that got the Data Protection Act in March 2022, Sri Lanka. Okay. So this type of rights do exist, let's say, even for a dead person. So it could be thought in terms of a dignity of a person, for example. I mean, what happens to a person after the death. So that's another aspect to look at. The third thing is, while we are talking about data protection board, I think we should also look at what's going to be at the appellate level beyond that. And that's going to be extremely problematic from a totally different angle. If you see TDSAT was established in 2000. So they started doing with telecom. From 9 January 2004, they also got broadcasting. From 2017, they got the CYAT, Cyber Appellate. But also one more thing, Airport Economic Regulatory Authority appeals also lie at TDSAT. And with this law now, you're going to have the appeals on data protection. The interesting thing about that is the composition of TDSAT remains same static from 2000 till now, which is chairperson plus 2 members.
Just to, can I respond?
I think we have a separate discussion.
Yeah, I think
on the
let's focus
TDSAT.
on user rights. I just wanted to know about whether I have the right to object to, or do I have any rights against the idea of verifiable consent? Because that actually might lend itself to collecting more and more data about me. So is this something that we see going to court? Because verifiable consent probably will end up becoming biometric collection of data. Anyone?
We don't have right to object per se in this law.
Okay.
Like, you have.
But
in
do I have the
GDPR
right? Do you see litigation happening there? Because effectively it's more data collection rather than less.
But it's a legal requirement under the Act.
Yeah, so
Yeah.
in GDPR, you have right to object against profiling, marketing, analysis, and all of that, unless it's required in the public interest, And in I think Indonesia as well, you have this ADMS protections and all of that. But in India, we don't have that. Now, what I feel is that in a lot many sense, this law, how it sort of interacts with new age and big tech and all that, I don't know what rights and how this sort of pans out over there, because in some sense, our phone numbers and that same combination of email ID, we all have email IDs by our names. That's how smart we are in privacy protection, I feel. And that same combination of our email address and phone numbers are put on again and again in the same combination complementarities everywhere. It's already public information. And then in tandem with that, if you add one or more personal information that you put out, there's a lot that can be traced about you. So there's a lot anywhere out there in the public sort of domain. And though in the notice consent, they're required to tell you about the data that has been collected about you, but that is not in the public domain. So, you have nothing against that.
So two responses, one to what Swati is saying and one to maybe Nikhil, your question on the point of, what is in the public domain. It's very interesting. So during the Aadhaar hearings, I was part of the hearings, and, we were trying to make this argument that demographic and biometric information, we should sort of require sort of a higher level of protection, and the Aadhaar Act doesn't fulfill that. And the government council basically gave the example that for all lawyers, we have these bar council directories. So for instance, I'm an advocate on record. I can file in the Supreme Court. If you go to the Supreme Court website with the names of AOR, like these advocates on record, my name, my phone number, my office address comes, right? The idea is to ease other lawyers, etc., if you want to serve something or get in touch. Does this mean the fact that my name, etc., is on this website? So the government is like, how is this protected information? You are giving your name and information everywhere. So you can't seek any level of, you have no reasonable expectation of privacy with respect to that, which is like, to me, what is publicly available data? So the fact that my name, my address, like my office address and my phone number and email are all on the Supreme Court website. If you look for like an advocate on record, does that mean that I have no protection against this? Like, to me, that actually is a big problem. And then in terms of, will there be litigation? I think the litigation at all will be at the stage of challenging constitutionality, where the argument would be you are actually encouraging data collection rather than reducing it. But if the government, A, if it's challenged, and B, if the government sort of if the court sort of upholds that challenge, then beyond a point, unless, depending on what the rules say, companies sort of are obligated to collect more and more data, because how else will you verify consent? So I think the level of challenge is sort of at the introduction stage, where you will have to make these arguments that you're actually encouraging more data collection, because how am I going to know if somebody's a child or not? Like, that means I have to collect the data of everybody in the room to know, like, is there a child in the room? So I think that challenge has to be at the sort of initial stage.
So one other practical question. We had the discussion in the data protection officers session yesterday about if, let's say, they were to become the DPO of company that spams the dot, let's call them B Finance, what are the changes they would do within the organization to ensure compliance with the data protection law? Flip-sided question here. And on the flip side, what are the rights today that I have against, let's say, companies that are spamming me from a data protection law perspective? Can I ask them for sources of information? Can I file a grievance with them? Like, what are the rights that I have against all the spam that I'm getting?
So, yeah, I think one of the things that we can look at is, once you write you first understand what is the source of information that they have about you. And then you can ask them to withdraw consent for that particular purpose or sharing of data with that particular source. But I'd like to hear what.
Yeah, so all of those things. So first, you obviously have to have the ability to unsubscribe, and it should be an easy ability to unsubscribe. Not that, what you see in current places, which is that sometimes you go to another website and you have to again enter your email ID. You can't have a two-step unsubscription. I think it would have to be easy way to withdraw consent. But also because you clearly have my data, because you're sending me a spam email, I have the right to
required
access.
for this, or is it already in operation?
Is it already in operation? I mean, it's not currently in operation in terms of unsubscription. I mean, it's good practice. So most companies.
No, I'm saying that right now with the law having been passed, can I now go and ask them?
And the law is not enforced right now.
Not enforced.
That's very clear. So if you see section 1 of the law, it says the law will be notified. So the law has been passed. There has been no notification of the law. So currently the law is not enforced. Like they will have to notify the law for it to be enforced. Like they did it with the IBC, with the Companies Act when it came into being. Different sections can be notified at different times. Different rules can be notified at different times. So, I mean, which is also going to be interesting to see. I mean, obviously, the first rule that would have to come out would have to be the Data Protection Board. You can't have anything without the board being there. But for instance, if you don't notify one of the rules and sort of notify other parts, like I think it's going to be interesting to see how they notify the rules as well.
And the right to withdraw is, in fact, nestled under the obligations of a data fiduciary and not under the rights framework. So it's, I don't think there's an additional rule, but it's a basic requirement that the ease of withdrawal should be the same as the ease of giving consent. So ideally under the law, once it's enforced on the board, it should be easy to work out. Questions?
Just to add to this.
Yeah.
So
Amol?
Need to see.
Amol, would you like to add something? And if you please raise your hand so that we don't forget that we are including you in this conversation.
No, I was listening attentively and I agree with most things which have been said. But I think you said what I was about to say was that when the law says that the right to withdraw should be as seamless as right to provide consent, but the obligations of withdrawal are on the data principals, and also would the scope of obligations mean cost and other things which might actually make withdrawal difficult process is something that we'll have to see. And at the end of the day, it boils down to, are people aware that they have the ability to withdraw consent, and is the process as clear as providing consent?
Thanks, Amol. There are a bunch of questions in the room. Start with 1, 2, 3, 4, and then we'll come back to the next round.
Hi, my name is Aman. I'm from KNS DG Protect. I have two questions. One is that when we are talking about CCTV feeds being taken at public premises, hotels, etc., in the Section 7 legitimate purposes, there is one instance wherein if there is an obligation under law, then consent is not required. That can be bypassed. So if suppose there are, let's say, police guidelines or some local authority guidelines saying you have to collect CCTV feeds, then will it be exempt from taking consent? This is first question. Second question is that in Section 7 and 17, there are instances of this word state instrumentality, and they have a lot of exemptions. Like they have exemption from taking consent for a lot of things, and they also have exemption from complete exemption from right to erasure. So if you're instrumentality, you don't need to have them. You can't enforce this right against them. So my question is that who are state instrumentalities, and where will it be? So obviously, if I am going against somebody saying that this right of erasure is not being fulfilled by that entity, suppose if it has some control of government, they'll take this defense, I am a state instrumentality. But who will answer this, whether or not they are? Will it be answered by Data Protection Board, or will it be answered by the High Courts or Supreme Court? So these two questions.
Okay, can we take one more question and then, yes, the gentleman here.
So I have a question in respect to the hello.
Yeah.
So I have a question in respect to the rights of the user, in respect to, can we dichotomize rights of paid user or free user in these models like Spotify or YouTube, where they have a different models? So I'm going through all of their privacy policies, and I found one thing: there is no restriction in respect to the collection of data anywhere. Of course, the most extensive privacy policy I found is Spotify. They have categorized the different kind of data, but at the same time, suppose on Google, so I can't restrict the collection of data. What I can do is I can categorize it. This type of data should be used to show me the tailored advertisement, but there is no way I can restrict the collection on any of the website. Even if I can stop the tailored ads on Spotify, but nowhere there is restrict them to collection of data. So under the new law, can we categorize these two kind of rights for the paid user or unpaid user? Because as far as the what understanding I have of the technology, that I'm a lawyer. So is that the different set of data required to show me the tailored advertisement, and there are different set of data will be used to customize services for me, like the on Spotify to give me better music or to match my music. So if I'm paying to Spotify, they are not showing me ad, but there is no way, and there is nowhere written in their policy or for any platform policy that they'll restrict the collection of data for me. So can we do that under the new law? Because as far as my understanding about the new law is like the tele medicine example, that we have a utility based consent. So can we do that?
It's a purpose limitation.
Yeah,
that
purpose
works in,
limiting. Yeah,
right?
yeah.
Okay. So Brinda, you want to start, and
Yeah.
Amol and Swati, please come in.
Yeah. Sorry, you had two questions. The first question was if the law requires you to collect data. I mean, if the law requires you to collect data, you have to collect data. I mean, then you will have that exemption. The point then is then you challenge it saying that how can a police, so I did this project, interestingly, on the use of 144, section 144 powers, which allow sort of restriction in public gatherings, more simplistically as it's understood. So we had done an empirical study where we had filed RTIs with every single police district to understand the sort of number and use of 144 across the entire city over 2 years. And some of our results were shocking, right? So it is these police guidelines in certain parts of Delhi, and you can imagine sort of which parts, etc., which will say that, oh, if there's anybody who's coming to buy whitener fluid, etc., you have to note their names, like names of girls, people in girl hostels. You have to, under the 144 order, it is the requirement of the hostel owner to give them information on like who's staying where. There's requirement for a CCTV footage as well at all ATMs, right? So actually a lot of this is coming under 144. Which is to me very interesting. And you can actually see we put up some of those sample RTIs, etc., as well online in our report. So you'll actually see these guidelines which say you have to do it. If you have to do it, it's a police order. I have to comply with law, because if I don't comply with the police order, then I'm prosecuted under the IPC under section 188. So then you would be exempt. What was your second question? I mean, state instrumentality is going to be understood very broadly, because instrumentality is separate from department. So there is, like in law, you see state agencies, which would be your CBI, ED, those sorts of things. State like departments, which would be like government departments, ministry departments. My sense is instrumentality is going to be defined in the most broadest manner, which would be like your Article 12 definition of state. So if it's a sort of any part that has things to do with the state is how the government would likely want to define that. And I think if you want to challenge it, you try basically everywhere. You probably first file a challenge with the board saying this exemption is being like wrongfully or illegally being invoked. So that's the way you would frame the challenge. Then you'd have to go up in appeal. And then you'd have to, or you could try a writ move. I mean, that would be a litigation strategy issue.
Can we take that a little later? Amol, do you want to jump in on any of this? Or you
Yeah,
want to
just I think on the state instrumentality bit, I think there's just one perhaps fine difference on exemption from consent versus exemption from act. I think from consent, the scope is broader, and any and every state instrumentality has that right to use the data which is collected for providing any other service within the database which is notified or which is used. But I think from exemption of act, the act says that state instrumentalities as may be notified. So I think those instrumentalities which are exempted from obligations will be notified, and then those will be exempted from obligations which are provided for data fiduciary. So that is there. I think there was another question on purpose limitation and collection of additional data. I think there is an example which is provided under the act that in case you provide consent, even if you provide consent to data which is more than what is required to provide a service, the data fiduciary is under an obligation to not use that data. But how would that effectively and practically enforce? That is a separate question.
Right. So unless it's
Yeah.
necessary, you can't. Swati, please
Yeah,
go ahead.
because that's the whole point. Like, how do you assess whether somebody is, adhering to what, they're saying they're doing or not doing? Because if you don't have for general data fiduciaries any sort of impact assessment or any sort of check and balances, unless a person goes themselves and files a complaint against, a data fiduciary, how do you check they're doing what they're doing as they're saying, right? That's, I think, a big gap. And even if they sort of are caught in the wrong and they have a voluntary undertaking, what does that look like? How many times? I think so a lot of it will in a way be done in a way which should be market driven. Like, there's this concept of this whole voluntary undertaking seems to be taken from Singapore, but they also have very strict code of practice around that. So it's yet to be seen how we envisage this and what we're going to do about it, because they also follow what is called as a privacy seal, privacy trust mark, these kind of, which is something like energy rating. So you kind of create competition in the market saying, if you do more privacy enhancing, privacy respecting practices, you're a more respectable data fiduciary. And even in terms of the consent and notice format that you're talking about right now, I think that's bound to change with the new law. It has to be in a more intelligible, accessible format. So I don't think so we'll have the same kind of formats anymore.
Also, I don't think the law would make a distinction between free users and paid users. I don't think you can do that. I mean, not in terms of your privacy. I don't have lesser privacy because I'm a free user. I will have lesser access to your premium services, but that doesn't mean I have lesser privacy. So I don't think any distinction based on the paying ability, because that will be inherently discriminatory. I think
we'll take follow-ups in a bit, but there were some new questions.
Yeah.
So Resh and Nikhil. Yeah.
So hi, I'm Nikhil. I represent ID5. We're a tech company that does KYC and identity solutions. So this is a follow-up to what the previous question was about purpose limitation. My question is around the format of notice and how that may deal with the rights of the data principal. The Ministry of Consumer Affairs has recently published a note on dark patterns, and there are about 10 of them notified. How do you see that playing out in the notice structure? Because as a business, I might want to use a bait and switch technique or something like that. The legal counterpart who's going to help me with this notice will say, yes, this is okay because it has clear affirmative action, etc., etc. It's still part of, it's compliant with DPDPA. So who's the authority that finally says, yes, this is this notice is compliant and doesn't sort of impinge on the rights of the data principal?
Can we take the second question and then responses?
Oh yeah. So I wanted to know, like, how meaningful is the right to information right now? Because they're only required to give you a summary of the data. So if I ask Facebook might say, we have your contact details, your preference of apps that you use and websites, but I want something more granular. What contact details do they have? What's the preferences they have? So how does the GDPR deal with this? And is there scope in delegated legislation for prescribing more granularity?
Okay. Yeah, I'll leave the GDPR part to you. Sorry, what was your question? I'm sorry, I'm not writing it down. Dark pattern. Isn't that a draft guideline? I don't think it's been notified. So I mean, I think right now you're not really looking at the intersection. If it is notified, then of course you have to see how both of them will play. And basically the dark pattern guidelines are pretty prescriptive. So there will be a huge change that companies will have to make in their UI and UX. And effectively it will be lots of work for lawyers. But the way nobody's going to give you a certification saying you are okay. That certification will only come if somebody challenges your policy or your dark pattern and they, you take it up. And that's why the intersection will be important about where do you challenge it? Because currently, obviously, the law doesn't deal with dark patterns and it doesn't sort of reference that. So, you'd have to see which is your place to go. But I think you could definitely go to the Data Protection Board as well. So that will only come through a challenge. I don't think it's going to come through any certification that's going to say, this is fine, because nobody's going to give you that certificate. And the second question was on GDPR and
the right to information.
Right to, I mean, I think, I don't know if you can, so it says, and any other information relating to the personal data and its processing as may be prescribed. So yes, the rules can provide for much more that the access information should have. So there is definitely scope. Will it come or not? Obviously will depend. But I think like the fact that who your data is being shared with is actually going to be very revealing. It's not, because that will tell you if it's being shared with marketeers, if it's being shared with a data broker. I mean, so I think that's subclause B is actually where a lot more of your right would lie.
Yeah, so I think currently it's not mandatory in the notice consent format they've given in a limited way that you need to give third-party sharing information, not right now. That's what our understanding is. But again, in the delegated rules and, more codes of practice, if something changes, I think there is scope for that. In the GDPR, it's very granular. You have to give notice in the sense where you're receiving consent in a granular format. It has to be unambiguous. And it's also problematic because, if you're getting so many of these kind of notice consent formats where things are granular, are you that conscious and aware about, knowing exactly what leads to what, So I think every time you get a choice, it's also a burden in that sense. And hence, we all know about the consent fatigue, and that power asymmetry in terms of what you understand and what actually, translates into. But I think there's a lot of work also done around nutrition labels and different kinds of format for notice and consent for people who have different accessibility needs. So the word accessible, I think, needs to be understood in a broader sense and not just access to infrastructure and connectivity, what the focus is, but to generally meaning, okay, what different kinds of people understand content in, because not everybody has the same context and background. I think that kind of a market is, I think, going to develop since if you have these kind of requirements coming in. But if Amol, I think would have...
Amol, would you like to add something, or can we go to closing remarks because we'll be closing at 12?
Yes, so absolutely. I think just taking off from what Swati said, in addition to written notice and consent, there's a lot of innovation which is happening in terms of audio, video, use of images, use of local languages and cartoons and other such more informative mediums. And also, I think Swati talked about the star labeling and our experiences in other sectors, particularly in food and pharma and energy. And we have worked with the telecom regulator to develop something called as broadband labels to sort of highlight the different parameters of broadband usage. And there was a discussion paper, but that was shelved because of several reasons. But currently, I think there's a lot of debate and discussion happening around front of pack labeling under the food, because currently you have at the back of the pack and no consumer actually read it. So should it be on the front of the pack, and what should be the extent of disclosure and ratings? And there is a lot of to and fro going between industry and the consumer organizations. So this is a good idea, but I think the industry and the consumers or the data principle will need to sort of come together to recognize that this is for the benefit of the ecosystem, and sort of we'll have to give and take to come to a conclusion, because this will benefit both. This will provide more certainty to the data fiduciaries and more information to data principals rather than fighting around these issues. Thank you.
Thanks, Amol. Quick closing remarks from Swati and Vrinda. If you have a wish list, or if you want an amendment that can happen before, or anything that you want to really close with.
I think my only sense right now is that, in a lot of these digital laws, we're trying to bring in a lot of values like trust and like these big ticket names like heart, the user at the heart of, the piece and all of that. And it's nice to read all of that, whether it's here or anywhere in the world. But, how it all really translates to depends on like what kind of implementation tactics and the practices and processes you're putting in place. Because essentially what you're trying to gear and move towards is a digital culture, right? But the starting pedestal for that is practices and processes, which then sort of becomes absorbed by the people. And then that translates into culture. We all know, there is a right to property. And I use this simple example again, which is of course not a constitutional right or legal right, but, it's such an important right and such a momentous time when that happened. But we know the reality of that right in, different parts of the country and communities. It's still a taboo, to be talking about that. So until something gets really absorbed by the culture and starts getting practiced as, you really can't change things. So I think codes and that's why I feel, law is not really everything. And if a law is not in sync with the code, whether it's the technical code or the code of practices, then, you're really not going to make a dent into how you want to shift things. So I think we really should focus on not just the codes of practice and ethics, but also the codes in terms of technical standards and everything, how they're evolving, whether they're in harmony with the law, whether law is in harmony with that, because this is often like disjuncted and, not put together.
Yeah, I completely agree. I think I kind of said a lot already, but I just think in terms of final remarks, I think a lot of the law, like the heart of the law, is going to be shaped by its implementation. So really, I think the law will also be built through all of us. It's through people writing again and again to data fiduciaries, asking for information. It's, taking that complaint up to the data protection board. And I think really we, in some senses, have a really unique opportunity to be part of something bigger. And like, I think what is really helpful, one thing I would entreat everybody is actually exercise these rights. You've been given a lot of rights, and, you can criticize them a lot, but the point is you have a lot of rights. And so I think what's really important is to exercise those rights and to sort of seek information and, just be more proactive. And I think that will itself, because law will only do something, right? We also need a culture change. And I think that culture change comes through individuals believing that it's your right and exercising that right. So that's what I would add.
I'm not going to add anything after that pep talk, but thank you so much, Vrinda, Swati, and Amol, and thank you everyone for those questions and an interesting discussion. I think we are out of time and ready for the next panel. So thank you, and see you all around. If you have any questions, just reach us out offline.
Thank you so much for that and for opening up today's day 2, rather. Up next, we have our roundtable with data protection commissioners from around the world. They literally were from around the world, some from Iceland, from Japan, and then our moderator was in the UK. So this is a recorded session. But I think what it really highlights is not just the question of independence, which I know we're all concerned about in the Indian scenario, but just the question of surveillance and how do you actually identify issues that are worth a regulator's time and attention and worth protecting consumers from. So this is a conversation that was hosted by Malvika Raghavan, who is currently a doctoral student at the London School of Economics and is also a senior fellow at the Future Privacy Forum. And the people who are speaking included Junichi Ishii, who works at the Personal Information Protection Commission of Japan and heads their International Affairs Department, and Valborg Steingrimsdottir, who works at the Data Protection Authority of Iceland and essentially looks after their data security and auditing wing. So it's basically the team that identifies these issues that are worth talking about. So it's about an hour-long conversation, after which we'll break for lunch. And I hope it helps sort of give an insight into how data protection authorities across the world are really addressing hands-on this issue of privacy protection. So we will have it on the screen right about now, and I hope you enjoy.
Very excited to be having this conversation today. After several years of waiting for an act, we can now say we have one. As you all know, India passed its Data Protection Act in August 2023. The final text we're still getting to the grips of, but we know that just last month, the Minister of State for Electronics and IT said at a gathering that the rules and the guidelines will be notified in the next month, and also that preparations were underway for the formation of India's Data Protection Board. MediaNama has reported that there is an officer on special duty who's been appointed for this as well at the central government level. So it's really a very exciting and dynamic time to be having this conversation. The Act itself delegates a number of areas for rulemaking and insubordinate legislation. So a lot of the detail really will come out in these rules and regulations. And that's why we're so lucky and kind of honored to have two senior officials from very well-respected data protection bodies around the world. I'd like to welcome both of our panelists. Mr. Junichi Ishii is the Director for International Affairs at the Personal Information Protection Commission at Japan. And Ms. Valborg Steingrimsdottir is the Head of Data Security and Auditing at the Iceland's Data Protection Authority. Both of them have a wealth of experience given their years at each of their authorities, so I won't be taking up too much time, hopefully. I'm just here to kind of ask the questions and listen to their wisdom. We hope to cover quite a range of subjects in the next sort of hour that we have with both of you. So without further ado, I'm going to turn over for the first round of opening comments. I'll come first to Ms. Falberg and then go to Junichi. And we really welcome having you here. We didn't provide a detailed introduction, but please feel free to go ahead and introduce yourselves again. But we're very interested to hear about how your authorities are located under your parent legislations in your jurisdiction itself, of course. And I think one of the opening questions that I had for you is top 3 pieces of advice for rule makers at the start of a brand new law. I think both of your jurisdictions have had various iterations of this kind of problem, so we're very keen to hear from you. Thank you very much, and over to you, Falberg.
Thank you so much. The first point I would like to mention is that the Icelandic Data Protection Authority is an independent authority in Iceland, which means that it doesn't take, for example, orders from other authorities, such as the ministry. We have our responsibilities laid out in law. We have the Icelandic administrative law, which provides that the Icelandic authorities in general cannot act unless it is provided for by law. And the law that provides for our duties is mainly the Icelandic Data Protection Act, but also various other acts, such as the Act on Scientific Research using health data. And so we have several legal frameworks providing for duties or projects that we have on our plate. Our Data Protection Act incorporates the European General Data Protection Regulation on the basis of the legal framework for the European Economic Area. And as I am sure you are familiar with the European Data Protection Regulation, it stipulates many duties to the surveillance authorities. I consider our duties mainly twofolded. On the one hand, we have to carry out supervision or surveillance, both proactive surveillance and also we resolve disputes regarding the data protection. And we also examine, for example, data breach notifications and sometimes have to act on them. On the other hand, we have a supporting role, I guess you could call it, and we must provide especially other government entities with guidance, education, opinions, and so forth. The Icelandic Data Protection Act also provides that our surveillance authority issues rules, for example, on electronic monitoring, and for it includes maybe appropriate security measures, specific rights of the data subjects, retention time, deletion, and so forth. And the Act also stipulates that we issue credit score services or credit score agencies with a permit. And based on that, the surveillance authority issues permits with specific provisions on the processing of personal data that occurs for this purpose. And in issuing both rules and permits, we have to, as I said earlier, stay within the framework of the law, because according to Icelandic constitutional law and the principles of administrative law, we cannot issue rules that are not directly based on the Data Protection Act. However, as with the European Data Protection Regulation, the Act contains a lot of discretionary principles. So we can use these principles to set clearer and more transparent framework with the rules and the permits that we issue. And yeah, for the three pieces of advice. For us, what has been probably most important is our independence. I think it's very important that the data protection authorities are independent units within the government. What we have also found very important is the enhanced cooperation with other European countries since the data protection regulation was implemented, because it gives us both a wider knowledge of what is going on everywhere else and how they are resolving their issues, and also helps us in arguing our cases here, that we are not alone in regulating in the way that we are. And the third advice would be to have good human resources and efficient procedures, which we find very important.
Thank you so much. That was a fantastic bird's eye view of where you are. And already I can see clear distinctions from the regulatory structure that we are working with. But we'll hand over now to Junichi Ishii, and thank you so much for being with us. Over to you.
Yeah, thank you. This is Junichi Ishii from Personal Information Protection Commission, Japan. And thank you for your kind invitation to this interesting panel. And the Personal Information Protection Commission is also independent data protection authority in Japan, established based on our data protection law called APPI, the Act on the Protection of Personal Information. Personal Information Protection Commission was established in 2016, and our data protection law was enacted in 2003 and took fully effect 2005. So we had 11 years that we do not have any independent supervisory authority for personal information protection. In that time, we had a multi-layered, how can I say, multi-layered supervisory regime that, if I understand correctly, 16 government authorities had their competency to supervise personal information, supervise the handling of personal information with regard to their own competency. Based on their own competency. I mean, the Ministry of Economy, Trade, Industry supervised businesses in general. And at the same time, the Ministry of Internal Affairs and Communications supervised communications network businesses. And Ministry of Finance or Financial Service Agencies supervised financial institutions, such like that. But such supervisory scheme was very complicated, and we decided to establish a single independent authority to supervise handling of personal information. But the difference from the point of view in EU, I would like to touch upon that we at the Personal Information Protection Commission have another face, that is the policymaker, not only the regulator of the data protection, but also we have a face of policymaker. I will touch upon later. Anyway, our commission's start was more precisely the amendment of the APPI. We organized specific Personal Information Protection Commission, which had been established since 2014 to monitor handling of kind of national identification number called My Number. The specific Personal Information Protection Commission was reorganized to Personal Information Protection Commission, removing specific to have competency, not only My Number, but also to personal information in general. when the Personal Information Protection Commission was established in 2016, the Commission was only relevant to the handling of personal information by private sector entities. Our Commission and APPI have now committed to have been competent to both private sector and public sector entities, including national government agencies, as well as local governments, by the third amendment to the APPI made in 2021. Just for your reference, the 2020, we had a second amendment to the APPI that enhanced and reinforced the protection of personal information, especially with regard to the rights of individuals. Well, the PPC is composed of one chairperson and 8 commissioners. The secretariat from which I am joining even exists to support the commission. The secretariat is composed of about 200 officials. Out of 200 officials, about 20 are officials for international affairs, which I belong. And our commission has several missions, including monitoring and handling of personal information and enforcement of law. And as I said earlier, as a face of policymaker, our commission also is entitled to administrate of the law. I mean, conducting so-called every 3-year review of the law, and if necessary, draft possible amendments to the law. And international cooperation. The last element is the reason why I present myself here today. Well, I read the news article recently reporting that the Minister of State in India said that several regulatory authorities, other than Data Protection Authority, Data Protection Board, if I understand correctly, could establish their own rules on cross-border transfer of personal data. But if I may, my advice is that the rules and regulations should be as simple as possible for the sake of compliance by the entities that is bound by such rules and regulations. This is my initial comment. Thank you.
Thank you so much for your opening comments. That sets us up really well for this conversation. It's super wide ranging, so I'm hoping that we can pick up at least on a few of the themes that have come through. To me, I think as we move into the substantive, first part of the discussion, two things have stood out. One, of course, is the idea of independent authorities. So I think the departure point for India here is that in our final act, we have a data protection board, but this is very much an enforcement and complaints kind of body, and it doesn't have actually rulemaking authority, as all of you will be aware. The other thing then is that the rulemaking and regulation making under the Act really goes back to the central government ministries. So it's really valuable to have both the perspective from kind of implementing the GDPR in Iceland, but also I think that 11-year period that you mentioned in Japan, where there was no single independent regulatory authority, and then the transition to a regulatory authority, because these are all sort of slightly different models, which is why this is so rich. I suppose my first big question then is, what would you do differently if you thought that this was the ministry making the rules? It's kind of pie in the sky, but given our situation in India, does that actually substantively change the prioritization of rulemaking? And then we can go into substantive areas as well. But I think the big question as we sit here and look ahead to the rules in India is, how does that actually change the prioritization of rulemaking? Does it have an impact? Because in our case, there will not be an independent authority that will be making these rules. It will very much come from central government. And I open that question up to either of you based on your experience, including of international cooperation.
I'm not sure I have an answer to your question, because as I mentioned earlier, we are, according to our constitutional and administrative law, bound by law. And that that applies also to the ministries. So the ministries also have to act within the law. So if we are talking about issuing rules based on law, it's always congressional legislation that has the final say, so to speak.
Junichi, anything that you would like to add?
Well, in general, under the Japanese legal system, we could, we as government agency could establish delegated rules, rules and regulations delegated by law within the scope of law. So we cannot establish any new obligations or rights by law, by rules or regulations other than originally prescribed in law. That is the basic rule for the rules and regulations to be established under the delegation by law. So, and speaking of personal information protection legal system, we have only one law, the APPI, and APPI delegates several elements to rules and regulations. More precisely, the APPI delegates, for example, and if you would like me to, I would like to explain more detail in later. But for example, the details of identification, personally identification code. That is the one of the personal information in the definition of APPI. The APPI delegates the details of personally identification code to cabinet order first, and the cabinet order then further delegates to more details of the personal information, personal identification code to rules established by Commission. So we can say we in Japan have multi-layered regulatory and legislative structure with regard to personal information protection, and that might be a cause of, how can I say, a kind of claim, a kind of complaints from businesses that it's very difficult to understand the whole of the regulatory framework of the personal information.
Thank you very much. And that's helpful to know. I suppose just to provide some context on the rest of our conversation and where our questions are coming from. So under the new Digital Personal Data Protection Act of India, all of the rulemaking that we are talking about in this conversation obviously would come under that legislation. The legislation, however, is very wide. So it delegates, I think there are over 20 instances of sub-delegation for rulemaking. So much like the cabinet orders and the rules that you just mentioned in Japan, India, we expect will have, under the DPDP Act, a set of regulations that will come out in each of these areas. And the areas are very wide. They range from, for instance, even the notification of how different dates for coming into force of different sections. So we do not have currently transitional arrangements, for instance. And the rules for notification will move from things like powers of exemptions under the Act to notifications on the restrictions of data transfer, an area that we hope that will go into. And then, of course, even specific standards in relation to how you have the form of data breach notifications and so on. So really, we're looking at the whole swath of rulemaking. I think the critical distinction here, though, is that rulemaking will come from central government. So there's almost a delegation back to central government in order the rulemaking power stays with our central government, and then the Data Protection Board itself is primarily an enforcement body. So I suppose, given that structure, if we go into the substance of the kinds of areas as well that are to be prioritized, one area that has already come up, I think, in both of your comments, is this idea of the international transfers and cross-border rules. And so perhaps we can turn to that as one of the areas of rulemaking that will be quite a high priority and that global businesses are also interested in. And your kind of advice for rulemaking in that area, given that clearly it is also influenced, in the background of several geopolitical negotiations that go on. Before I turn to you very quickly, again, just to frame where we are coming from, in the Indian legislation itself, there is under Section 16, essentially, specifically, the no restriction on data transfers unless notified by central government. So really here, the rulemaking authority will come for notification on restrictions, or blacklisting, as we call it. Interestingly, there's no objective criterion to guide the discretion. It's a very simple provision, 3 lines in the legislation. So this is going to be quite an exciting area. So I think on that, my main question back to you, and maybe I'll come first again to Junichi and then go to you, Vaibhav, is how do you think that the rulemaking develops when you think about cross-border rulemaking? What has been your experience in the considerations that affect these rules that come in your specific countries, especially I think for Japan, because you have managed to be in a position unique where you have both adequacy from the EU and you are a member of the cross-border data flows. So coming to you first, Junichi, and then over to you, Vaibhav.
Yeah, thank you. As you pointed out, our Personal Information Protection Law (APPI) has regulations on cross-border transfer of personal data, and such regulations were introduced by the first amendment made in 2015. I'm not sure if I could say this, but I heard that that was the main reason to introduce such regulations were to obtain adequacy decision by EU. And as you may know, after 3 years negotiation, we at last achieved the mutual adequacy decisions between Japan and EU. And to achieve that mutual adequacy decisions, the APPI had a scheme to designate foreign country to which the personal data can be transferred as same as the manner in domestic transfer of personal data. And the APPI recognized 3 main transfer tools. That is the designation of foreign country I mentioned before. And the second one is safeguarding personal data by arrangements between data exporter located in Japan and business operator that is applied, that the APPI applies, and data importer in foreign countries. The typical elements, typical instruments is contract between such entities and binding corporate rules or something like that. And the third tool is explicit consent by individuals. Well, we had to elaborate how the Personal Information Protection Commission designate foreign countries as those to which personal data can be transferred. And that was delegated to Commission rules. Also, we had to clarify what kind of instruments business operator could use to transfer personal data by safeguarding the personal data between data exporter and the data importer. These elements were delegated to Commission rules, and we elaborated requirements when we at Personal Information Protection Commission designates foreign countries as those to which personal data can be transferred. If I remember correctly, we have 5 requirements for such designation. One is also, of course, relevant or equivalent protection personal data. But interestingly, we had another requirements such as possibility of mutual cross-border transfer, cross-border flows of personal data. I mean, that country to be designated does not have policy on so-called data localization. And one important thing is that designated to be the country or foreign country to be designated has independent supervisory authority for personal data protection, as similar as Personal Information Protection Commission in Japan. And speaking of safeguarding personal data between data exporter and data importer, we elaborated that, of course, the business operators can rely on contract between entities relevant to data protection, cross-border transfer of personal data, but there is another element that is certification. I mean, internationally recognized certification can be used as such, as one of such instruments to safeguard personal data transferred to abroad. So basically, we at the Personal Information Protection Commission toward the, how can I say, how the both individuals as well as businesses that is bound by personal information protection law could benefit from such rules elaborated by Personal Information Protection Commission, and we established such rules and regulations. So that's a very, very good question, but actually we only have designated EU and UK.
Thank you.
So the only designated region is the EU when we designated the EU as a foreign country. And in that time, the UK is a part of the EU.
Excellent. Yeah, thank you so much. Super helpful. And we're going now to the EU perspective. Over to you, Falbuk.
Thank you. Yes, as for the international transfer, we are entirely bound by the decisions of the European Commission as to which countries are considered safe third countries. But we have a seat in the European Privacy Data Protection Council, which advises on the matter. So we are taking part in the conversation. And further than that, we have the EDPB's guidance regarding which measures are sufficient when transferring data to unsafe third countries. But we have found that it is very complicated to deal with, especially when we look at the cloud-based services, which are our main concern, I think, because of strict requirements on encryption, for example. And so it becomes very technically complicated. And this, as you mentioned, might be a reason for us to consider setting out some broader guidelines. But of course, we are bound by our European framework. But now that we understand better where your questions are coming from, as you said, I agree, because our legislation, as it sounds like your legislation as well, is based on some broad principles, which we have to interpret in each case, and it depends on the nature of the data, as well as who are the data subjects and the nature of the processing, what requirements we make about the data processing. And that also could be the grounds for setting out some rules that apply in different fields, because then you can have more transparency in what requirements we are making regarding each category of data. For example, as I mentioned earlier, that we issue these permits for the credit processing, because that processing has great consequences for people getting loans, and so it's natural that we set out specific principles to lay out these are the requirements that we will make based on the principles of the legislation when it comes to this specific data processing. And aside from rulemaking, because as I mentioned, I think we have only set out rules for the credit data, as well as electronic monitoring. We do make our own policies as when it comes to our surveillance. So each year we issue a policy where we state what will be our priorities in the next year, and that this is the policy. We always look to the policy when we are making decision where we are going to put out our resources. And for the recent years, we have prioritized the protection of children's data, as well as the protection of health data. The first, because the children's data is specifically protected in the GDPR, and as to the health data, in Iceland we have extensive collection of health data, centralized collection of health data by the government, and the health data is categorized as sensitive data, so that these are the reasons for these priorities. And we have also done how political parties use platforms, social platforms, to aim advertising to potential voters based on profiling. And that was due to the British ICO's investigation on the similar matters, as well as we became aware that the Icelandic political parties are using these social platforms to great extent. And I think 90% of Icelanders use one or another of the main social media platforms like Facebook or TikTok. And so all this has resulted in our surveillance being focused a bit too much perhaps on public entities. So now for the next year, I think we are going to try to focus a little bit more on private entities.
Thank you so much. That is all incredibly relevant and resonates with where we are in India in terms of both I think the public debate and the focuses. So all those three areas that you mentioned, children's data, health data, and this question around social media regulation, especially in the context of election advertising. If you can call it election advertising, it should be canvassing in my view. But actually, just to go, that was very interesting to hear about how you set up a policy, if I understand correctly, of the areas where you would be focusing on rulemaking, and then you move into your processes of rulemaking. Could you tell us more a little bit about the process themselves? So when you pick up a particular area for rulemaking, how you approach it, what are the generalized kind of rulemaking processes and requirements that you put in place around transparency, accountability, and also the process of rulemaking, both in terms externally, in terms of consultation, but also internally? Is there a kind of broad framework or anything that you follow?
In setting out our policies?
and the actual rulemaking process itself.
So how we conduct our surveillance.
Yeah, yeah. Is there a surveillance before you actually set out the regulations and the rules?
As so far, we have been doing this all at once, I think. We are always trying to make it a little bit more transparent beforehand. For example, when we first set out our policy, it was kind of based on just what we had been doing already. As to how we conduct our, so you were asking about how we decide on when we are making rules, for example, about, should I say, electronic monitoring? Yeah.
I mean, go ahead.
Sorry.
I think based on my understanding, just to clarify, I think my understanding is that you have your policy where you identify the specific areas, and then you mentioned that you go into the rulemaking process. I think, given where we are in India with similar issues, which I hope we have time to talk about, I thought it's helpful in this part of the conversation to move into your processes themselves. So moving from the identification of the areas into how you actually undertake your regulation and rulemaking would be super interesting to hear about.
Yeah, okay. Because when you talk about the rulemaking, I'm not sure what you are speaking of, because we don't issue any specific rules on regarding this specific data processing, but we conduct our surveillance. So we audit and investigate, and then where we decide to audit and investigate usually depends on the information that we are receiving anonymously, or by, for example, complaint, or if we get a lot of data breach notifications regarding a specific processor, then usually that is where our focus goes. Unfortunately, we have been a little bit understaffed or underfunded in the recent years. So we haven't been able to do as much as we would like. But based on the cases that we are getting notifications about, we have, for example, been looking at cloud-based services in the health sector. And we have been looking at cloud-based services in the elementary schools. When you, for example, using Google, and we have also, as I said, we have investigated the use of the political parties of the social platforms and issued an opinion about that, and also called for a more of a cooperation-based process with the political parties. So just to try to prevent that something happens later on.
Well, thank you very much. I think that's helpful in our context. Before I move to Junichi, maybe to take this forward. So for us, the way that we see it happening in India, say, for instance, if we go into social media regulation, there would be a first tier. We have something in the act, there would be a first tier regulation. We expect there will be some more fine embedding of rules. And then, as you mentioned, as we go through our iteration, perhaps based on what we are seeing emerging in our context, we'll have maybe more fine opinions, guidelines, maybe softer codes. It's interesting because we're so much in an earlier part of the journey right now. I don't know whether that maps to the kind of multi-layered model, Junichi, that you were talking about before in relation to how things have been going in Japan. But if you could share anything about the rulemaking processes. When I say rulemaking, I really mean the entire swathe of regulation under the essentially subordinate legislation under the Act. Welcome your comments as well.
Well, in Japan, we have Administrative Procedure Act that generally prescribes the procedures to establish kind of cabinet order or ministerial rules, enforcement rules, including Commission rules that we established in terms of the APPI. And that Administrative Procedures Act prescribes that we have to go through public consultation if we establish any rules or regulations that affects rights and interests of individuals. And Commission rules delegated by the APPI certainly affects interests rights and interests of individuals. So we had to go through the public consultation with our draft of Commission rules, as well as Cabinet order, as well as Commission rules. And while I have failed to mention this, but we have another layer of regulatory scheme, that is guidelines under the Commission rules. And maybe it is unique for Japan that our guidelines contain, how can I say, binding one, in part. I understand the guidelines based on GDPR does not contain any binding nature, but our guidelines established by a Personal Information Protection Commission in part contain binding one. Mostly these binding one are binding provisions in the guidelines are changing the words of law or cabinet orders or commission rules, but and other part of guidelines are not binding, just for reference for businesses to prepare for their compliance with laws and regulations. Anyway, we have to go through the public consultation procedures before we establish any cabinet order or commission rules delegated by APPI. And notably, I'd like to introduce that we experienced, or we went through another consultation process with stakeholders before we go into public consultation procedures. So generally speaking, I can say we generally first hold consultations with stakeholders and prepare for draft and go through the public consultation and then establish rules and regulations.
Thank you. That was very interesting, actually, because I think that's exactly where we are at the start of in India. And it's very helpful to see that flow from kind of almost stakeholder consultations, which I think the minister is beginning to have with these dialogues in India, moving into your public consultation process, then the draft rules, and then the public consultation and so on. I had a quick kind of follow-up on that, actually, is that one thing that has emerged from this conversation is it's not so linear that you make the regulations and then you do the enforcement. It's very interesting for me to hear that rulemaking or regulation and the draft rules intersect with enforcement in some sense. So you have your rules, and then you see through your surveillance and supervision that certain areas require more regulation. Maybe they require more attention. And I wonder, before we go into specific areas, if I could just ask you to reflect on how you pick those particular areas. So I think Falberg, you've already mentioned a lot of this comes from complaints and from things that are driven from the bottom up. But we know in India, for instance, that having a bottom up driving it's not potentially going to happen as much given the frame of our current legislation, which I won't go into. But I think also just the fact that our capacity will be starting to get built up. We don't know. I mean, potentially citizens could be sending in complaints, but really it looks like there's going to be a lot more proactive surveillance to understand the issues. So given your vantage point as regulators, and also people with responsibility to make regulation, how do you pick your areas? I think, how do you pick what needs immediate attention, and what does that timeline look like? Would love your thoughts. I'll come first to you, Falpo, and then to Janiki.
Thank you. Yes, I think there are benefits to both ways, as you mentioned. And if it's more proactive, then of course you have maybe, but it's better to have some data to base your decisions on. And we try to use our, as I mentioned, our complaints and data breach notifications and other, we get also like anonymous notifications. We try to use it to build up some data to try to see some patterns. But other than that, we have also mapped out, for example, based on the GDPR, we look at which categories of data should have specific protection, which data subjects need specific protection. And as I mentioned earlier, are there great risks connected to this specific processing? So these are like the three basic criteria we look at. And adding on that, we know here in Iceland, we have a lot of centralized data by the hand of the government, because we are, I don't know what the right wording is, but it's a Scandinavian welfare state. So we have a lot of centralized data. And as I mentioned, that has led to our surveillance been aimed a lot at public entities, but more and more private entities are collecting more and more data, and that's what we would like to prioritize, where there is collecting of a lot of data, and look at these three criteria I mentioned earlier. And sorry, and just to add, because we use, for example, when we look at the data breach notifications, we don't only look at where we get a lot of data breach notifications. We also look at where we are not getting data breach notifications. And so, for example, we have three large banks in Iceland. And we have from one bank a lot of data breach notifications, and then some from the second, and then I think none from the third. And that also gives us cause to look into what is happening there, because I'm sure there are data breaches happening there, but why aren't they notifying us, and what is going on? Yeah. So gaps in data also give us clues.
Yeah. Super interesting and very relevant, I think, because in the Indian legislation, we do talk about classes of data fiduciaries. So both for thinking about regulation, but also for exemptions, which which is also, I suppose, a regulatory power. But before we move there, Janichi, is there anything from your experience in terms of prioritizing areas? How do you do it in Japan?
Yes, speaking of cabinet order and commission rules, contents of cabinet order and commission rules, the content, these contents are specifically prescribed in law. So we have no choice to select which we prefer to prescribe in commission rules or cabinet order. We just do what law delegates to us, what law ordered to us. And for your reference, the contents of cabinet order, what prescribed cabinet order is details of individual identification code, further details of sensitive personal information. A part of sensitive personal information is prescribed in law, but some of the sensitive personal information is delegated to cabinet order. And derogation from obligations prescribed in law, and derogation of powers, delegation of powers from Personal Information Protection Commission to other regulatory authorities relevant to individual areas such as securities, finance, or communications. That's our contents of cabinet order. And Commission rules are set to detail further details of individual identification number, and also further details of sensitive personal information, and detailed items to be brought in data breach notification. And as I introduced earlier, the details of cross-border transfer of personal data. Of course, there is more issues to be set in Commission rules, but again, what we could establish and what we should establish in cabinet order and Commission rules are all set in law. So there is no option to choose the areas of focus or something like that. So our availability to select the focusing area might be in guidelines that is more flexible to establish for us to show the details of or clarification on the regulation of personal information protection. And if I understand correctly, maybe the first step will be the inquiries made by businesses or individuals, because we at the Personal Information Protection Commission provide how can I say, windows for such inquiries from individuals as well as businesses. And as a policy maker, we regularly have communications or exchange of opinions with business or academia or some other stakeholders. And such exchange or communications bring us insight what areas should we focus on next, and maybe we can amend guidelines as needed or some other activities to make clarifications on the law or cabinet order or commission rules.
Yeah, thank you. That reminds me a little bit of the FTC. I know that in their international affairs side, I've heard people speak once about how they organize roundtables with stakeholders, with industry participants, often to understand, bring them in and understand their technologies a bit better, even to make that assessment of whether guidelines are required, whether guardrails are required, or actually there's no regulatory intervention. So that was fascinating to understand as regulators who make rules, how much kind of capacity you need to look at complaints, anonymous tip-offs, or data breach notifications, but also this kind of active engagement and coordination almost with stakeholders that in the face of technological change. I think in the last part of our conversation, I was hoping to delve into a couple of areas that came up, which I found very interesting. So Valbag, you mentioned about the centralized data within your government as a kind of, Scandinavian welfare state. We also have a very datafied welfare state in India. In fact, many would say that the right to privacy judgment that really preceded and put the coals in the fire for our Data Protection Act and kind of made it happen came out of a constitutional case revolving around our biometric data usage and storage under our biometric ID. So in that sense, very connected both to the Japan My Number kind of jurisdiction and overlap with data protection issues. And I think the other thing that came up was really this question around children's data. So we do not have sensitive data, personal data anymore as a category in Indian law. But one category of data that is going to need a lot of regulation making is children's data. So hopefully, if we have the time, I'm very curious to delve a little bit into how you're thinking through these issues now, especially after some enforcements that we've seen. I'm thinking of the Italian case around children's data and usage there. So maybe we can turn first to the centralized data within government. How do you see your role when you are undertaking this kind of surveillance, and how do you negotiate that relationship and almost having to create regulations for government around their data use as a data controller? Falberg, I think this was your point, so I'll come to you in case you're able to share more.
Yes, I think so far we have, as you mentioned, we have been focused on the health data. It came apparent to us. We also have the genetic information that is all stored in a kind of a private entity. But there is a great cooperation between that private entity and our general public hospital system, especially connected to scientific research on health data. So we have this act I mentioned earlier this morning on scientific research based on health data. Based on that act, we have to monitor specific aspects of these researches, but we also have other public entities that are monitoring other aspects of these researches. So there has been a bit of collision there, but we had several cases during COVID, for example, where there was this collision between this specific private entity, which stores all our genetic information, and the public hospital doing research on COVID patients. And we had 3 major decisions where we came to the conclusion that there was a breach of both the Data Protection Act as well as this act on the scientific research. And that we found was a bit difficult for our cooperation with the other surveillance authorities, because we were not in complete agreement on how to interpret these acts. But this is something that we take very seriously, because especially these researches, when you collide these health data and the genetic data, this can have a great consequence for people. Yeah, I'm not sure if I'm answering your question, but this is an example of our surveillance.
No, you're exactly answering the questions. And I suppose, I don't know how much you can share, but negotiating that must be incredibly hard within government as a kind of government, but also very good, I think, for kind of democratic values, and especially things like data protection. So I don't know if you could share anything more about how you use guardrails or requirements in those kind of internal discussions that perhaps our ministerial colleagues might hear from when they are at such a table making these kind of decisions.
Yeah. But then again, we are this independent body, so we don't have an obligation to negotiate. But of course, it's better to be in some kind of understanding, especially with other surveillance authorities, and yeah. So it requires a conversation and an open dialogue. I think that's the best way forward.
Yeah, definitely. And as I said, I think this is one of the kind of big shifts in the legislation. Personally, I was hoping for an independent data protection authority for exactly that kind of advisory role that it could play as an independent stakeholder, but we have what we have. Janice, I just want to come to you on this point. I mean, if you have anything to share in relation to your role vis-a-vis especially the central government or other governments as data controllers, but also the question of children's data, whether you're currently considering rules, you already have rules, how you negotiate that?
Honestly, that's a difficult question to me. But my understanding is children's online will be certainly one of the topic that would be addressed in the course of next every 3-year review of the APPI. I'm not sure if that discussions will lead to any amendments to law or amendments to Commission rules or guidelines. But anyway, considering all of the many data protection regulators all over the world now focusing on children's protection or children's and data protection issues, we at the Personal Information Protection Commission should also discuss and deliberate how we could do in that issue. Speaking of the relationship between Personal Information Protection Commission and other ministries, government organs, with regard to MyNumber, the MyNumber Act is administered by other government authority than Personal Information Protection Commission, unlike the APPI, the Personal Information Protection Law in general. So in that terms, we at the Personal Information Protection Commission could be purely a regulator and enforcer of the law, and there is no room of conflict of interests between Personal Information Protection Commission and other ministries. Personal Information Protection Commission is just enforcer and regulator and supervisor of handling my numbers by other ministries. Meanwhile, the APPI, as I said earlier, Personal Information Protection Commission has a pace of policymaker that administrates but the APPI itself. So it is a challenge for us to avoid conflict of interest in terms of policy making and regulating, enforcing, supervising of the law. So we, if I understand correctly, we have a firewall between the team competent to enforce the law, monitoring and supervision divisions against policy-making division that is handle that is discussing how we could improve the law itself within the commission. And if I could add something, our commission that is composed of one chairperson and 8 commissioners are set to act by their own will, and they should not be affected by any other powers, including Prime Minister in Japan. So as such, the independence of the Personal Information Protection Commission is ensured. Thank you.
No, thank you so much. I think we're coming up to an hour on our discussion, but there's still, I mean, I think this is the point we began with, which is independence and regulation making. And I think it's interesting that we've come full circle. And it's actually really helpful to see how you negotiate. I suppose in an Indian case, we have a natural firewall between our enforcement and our regulation making because it will be delegated back to central government. One question that we didn't have time to cover in our comments, which perhaps I welcome you to cover in your closing comments if you have any, is this question of exemptions. Because just as, you know, these assessments based on ground surveillance and your supervision and risk, you know, that you focus on particular areas, such as, for instance, biometric data usage or children's data or health data, Just as you focus for regulation in India, also we have the option of focusing on exemptions. So you're exempting certain classes of data fiduciaries, exempting certain state instrumentalities and state entities from the application of the Act. And even interestingly, exemption of the children's data provisions from certain types of data fiduciaries having to follow that. So these kinds of exemptions was an interesting power that our authority, the ministers will have under the Act. Unfortunately, we haven't had a time to get your opinions on that, but at this point of time, I would welcome a final round of comments. Thank you so much again for having this wide-ranging conversation, starting from, how do we think about areas right down into specific areas of regulation making and the room for movement that you have once a law is passed. For our final comments, I'll welcome first to begin with Falberg, and then I'll move to you, Junichi. And as I said, any final thoughts on exemptions would be most welcome, but any other pieces of advice that you would like to end with, knowing what you know now about our context, are also most welcome. Thank you.
Thank you. Regarding our exemption, I can mention that, for example, courts in Iceland are exempt from the Data Protection Act when they are conducting in their judicial powers. And recently, I think it was in 2018, the European Court of Justice concluded that, for example, the court's conversation with journalists about what is going on within their courts is something that falls within the scope of when they are acting in their judicial power. And therefore, we consider now that almost nothing that happens inside the courts is under the jurisdiction of the Data Protection Act. And that is, in our concern, something that we would like to what should I say, review when we are reviewing our legislation, because in Iceland, the courts publish almost all their decisions on their websites. So it's very extensive publishing. And then there is a search engine. And of course, within the courts, there is a lot of sensitive data, there is a lot of health data, and so forth. And so this is very intrusive processing for the individuals. So this is something that we would like to review. Perhaps it's not the solution that the Icelandic Data Protection Authority should have surveillance of the courts, because they need to have their independence. But we consider that it is important that they have to oblige to the Data Protection Act nonetheless. So yeah, that's one of my examples of our exemptions.
Thank you. And a final word to you, Junichi.
Yeah, thank you once again. Thank you for letting me join this conversation. And first, exemptions in the APPI is also APPI has also exemptions to their obligations, rights and obligations. These exemptions are applied to broadcasting institutions and news reporting institutions, or those who are professional writers or religious institutions. And maybe that is different from the GDPR, but political parties are also exempted by APPI. That's because the APPI respects freedom of expression, freedom of religion, freedom of political activities. So we at the Personal Information Protection Commission does not have any power to supervise and enforce the law to these exempted entities. But as I said, as for political parties in the foreign countries, I understand it is a rare case that exempt political parties from the activities from the application of data protection regulations. So that would be a point to be discussed in the course of review of the APPI in some future. But since the APPI amendment to APPI is to be done by national diets that is composed of political parties, it might be difficult for us to achieve such amendments. That's headache. That may be a headache of my personal headache. And with regard to the data protection authorities to be established in India, what I would like to say is the important thing is cooperation between and so cooperation with foreign counterparts, foreign authorities, and to understand other legislative systems, legal systems, and philosophies that the legal system has to make their own rules and regulations, rules and regulations to be aligned as much as possible to international norms. So in that regard, I would like to thank for this opportunity to have conversation with Icelandic authorities as well as Indian giant of knowledge. So thank you for the opportunity once again.
Yes,
Yes,
if I could
and
also
yeah,
add
of
that,
course, go ahead.
yeah, because I just wanted to thank you as well for inviting us to participate in this meaningful conversation. Because I mentioned in the start that we value very much more cooperation with our European counterparts, but also it's very helpful and important for us to have a dialogue with other parties as well. So this is has been great, and I have learned a lot. So thank you.
And it's my turn to thank MediaNama actually for bringing us all together. It's interesting that we're doing this in the week, we're taping this in the week of the Global Privacy Assembly annual meeting, where I know that many of the regulators get together this year in Bermuda, but hopefully next year you will have someone from the Indian Data Protection Board as well presenting at the Global Privacy Assembly. In the meantime, though, we will continue to watch the space. I want to thank you so much again, both to Falgad and to Janichi for joining us for this hour, and to MediaNama for bringing us together. All the best for the rest of the PrivacyNama conference as well, and back to the MediaNama team. Thank you so much. We're very excited to be having this conversation today. After several years of waiting for an act, we can now say we have one. As you all know, India passed its data protection.
Sorry, I guess I started playing again. Thank you all. We're breaking for lunch. Post the session, we have a little bit of a surprise. Bruno Genserelli, the head of the European Commission's International Affairs and Data Flows Unit, who basically the unit that deals with adequacy, they specifically wanted to participate in the discussion on cross-border data flows. And you know that adequacy with the EU is a slight bone of contention and a tricky situation following the DPDP bill. So we look forward to hearing from him. We're open for lunch. We'll take about 45 minutes and hope to see you all then. Thanks.
I just.
Yeah.
Take.
Hi, everyone. We'll be starting with the post-lunch sessions now. So everyone who's standing, if you'd like to take a seat in the next minute or so, we can start. All right, so thank you everyone for joining us on day 2 of PrivacyNama, especially for the post-lunch session. This is a great one. It sort of looks at one part of the past bills that's sort of been trimmed down significantly in the act that was eventually passed a few months ago. And those are the provisions on cross-border data flows. What was once very extensive, complicated, is now sort of being whittled down to 2 sections, but I think there's a lot to read between the lines in this case. So we hope to have a really productive and constructive discussion on everything that's been happening over here. I'd like to welcome the moderator and the panelists to the stage. Speaking today, we have Venkatesh Krishnamurthy from BSA, the Software Alliance, Bhavna Sharma from PricewaterhouseCoopers, Vivek Abraham from Salesforce. Tuning in virtually, we have Bruno Gencarelli from the European Commission's International Affairs and Data Flows Department. And moderating today's session, we have Arinderjeet Basu from the Center for Internet and Society. So thanks so much and look forward to hearing you guys.
Hi, everyone. Thanks for joining for this session. Post-lunch session always sometimes difficult to keep awake, but hopefully we have an excellent set of panelists that will ensure that you are excited enough. And it's a really interesting topic as well. I'll keep my opening really short. I think we are in a phase now where we have a very specific provision in the data protection law, and we're also in a phase where the various sectoral notifications that are equally important when considering compliance for businesses, such as the RBI directive, have been there for quite some time. So I think it's really time to both reflect and to think through what the existence of these provisions mean for businesses, both in India and outside in terms of compliance. So I think in our kind of initial conversations, what we realized is that we are in a post-theory world on cross-border data flows, and really looking at what the present implications and future implications could be. And we can't have a better set of panelists to talk you through some of these implications. So as I said, I'll keep my opening very short and take you through basically, hopefully, the economic security and various grievance redressal mechanisms that could arise through some of these things. So the first question to Vivek, if I may, just to lay out the broad, from a business perspective, what is the broad state of play? Who are the relevant regulators? And just normatively, do you think that this blacklist approach that we have in the latest in the law is something that makes sense? And how do you approach it from a business perspective? So let's keep it broad and we'll narrow it down later.
Thanks, Arindrajit. So broad state of play. I think we all are aware of the DPDP bill, the act now. So you have clause number 17, or is it, or 16 and 17, which talks about cross-border data transfers, which the bill or the act right now says that you can do it subject to certain conditions, which the government will come out in the future. We don't know for certain what those regulations are going to be. Obviously, there's a lot of news, there's a lot of talk around this negative list or blacklist approach, where they'll cordon off a few countries where we couldn't transfer data. Now, what the criteria should be around blacklist, and whether it will change or whether it's just one plain list, no explanation, we have no idea, right? Now, as a result, I don't know how generally the industry is reacting, but I can tell you from a Salesforce's perspective, we are not really reacting as of now. We are waiting for things to fall as they were. And we are hoping, and I don't know whether the word confident applies here, is that we should not be greatly impacted. The sense that we have from various discussions and reports everywhere around the internet is that most of the G20 countries should be okay for us to transfer data to, and it should not impact a lot of our business processes. But that's the basic layer. You've obviously mentioned RBI. There's we've been always conscious of that fact that we have to have payment data or transaction data stored in the country. SEBI has actually an interesting requirement as well, where if you're operating on the cloud and you're a regulated entity by the SEBI, you need to ensure that the cloud operator is MeitY empaneled. And one of the requirements of MeitY empanelment is you need to have localized data storage. So there's cross-border data transfer regulations for you there. I'm expecting more explicit rules and regulations coming out from all the other regulators. Financial services is an obvious one. Probably there's going to be health. Probably there's going to be something around national identity data. This could be social media kind of data or inferences that may be there, or anything that's seen to be sensitive around gender, caste, or whatever that people think is. And maybe you can go back to the original 2019 definition as well to get some color around what could be down the road for us. It's all up for grabs. I don't know exactly, right? But I don't think it will come through these rules, through the DPDP rules. It may come through other regulators as of now. Like I said, we're not reacting till we know what's there for certain, because each of these changes for companies like us requires millions of dollars of investment, several thousands of hours of effort. It's not a fun decision to make when you don't know what's happening and if you could get it wrong.
So I think one key point that came through is that despite having a law, there still remains some degree of uncertainty and kind of predicting which way various other policies will go as well. So moving to Bhavna, you advise a lot of clients on navigating some of these uncertainties. And then, so one of the question is on that. What is the general advice that you would give on the uncertainty in the landscape? And also a more, I suppose, practical question is, when this blacklist is drawn up, what would be your recommendations on what should the criteria be? So of course, Vivek mentioned the G20, and so some degree of economic cooperation could be a potential factor, but what are the other things that you think the government should bear in mind? So I suppose two questions there. One is the uncertainty, and second is, when this blacklist is being drawn up, what are the criteria you think should be there in mind? Thanks.
Thank you for having me here, and thank you, Arindrajit, for such a layered question. So as we all know that Indian government is very clear with its stand when it comes to regulating cross-border data flows or any tech sector that is technology related. So they are clear that they have to take up the principle based approach, where they will be putting up the principles in the main act and they will be regulating via rules. Similar approach has been taken for cross-border data flows as well. As we can see, we have only two provisions, very short provisions, section 16 and 17. And section 17 clearly lays down that there will be no prima facie restrictions on cross-border data flows with regard to any country, unless the central government notifies a country to be restricted. And that's what we have called the blacklisting of the countries. So for my understanding, and as being working with PwC now, and I've also worked with the government, what I feel that as we have already 7 principles in line in the act already, there has to be 4 more principles that should be aligned for cross-border data flows. The first is principle of uniformity, where I am saying that there has to be a non-discriminatory treatment among the countries when we are choosing for them to be in the blacklist or not. Non-discrimination based upon nationality, products, services, geopolitical conditions, etc. For a being, we shouldn't consider all those things. Another thing, when we are talking about uniformity, there has to be well-defined rules, criteria regarding consent mechanism, transparency, accountability, and all other aspects, specifically for cross-border data flows. Because here we need higher level of protection. We cannot rely on present consent mechanism that we have presently for Indian citizens presently. Another one, I would say that when we are making these criteria, firstly, we used to focus upon Indian requirements, but here we have to focus upon what is there in the other countries' law. Why I'm saying this, we can take an example of Schrems judgment. What has happened there? The CGEU has invalidated the privacy shield among EU and US. Why? Because US had certain surveillance programs that were not keeping the EU citizens' data protective enough that was required as per the adequacy standard. And that is why it was invalidated. So for my say, I would say that we have to have certain ground norms that has already been followed in the countries, and basis that we have to set up our standards that are being actually practical and can be easily operationalized. The second principle I would say is data responsibility. Here I am talking about the proactive measures the industry should take. I'm not saying this from government perspective, but even from PwC and other Big Four practices, we always say this, tell us that this is what you have to do. Do not keep us into doubt or into ambiguity what we have to do and what not. Data responsibility talks about all the due diligence requirements. We can see under IT rules, we have so many obligations as due diligence requirements on data fiduciaries and intermediaries. Similarly, we should have it for data fiduciaries and significant data fiduciaries as well. Next is very important, very controversial, data localization, still not mentioned under the Act. For this, I would say I'm not too much favoring data localization, but yes, there has to be partial data localization. First and foremost thing that we need to do for this, the Indian government should do, is categorization of data. That is, again, not there in the Act. Because for data localization, we have to have server located in India. If we are having this requirement in India, then it has to be only for very sensitive data. That is the critical data. We can have lessons from Germany. So German federal law says that the German citizens' data has to be processed in their German Federation region only. Similarly, China's cybersecurity law says that if you are processing any critical data, then has to be processed in China. Similarly, we have to take a lot of things from what is already done when we come to data localization requirements. There has to be both partial and strict basis what kind of categorization of data that we have. The last is data resilience. Here I am talking about the reactive measures. Here we have to tell the industry regarding what may be the steps that has to be taken when there is technical failures, when there is cyber attacks or any breaches that are occurring. For this, I would say that there has to be redundancy and backup plans. There has to be recovery plans. There has to be residency policies that has to be adopted by the industry. Also, as I've listed all these 4 principles in addition to the existing one, I would like to mention that this blacklisting concept will not be a one-time process. It will keep on evolving, keep on changing, basis one or the other thing happening. Another thing, as we have set up the standards, very important thing is that the rule should have certain grounds basis which there will be no restriction. I'll give you an example. PwC doesn't involve into cross-border data flows with Syria. We do not indulge with Palestine. Basis is terrorism angle. I would say that Indian government should come up certain grounds basis which there will be no transfers of data. And another thing is, I'll wind up the answer. We were coming on transition time. And so for this, I would say that we do not need to worry about, because government is very much favoring the industry. They are not coming up with unreasonable timelines that you have to adhere in 6 months or you have to adhere in 3 months or so. So we have to relax. As Vivek has said that they are not doing anything, I think that's the best policy for now. Till now, the rules are coming in.
Thanks, Bhavna, for advancing such a clear proposal in Think Tank Speak. That's a policy brief right there. And also, I don't think I've heard the phrase Grundnorm and Kelsen being used in a tech policy discussion. So thanks for that segue as well. So I think this is a great chance to move to Venkatesh. And I'd like you to comment on 2 angles. One is, what is the kind of global legal landscape, and how does India's approach, both in this present law and elsewhere, how does that compare? And second, just because Bhavna mentioned consent mechanisms, how relevant do you think the overall idea of privacy is to, and how connected are privacy and cross-border data flows? So I hope the question is clear.
Thanks for MediaNama for hosting this event. So the 2 questions, firstly, thank you for doing a great job of sharing all the questions beforehand. It really helped. The first part to your question, I wanted to share regarding the global landscape for data transfers and where does India come in right now, especially after the passage of the DPDP Act. At BSA, we authored a study called Cross-Border Data Policy Index, where we ranked countries or groupings of countries across the world on how good the data transfer regime is. So let's take 4 categories: A, B, C, D. A is on transfers are unrestricted, and D is most restrictive. So this study just came a few days before the DPDP Act was passed, and India came up in the category C. So it's not extremely restrictive. In extremely restrictive, maybe China would fall in, Russia would fall in. It is somewhere close to C, which is 1 category below that. EU comes in number 2, say B, and say US right now, with the absence of a federal law, comes in category A. So that gives you a broad sense. I'm happy to share that study with those who are interested. That gives you a broad sense, maybe how the different plethora of data transfer policies or data restriction policies get assessed in India and across the world. With the advent of DPDP Act, I don't know how much the rankings will change, purely because there is a lot of rules, subsequent delegated legislations that yet to come. So it's tough to take a decision right away on this. That said, one of the challenges for me when I talk to global companies or companies across the world, whether it's in Germany or Japan or Australia, is unpredictability. I mean, when you look at data transfer policies, what you want is predictability, because it's very challenging to change an architecture based on, say, a particular sectoral law that comes up, or something like in this particular case of the DPDP Act, a power that the government withholds to restrict data transfer to a particular country without any guardrails or without any mention of why that particular restriction would be made applicable. So that's the challenge in the current scenario. The reason I say that is, the first question that emerges is, would the transfer be restricted to a particular country based on privacy violation norms or personal data safeguard? Or would it be based on other considerations, say whether geopolitics or other security considerations. So those are challenges which the industry can't answer. That's unfortunate. But those are challenges that are beyond the scope of most industry players, right? So within the scope of a privacy bill, the focus should be on personal data and privacy, and that has not come out very clearly. But at least one before I get into this, one starting point is the bill's interpretation of data transfer has significantly changed from 2017 or 2018 to now. And that gives us a lot of confidence that the government of the day recognizes the importance of cross-border data transfers. And that's come out repeatedly through multiple, not just the DPDP Act, it also came out through in G20. While there was no specific acknowledgement of cross-border data transfers in the statement, they ratified the G7 statement, which acknowledges DFFT. So the data free flow with trust. So the signals to the industry are positive in the last few years. The government has increasingly reached out to the industry to understand what would require more time. What should we be asked? What is a hurdle for industry to do business? So it's not a carte blanche approval to allow data to be transferred, but that said, the government is more consultative. They are trying to understand where would the industry face challenges. So from that perspective, yes, there's uncertainty. We are not able to say how the delegated legislations would take us forward. But at the same time, the receptivity of the government to acknowledge cross-border data transfers is a welcome first step with the DPDP Act.
Thanks, Venkatesh. And again, always nice to have panelists who have like documents and proposals ready, so we can have a absolutely backed up discussion with substance. So speaking of substance, I think this is a good time to move to Bruno, and maybe a broad question. If he's, I hope he's online and he's there, right? So broad question simply is, any insights on the state of EU-India engagement on cross-border data flows? I think keep it broad, and then maybe we can narrow down later on.
Okay. Can you hear me? Can you tell me? Yes.
Yes, we can.
Good afternoon. Very pleased to be. I'm sorry not to be with you physically, but very happy to connect with you. Thank you very much for this invitation to this prestigious event. I was listening very carefully to the previous intervention, because indeed we are all looking forward to what might happen in terms of further development of the frameworks. Let me say maybe 2 or 3 things on indeed that dialogue between India and the EU on privacy, on data flows, and where it may lead. First, noting that this is a dialogue that has intensified in the past years. There have been a number of milestones, of course, the adoption of the Act, and that has brought certain aspects of convergence between our system. And the fact that this was, the whole process was a very open and inclusive process. As you know, this was made public. The European Commission and the European Union, and I'm happy that we fall in ranking category B. That's my takeaway of the day. Has made us a number of submissions. So let me just recall that there was a joint statement at the leaders' meeting, that's the meeting between the leaders of India and the leaders of the EU in 2021. That has made clear that this is an area of work that the EU and India will work on enhancing convergence between our regulatory framework to ensure a high level of protection and facilitate data flows. India has joined also the EU Indo-Pacific Joint Declaration on Privacy and the Protection of Personal Data in February 2022. That sort of highlights, it's a very important document that highlights a number of principles and that in a quite detailed fashion for such a declaration, both in terms of coverage of scope of data protection laws and overarching data protection laws, role of data protection authorities, transfer mechanism. That's a declaration joined by the EU, but by countries as, for instance, Japan, Korea, Australia, India, and others of the region. So, meaning all of this are signs of our mutual engagement. Let me also recall that the EU and India relaunched negotiations on a free trade agreement, which for us should have a robust digital trade chapter, which should contain also provisions on privacy and data flows, as we have negotiated with several other countries recently, such as the UK in post-Brexit times, Chile or New Zealand, to mention a few recent examples of our FTA. So all of this, I think, is a useful background and a useful context and useful confirmation of how much we could do based on something which is a common value, as very much stressed, first of all, by the Indian Supreme Court. And then we have, of course, also, as we have looked very closely and participated and indeed made submission during the legislative process. We have, of course, very with a lot of interest observed the outcome of the legislative process and the act. And we see that on transfers, for the moment, India has chosen a certain approach, that by, in particular, exempting incoming data that comes from abroad to India, exempting it from most data protection rules contained in the Act, closes certain possibilities in terms of using certain instruments on the EU data protection law to facilitate data flows, may open others. That's why we are very much looking forward to further developments, because I mean, our experience is that to be really adapted to the diversity of the digital economy, the diversity of destination, the diversity of business models, a modern data protection regime should have a broad toolbox in terms of transfer mechanisms. And that's certainly our experience. That's the feedback we're receiving from our companies. I will give you an example. Model contractual clauses, that's the #1 transfer mechanism, which is used by companies, EU companies or foreign companies exporting data from the EU. And what is interesting is that compared to a few years ago, more and more jurisdictions are adopting that instrument, including many in different regions of the world, Latin America, but also the Asia Pacific area. I'm thinking, for instance, what the ASEAN, the Association of Southeastern Asian nations, they have adopted their own set of model clauses, and that's a possibility really of a new possibility that is emerging in terms of bridging different systems and bridging these different clauses to facilitate the life of companies active in multiple jurisdictions within a certain region, but also between different regions. It would be, for instance, a pity if an important actor like India couldn't join that international conversation at the moment when there is an increasing demand for international standards. So that's why we are very much, I gave just that example, and I will probably have been already too long, but that's why we are very much looking forward to further development of the Indian framework. We're also very much looking forward at the role the new data protection board will play. We very much believe in cooperation between regulators. We believe that cooperation has shown in other regions of the world and with other partners that it can bring very concrete outcomes in terms of developing common compliance tools, which which at the same time protect privacy and facilitate data flows.
Thank you very much. I think that covered a broad sweep of issues from global conversations to the business perspective, to, of course, the relevance of privacy to this panel discussion and to cross-border flows. And I think picking off on that, coming back to Bhavna, I wanted to move to the fact that how relevant. So the context is, of course, that the Schrems II decision of the European Court of Justice basically relied on surveillance powers that the US had to essentially restrict flows at that time. So I wanted to ask you about the situation in India. India, of course, has always been a place that is home to global data processing, but also has surveillance laws of its own. So to what extent do you think that, for example, the exemptions that exist in the data protection bill are relevant to either furthering or not cross-border data flows? So, yeah.
Okay. So the exemptions that are provided under the Act to the central government for allowing the government to process the data based upon national security, integrity, sovereignty, and maintaining public order, things of this sort. So the practice of exempting any government of any country is not a new thing. We can see in EU also, in US also, the same practice has been done. And I'm not even mentioning what China does. So what Indian government is doing is not a new thing, though we have a very, I would say, very narrow restrictions, or I would say not restrictions, but narrow powers that are being given to the government, and they're effectively suiting to the requirements of India as well. I'm sorry, I forgot the question. So, okay, the laws that we have presently, right? The practice of surveillance power was there in India since 1885. We have Telegraph Act 1885. Then we have rules also under that. We have IT Act there under Section 69A. Sorry, Section 69. There we provide power to the government to intercept and monitor the data based upon national security. Then we have Unlawful Practices Act. There also we empower the government to provide surveillance for certain areas. Then we have Prevention for Money Laundering Act as well. There also we empower government for the same thing. So I have not seen that these laws have restricted any country to not to choose India as their point of destination. Even in few of these years back, 10 years, I have seen a lot of data centers opening in India, may it be TCS, AWS, Salesforce, then Oracle. There's so many data centers opened in the recent times in Mumbai and Pune and many other states. So we cannot say that these laws have any time restricted the private industry to open their centers or choose India for processing their data as destination, as India as the destination. Coming to another point is that now we have privacy law. It will more strengthen the already existing law, the whole mechanism of surveillance. It will give rights to the citizens now. Before we didn't have the very vocal rights, but now citizens have their rights regarding the surveillances and other things as well.
Thanks a lot, Bhavna. Maybe the same question to you, Venkatesh, but with the additional question of one on whether surveillance laws in India and elsewhere restrict cross-border data flows or meaningfully protect rights, and second, how do you see AI and other emerging technologies changing this landscape, both the economic rights-based and security-based connection between cross-border data flows?
So, I mean, given AI is topical, maybe I'll start there. So what we are seeing currently is governments across the world trying to understand this emerging tech, including Government of India, with their plans to use some framework in DIA to regulate or to at least put a framework around this new emerging tech. So how does AI and cross-border data transfers intersect, and how that will play out with respect to DPDP Act? Definitely, it's quite too soon to say, given how things are changing with generative AI. But one aspect we see is the benefits of AI are only good and to some extent accurate if you can look at data protected through privacy and security for sure at a large scale. If you restrict the amount of data an AI system can take in, it's going to be challenging to get accurate results. So this is something, for example, in the healthcare space, we are seeing, we could see it play out. If you look at a particular data set, say, which is personal data or anonymized personal data, and the genetic base is quite limited to a particular geography or a country or a community, that particular result can only be applied in that area, maybe not even in that area. So like in detection of early onset of blindness, Microsoft has a particular app that looks at data points for cornea or some eye related issues. I'm not able to exactly mention those details of those data points, but they are looking at pan India. Now that's a starting point. Ideally, they would be looking at this also globally. But those are the kind of innovations that AI can bring. I agree that these the frameworks will have to come in to restrict some of these measures around high risk AI, but definitely cross-border data transfers would be critical for getting accurate results and making sure that what is being given to the user is useful to them. So that's point number two, the question number two that you had. On one, so surveillance laws is something that, in every time we engage with the government, this is a thorn that keeps coming up. The question is, it's very tough for the government to access data. Many of you would have already heard it. The government has to go through the MLAT treaties to get access to data. We definitely hear from the government the pain points that they have when it comes to accessing data. Metadata is what they asked, and sometimes they say that even that is tough for them to access. There are difference of opinions across the board, but I fully agree that the government has a lot of challenges in accessing that data. But it is going to be very challenging to look at privacy and the access to data in the same conversation or same light, right? So they are two different objectives, goals completely. So it is very important to separate the discussion and look at them through the lens of maybe surveillance law reforms or IPC, the penal code, etc. And to look at privacy separately, because if you try to merge them, you will there'll be a conflict of interest, and that might not necessarily work in the favor of the user or the citizen.
A great point. I think again a perfect segue to Vivek, because of course there are different sectoral regulations on cross-border data flows. Different sectoral regulators may have different objectives when passing a directive or a law. So how do you see this play out with this new law, and what recommendations do you have for, despite having these different kinds of challenges and objectives that regulators may have, how can this be smoothened out going forward?
Yeah, that's a very nuanced conversation, to be fair, Arindrajit, because the simplistic view is, and from coming from Salesforce, is that we don't like any localization restrictions. We would like everything to be free flowing, and from our perspective, that is the ideal state in terms of cybersecurity, legal restrictions, anything. You build in redundancy into the system, you have a better outcome on all aspects, performance, cybersecurity, whatever, you pick up any parameter. I do not believe that localization is really required, or rather, let me put it this way. Salesforce does not believe that localization is required to achieve any particular cybersecurity objectives. Yes, governments have been localizing sensitive data, defense-related data, intelligence-related data for, I would say, I don't think it's really technology backed. I don't, there are incidents on air-gapped systems as well. There are incidents on distributed systems as well. You cannot really prove one way is better than the other. It all boils down to the implementation at the end of the day. But in principle, in general principles, I think having a better, having a more open system is better. I think one more aspect that we contend with, which is not really talked about, and what I think Bruno sort of brought out in a tangential way, is companies find variances in jurisdictions or variances in regulatory structures also very difficult to manage, right? What may be sensitive in India may not be sensitive in EU, and vice versa. And that's very difficult to manage when you have a global system, when you have customers that span across different countries. And suddenly when you go across one border, the rules completely change on what needs to be done to a particular, different retention times, different retention mechanisms. One set of data needs to be redundant, others can be deleted, So these are technical challenges which cost a lot. You cannot pass down all these costs to the end consumer. And essentially that becomes a burden to everyone. It impedes innovation, it impedes a lot of other things which are desirable in the ecosystem and not necessarily a good outcome for anybody involved. I think one small recommendation that we've been making to not only the state governments and the Indian government here, but globally is that, look, data will eventually flow to places where it is more efficient, more cost effective for it to store. So if India wants localization of data, you need to make it more cost effective and more efficient to store it in country. Right now, it isn't. It's cheaper to store data in the US than in India. You don't have any subsidies really targeting that over here. The moment you start doing that, why wouldn't I as a company or any other company that generates a lot of data, why would you not want to store all your data in India and make it the regional hub or the global hub? I mean, obviously you have 1 billion consumers here, 1.5 billion consumers here. You want the data or you want the content as close to your consumer, right? So it will, I think that's a much more powerful economic incentive. And I think a lot of the data from EU bears that out. As you have more consumption, people will set up more data centers, CDNs, and the data will eventually get localized. And you don't want more than required redundancy. So you will eventually go to that point where you have that copy of whatever you want in country. I think, coming back to the sectoral requirements, I think that is a potential minefield for companies like us. You're absolutely right. I think you said different regulators have different sensitivities, different outcomes, different objectives, and they are looking for different outcomes from regulating that space. Some have investigative powers, some have enforcement powers, some just have advisory powers. And I think all of this plays into how they come up with certain regulations, right? I think it is important to understand that, look, there is a system out here where we are all trying to achieve the same objective. It is not just the regulator, and the world is changing where the regulator by itself cannot manage all good outcomes. You have to work with the industry, you have to work with the general society to ensure that you have a functioning, clean system, right? And unless you come down to that level, you're always going to be in a situation where you're trying to play catch up because there are any number of people out there, and your cyber actors nowadays are not individuals. I mean, the era of people who are working out from their garages or that one laptop from their parents' bedroom or something like that, it's long gone. Now the cyber actors are states, right? And these are people who have unlimited resources. They will find one particular vulnerability and they'll throw everything at it. Ask many of the other companies. I mean, there was a significant attack on the internet that brought down a significant internet company, by a certain significant amount. Now, was that an outcome that was feasible many years ago? No, now it is, right? So I think one needs to be cognizant of the fact, and let's start making regulations in a community rather than in a vacuum, and then be prescriptive about it. I think that's one feature that we need to start bringing to India. I just want to also bring up the concept of AI. I think there's a very important concept that we are not discussing because which does not fit well with this whole concept of data localization. So you have a lot of these, for example, I'm using ChatGPT, but it applies to any LLM, including the LLMs that we have developed, right? You put in some data. Let's say you create a prompt, you put in a prompt to create a video or a movie script or something like that. Now, where does that movie script reside? Right? There is no defined memory space. There is no disk number. There's no byte space or anything like that you can say, okay, here is where the outcome of the output of this AI is residing in this particular. It does not. It's a hive structure. It's pretty much like how memory in your brain gets stored, it's distributed across the entire brain. Likewise, it is distributed across the AI, and it is part of the inference model now to generate future outcomes. How are you going to implement your data localization structures there? Right? The only other option is you stop bringing such products to India or anywhere else which has such strict, because it is an expensive proposition to run individual instances. So not everybody is going to get it. If we are happy with that outcome, I don't think we are as a country. But if we are, then yeah, go ahead with the data localization. Yeah.
Do you want to comment, Venkatesh?
Thanks, Vivek. I just wanted to bring up that sectoral point.
Please, yeah.
Maybe a couple of points on that. Because yes, the DPDP Act allows for data transfers as of now, with powers that may restrict in the future. But already the challenges sectorally are quite a lot, right? So if the big sectors, healthcare and banking, the financial sectors, you have a hodgepodge of regulations which makes a company, both the spaces are very innovative and fast paced. So whenever there is uncertainty, what happens for any company is, how do they architecture a product that takes care of sensitive data and also complies with all the regulations that fit in. So this is going to be a realm of challenge. Let's be very clear that the overarching DPDP Act looks only at privacy, whereas the sectoral regulators' understanding of privacy is going to be extremely different. So if you take the case of RBI, they were concerned about payments data in that restriction. If you take a healthcare provider, they are going to be concerned about personal data maybe, but not just personal data, maybe other kinds of data which they will define through Disha or any of these other legislations or acts that they might look at. So, so it might not be, it'll be important to understand that the various stakeholders in that ecosystem will have differing priorities. And we've seen this happen in different cases. So maybe if you take a CERT-like situation where the government wanted to localize logs or some other issue. So, and without straying away from DPDP Act, which is the focus of our conversation, it is to say that it is very important that privacy is the focus of this act, and it is when it talks to other regulators, when this act talks to other regulations, as far as privacy is concerned, this act takes precedence. The bill in the two sections that there are, right? So there are two sections around 38, which gives conflict, which resolves conflict, and also this section 17 itself, which resolves. So they provide both ways. So you can, if there are higher restrictions already applicable in any other law, that will prevail. And 38 says in case of conflict, this will. So it is not entirely clear how this would pan out. I'm sure the rules might address them, but I just wanted to flag that this is for privacy. The other regulators are not mandated to take care of privacy.
A really important point. And I think I just wanted to see if maybe we can bring Bruno back in and ask him for a perspective on, of course, Europe has been developing this space for quite some time, and how these challenges such as sectoral regulators and so on have framed the European digital policy landscape. If Bruno wanted to comment on that, I just wanted to see if we can bring him back into the conversation.
Yes, maybe I will try to react to some of the things my co-panelists have been discussing. First, data localization. I totally agree with what has been said. Data localization has never been part of the DNA of EU data protection laws. We have I'm not saying that it's always easy, but we have always believed that we can both protect data and be open to flows. And we are reconfirming that with a very strong commitment in our approach to digital trade chapters in our FTA, which this approach tries to sort of mark that dividing line between, on the one hand, genuine data protection laws, where the regulatory autonomy of each party should be respected. India should be free to fix the level of protection at the level it believes appropriate, such as the EU or any other part, on the one hand. But also, and I think it needs to be stressed because it's often underestimated, we are, at this stage, the only one who are including in their modern trade agreement straightforward prohibition of localization measures. And therefore, this, as I said, drawing the dividing line between genuine data protection and unjustified obstacles to digital trade. This is for us very important. It is, as I said, not always an easy exercise, but I think again that's an area, and I think, for instance, also of e-commerce negotiations that are taking place as we speak in Geneva in the framework of the WTO. This is a very important, another very important international conversation, and an area where there is a clear need for international standards, and again, an area where we are certainly looking forward to deepening our partnership with our international partners and our dialogue with our international partners. Second thing about data transfer mechanism, and I agree, we need a broad tool because needs are different. We need a broad toolbox, sorry, because needs are different. And some of these toolbox, I understand, I fully understand that, and I agree, some of these tools can be based on that bottom-up approach that was mentioned, where there is cooperation with, of course, stakeholders. There should be cooperation with stakeholders on any of the tools, but some are particularly, some of the elements of that toolbox that exists in Europe and that exists in many systems are, I would say, particularly well adapted to that form of dialogue with stakeholders. I'm thinking about certification, I'm thinking about codes of conduct, which are really the product of that type of dialogue and cooperation with stakeholders across many sectors. What is also important is that, and that's another important balance, that those tools provide legal certainty when you rely on them to transfer data. And that's where the role of data protection authorities, privacy authorities, such as we hope the new data protection board in India, that's where the role can be crucial in working with stakeholders to develop tools that meet the requirements of the applicable legislation, and giving where data protection board, where data protection authorities have a possibility to give their approval and pre-approval, so that those tools are standardized and can be used off the shelf. That's true for model tools, but that could be true also for other mechanisms. So that dialogue, when creating a new data protection authority, is very important, including in the area of data transfers.
Many thanks, Bruno. I have a few more questions for the panelists, but I think because we have about 20 minutes left, I wanted to see if the audience had any questions so we could get that interaction. Then if not, I have a few more in my bank as well. So open it up to the floor and see if anyone has any questions or contributions for the panelists. So over to you.
If you have any questions, feel free to raise them. Otherwise, we can go back to the panel. I think we can go back if anyone has there. Yeah.
I have a bunch of questions, so this is great for me. I actually wanted to move now to maybe next steps on where we see this going in the future. I think one question that is pretty important, but maybe I haven't seen as much conversation on it, is basically the idea of grievance redressal. And I wanted to move back to Bhavna on that actually, is that given the existing legal provisions, how would grievance redressal work, and both from the perspective of businesses and consumers, when you have the various challenges of even the present landscape that have already been outlined both in India, and of course we heard a perspective from the EU as well. How do you see grievance redressal working out? And again, do you have any proposals for how the grievance redressal can be made easier and less painful for businesses and consumers?
So the Act provides right to grievance redressal to the citizens. And it has clearly mentioned that one of the major agenda is always to cater to the problems and complaints of the users and the digital Nagrik that we have in our India. So, and also there are due diligence requirements on part of data fiduciaries and significant data fiduciaries to have data protection officers appointed. Also have a complete set the grievance redressal mechanism in place where the consumer or the businesses can approach when there in case where there is any breach or is there any violation of the law itself. Also, for this also, I would say that we have to wait for the rules to come in. Supposingly, same we have for, I mean, under the IT Act, we have the IT rules where we have set up all the mechanism regarding grievances, the timelines, how it should be followed, and what all things should be there. Similarly, under the data privacy law as well, there will be a separate rules based upon which we will have a proper timelines, the complaint, the grounds of complaints on which a consumer can make a complaint and reach out to the particular data fiduciary. So this is a very good stand that already been taken, and we have a very good example already existing. We have a mandatory requirements on the intermediaries that they have to have a grievance redressal mechanism. Also, we have GAC portal now where they can be appeal made, and the consumers are always open to go to courts. Similarly, I feel that this similar mechanism may be taken in case of data privacy law as well.
Thanks again for a useful proposal. I think now maybe moving away from the next steps a little bit. I wanted to go to Vivek and actually ask for some insights on how at present, of course, as you said earlier, companies are constantly navigating the evolving legal landscape. But at present, how do companies actually store data and how are they actually segregated? Because in Bhavna's initial proposal, there was this, one of the principles was kind of categorization and so on. So in terms of present company practices, how do they line up with navigating the future in terms of both the uncertainty and if the blacklist is, say, is not a kind of absolute blacklist, but blacklisted based on categorization? What is the current state of play, and how do you think that prepares companies well or not for the legal regime going forward?
Again, you know, this is a question that varies from company to company depending on their risk appetite. I think if you're a company or an Indian company with a low risk appetite, and typically this would be companies closer to the government or in the public sector or storing seemingly sensitive data, they are already looking to move their data in country in anticipation of certain localization requirements. I think, you know, but there are companies who have all sorts of quote unquote sensitive data, and I'm using the word sensitive in a very loose way, nothing to do with the 2019 definition. We have mechanisms which, and at least I'm sure other companies do as well, but the way we handle it is we provide mechanisms to the companies to decide which law applies on which piece of data at the field level. So for example, if there is a piece of data which is resident on a particular server, you can decide that, let's say, CCPA or GDPR or the DPDP applies on it, depending on, you know, where the data is and how it is being accessed. And you know, the companies can choose to apply that mechanism on top of that data. And it has different implications on, you know, how the data is being accessed, how the data is being, let's say, used in analytics, how the data is being used in AI. And you have different control mechanisms for that. But in general, I think companies are looking to minimize risk. Some of the larger implementations may see a little bit of lag depending on how the law is panning out. And I think now that the act has come, I think we're seeing a little more movement. But in general, lower the risk appetite, you try to localize in the Indian context. Higher the risk appetite, you sort of try and play within the gaps. Yeah. And obviously the AI thing that I mentioned, that, you know, we still don't know where it is. But if you're really, you know, looking to exploit the LLMs, you would wait as a company to see if you have a local instance in place, which may or may not be cost prohibitive.
So understood correctly, even the categorization itself is based on kind of figuring out what the legal movement would look like and kind of tagging certain tracks of data to certain specific law. No, that makes a lot of sense and useful perspective. A final question, maybe the audience has had some time to figure out a few more questions for the panelists, but to Venkatesh, I think a broad question, but from the private sector or even from a rights perspective, how would you advise a policymaker, one, in India, two, in EU, and three, maybe in the US, on cross-border data flows? The reason I kind of asked from 3 jurisdictions is because I think all these 3 jurisdictions are relevant for the future of cross-border flows, and there needs to be, as Bruno identified as well, I think a need to figure out mechanisms in which we can cooperate both on domestic lawmaking and also on global governance arrangements. So yeah, broad question, but your takes.
Yeah, I mean, advising policymakers from 3 jurisdictions. Like, let's start with some ground points. Like you talked about 3 jurisdictions, US, EU, and India. In terms of the tech presence in these 3 jurisdictions and the outlook towards the tech sector, there's a lot of differences, right? So I'd start by saying, that those differences are unique to those country groupings, if it's EU, and then if it's US or India. So I'll start with acknowledging that, the requirements are different. But that said, the way people interact with technology today across these countries, if you look at a platform, is increasingly becoming somewhat similar. I mean, I'll rephrase how I said that. Somewhat similar in the sense that if you're looking at say how Twitter is used in a particular city A, it would be something similar to how it's going to be used in a city B. There will be differences, no doubt, but the issues of misinformation and those which are stemming out of it are being faced in this city today as well as the city elsewhere at the same time. So it's happening instantaneously. So with that in mind, regulators are realizing increasingly that you have to look at policy and technology together internationally, and it is very tough to look at it from a piecemeal perspective, and this is seen in time again and again. So with all this context, I would say promotion of cross-border data transfers becomes critical, and this interplay with privacy, Bruno was referring to it, how governments solve it would be a big challenge. So for that, what we recommend, of course, is there are many mechanisms, the EU ways, SECs, BCRs, and other adequate level of protection to what's already in EU, or there are APEX CBPR kind of certification mechanisms as well. So those are suggestions that we give to governments across the world to adopt. So promote cross-border data transfers through legislations. Leverage these mechanisms wherever is there. I've seen governments hesitant to look at certification mechanisms, but those are worth considering. That's a suggestion that I would give. And number 3, if governments are looking at restricting data transfers for whatever particular reason, let that, as Bhavna had pointed out earlier in our intervention, let that be based on clear path or guideways without uncertainty. And they should not go away from the basic premise of ensuring citizen privacy. I mean, that is the focus of our discussion. So those were the 3 things I would say.
Perfect. I just wanted to check if the audience had any questions for the panelists, any of the panelists here or for Bruno.
Maybe I can say something on what has just been.
Please. Yeah, please.
No, when you work on data flows, you have to be optimistic. And I think actually that compared to where we were a few years ago, there are more opportunities because there's a convergence not only on rules, but also on awareness and business practices. I think we have different models. There's no one size fits all models, but I think there is increasing understanding that we need common rules of the game on responsible use of that. And that opens ways to develop those bridges I was mentioning, for instance, between different sets of model clauses, but there are other examples. And that's why I think it would be a missed opportunity if India couldn't join that conversation and that form of cooperation. I also very much believe that, again, having a regulator, having a strong regulator with the necessary expertise is very useful also in that context, because regulators can concentrate on what really matters, which is equipping stakeholders, businesses with compliance tools, which is what matters at the end. Is that you need to transfer data as part of your business operation, and you can rely on something that gives you the legal certainty and that of compliance with your system, while being sufficiently interoperable, convergent. You can use all sorts of words with other systems, and that's where the debate is now here. And the good thing is that I think with many organizations in the world, we have gone beyond just the sort of wishing that, and we are working on concrete solutions. And we are seeing that in this debate, in this conversation, it's becoming a more diverse conversation, a richer conversation with also new actors. I was mentioning international organizations, regional organizations such as ASEAN, who a few years ago would not have been present in it. Just another example, would not have been present. And that allows, I think, an interesting network effect to have a critical mass of countries, a critical mass of jurisdiction working on facilitating data flows, not only within their region, but also between that region and other regions of the world.
Thanks for that perspective. We still have a little bit of time, so any couple of questions at least, if anyone had. Otherwise, yeah, please.
So would the panel like to throw some light on data flows coming into India, like issues concerning adequacy or BPO industry, where we are net importers of data? So far, the conversation has been about data from India going out. Would you like to throw some light on data coming in?
Anyone specifically?
Chandra, no, nothing specific from our perspective. I mean, we are a data processor in the eyes of the law. We enable any implementation of any regulatory mechanism on any piece of data. So if you're bringing in data from the EU, which is not pertaining to any Indian citizens, then we would enable the implementation of the GDPR law in India. That's built into the system. So we don't really hold any view as such. I don't think we have one view one way or the other on whether the Indian law should include that or not. At the moment, we are built to support both ways. Yeah.
I think another point related to data coming in, not flows, but the idea of data access was already brought up, where accessing data by law enforcement agencies remains a challenge because of a cumbersome MLAT process, and India is not part of several of the Cloud Act, for example. So if anyone wants to shed more light on that, so there's one is the flow, which is a continuous sharing of data, but the other concept is access, which is that a case-by-case sharing based on a particular legal request, and that remains a challenge. I think someone mentioned the MLAT process as well. I think it was Venkatesh. So you want to shed more light on that and how that can be resolved?
Yeah, so as I said, I try not to bring this conversation during a privacy legislation piece, purely because of how it gets interpreted. But I'll answer your question, right? Right now, the Cloud Act was a mechanism whereby the US government is trying to sort of have a committee of laws, solve a committee of laws situation when it comes to, okay, how do I access a particular data? And that comes from an important case ruling in Ireland and the US and Microsoft. So I think that particular situation in India is going to still be a challenge because of various reasons, but India is not going to come up on that list where this agreement can be where India can participate in this agreement. Budapest there's a history behind it, so I won't go into that. So before that, so that remains still a challenge where data transfer access is a challenge for law enforcement, and this comes up quite often. So data coming into India. So one way to look at it, I'm paraphrasing, so it's not necessarily my direct opinion on this matter, was when this question was asked to the Minister of State in some meeting, the thing was that industry who was concerned about this didn't bring it up. So, that at least that was the perspective that was given. And in the run up to the privacy legislation itself, this was seen as, we need to also not restrict that, because that would hurt the Indian industry, specifically around processing, etc. So maybe it could be done with respect to that. But yeah, with respect to the first question that you asked, which is around access to data, that's still going to be a challenge for Indian government to access data from elsewhere. That's going to be a challenge for other governments to access data. Right now, with the current legislation, it's not. There is no sort of clear picture on it. Hopefully, the other countries' law protects their citizens' data.
Perfect. Please, yeah.
So this has been a constant point of feedback from our side to a lot of the congressional staff delegations that keep coming here, that, a lot of the regulation, and not just India, but around the world, is being built because there is this general air of mistrust around how the Cloud Act is going to be used, right? And therefore you see, no, you need to store logs here. Therefore, no, you need to have payment transactions here. And of course, there are other factors around that as well. But this general sense that, okay, I don't know how it's going to be implemented, and if it's going to be implemented against me, where am I going to stand on this, right? So I think if, there is an initiative to sort of, I don't know how it's going to be done, if there's a, using the same word again right now, which is trusted geographies and trusted entities, etc. If you're going to have that kind of a mechanism, or if you're going to rework in such a way that it is not something that gives blanket access to the US government or one entity to do anything that they want, there could be a conversation that could be had, right? Or if you're going to rework the MLATs mechanism in such a way that there is parity, right? There is real parity, then yeah, maybe there could be a conversation that could be had. But since there isn't, all of this is, in my opinion, and my view, and a lot of other people's view, a workaround.
Fair point. I think maybe last word, we're at 3:30, so we are doing well for time. Last word from Bhavna on any of the issues following which we'll close.
So one issue that I myself is stuck with, I would like to have an answer from the other panelists, because even I was thinking of one thing is that India is too much favoring the global south, right? So, but in global south, we have a lot of countries that doesn't have a privacy law. So there is a higher probability that if we are talking about a blacklisting, there will be a lot of countries that are under global south, and India is too much favoring global south and promoting them. And one of the aspects to promote them will be cross-border data transfers. So I'm looking forward to it, how India will be managing this aspect. And because they have to strike a balance between innovation, growth, and of course, protection of the data flows. So please.
I'm not sure we have time for a very quick answer, but I will say that I think that's the thrill or challenge of foreign policy, where you have to compete on multiple equities. And I think it's balancing the kind of common threads with the global south, with the desire to protect citizens and further security, and that's the exciting thing about foreign policy. Let me close there, and if you could all join me in a huge round of applause for the panelists. Oh, Bruno, please come in here.
There's one question for Bruno from the audience.
But I just want to say that indeed, this form of cooperation, and we are negotiating what we call the e-evidence agreement with the US, at the cloud agreement. We have joined the Budapest Convention and the additional protocol to the Budapest Convention, where you find countries from the global south and the global north, if I may say. It's a really universal instrument. Is the answer to data localization, because it shows that through international cooperation, we can meet the requirements and the legitimate requirements of law enforcement agencies, security agencies, without the need to necessarily localize data. So those are instruments that exist, that are open, and that have been already joined by many countries around the world. They are not only transatlantic instruments or instruments limited to Europe or other countries that are typically seen as a part of our family, I would say. So with that, I thank you. I have to leave because I'm already late for another meeting, but it was a real pleasure to join this event. Thank you very much.
Thank you. I think, Bruno, we have one more question for you, but I think you may have dropped off. Okay. In that case, if you could all join me in a round of applause for all the panelists, please. Thank you.
He dropped off. We're just going to take a quick 10-minute break for tea for everyone who wants to have some. We'll come back for the last couple of sessions post that. Thanks. Thank you all for a great panel.
So then you offer your I was surprised as you were
Hi, everyone. We'll be starting in 2 minutes. So if you can take your seats slowly. We'll be starting in 2 minutes. Hi, everyone. We'll be starting the next panel now on the obligations for data fiduciaries and what's next. I'd request everyone at the back, if you could please take your seats so that we can start the next panel on time. All right, everyone. So over the past 2 days, we've been looking at the various obligations that data fiduciaries have under the DPDP Act. Those range from the various provisions on notice, consent, and grounds for processing. And this morning, we also looked at concerns over user rights and how data fiduciaries are necessarily supposed to respect them. But outside of this gamut of sections on processing and legitimate uses, there also exist many other obligations that data fiduciaries have, whether it comes to data breach reporting or many other such issues. So this last panel on this issue today will essentially cover what those responsibilities are and what the right path forward might be for various companies operating in the country. I'd like to call the panelists and the moderators to the stage. Today we have Varun Sen Bal from NASSCOM speaking with us. We also have Neha Chaudhary from Ikigai Law, Tamogna Goswami from ShareChat, Pragya Maharishi from Truecaller, and moderating today's discussion, we have Prasanto Ray from FTI Consulting. So look forward to hearing from you, and thank you.
Okay, so thanks very much, and great to be with a lot of friends on the panel, discussing something which I guess we have at various points since, I don't know, Puttaswamy versus Union of India till now, and the first, Justice Sri Krishna committee, and now, except that, a lot of those discussions were very academic, like what is a data fiduciary, are you a data fiduciary, etc. And suddenly they're very real. But we're still having those arguments, right? I mean, yesterday we had this whole discussion on the payments chain, which is interesting. It's complex, and it starts with the first guy, the merchant, who is seemingly collecting data, but he's not a fiduciary. Then you've got the issuer, the acquirer bank. Then there's the PAPG. There is a network. Now, some networks have spoken to say, hey, we are not a fiduciary, we are a processor. So don't ask us about obligations of fiduciaries. We don't have any. Okay, but yesterday we heard, from a payment gateway, from PayU, that no, we believe we are a fiduciary. And I kind of tend to agree with that. So I'd just like to, put this question along with, so the question is, do you see this as a significant challenge? People still trying to figure out if they are, especially when, they are little further down the chain, they are involved in processing data, but they are clearly involved in determining the purpose and means of processing that data, which is the definition of fiduciary. But I think the primary thing I'd like to start off with is the question, what do you see as the first and the biggest challenge now as data fiduciaries have to figure out what their obligations are? So Neha, would you like to start from your side? No particular order.
Thanks, Prashanto, and thanks, MediaNama, for having us here. I think it's actually exactly what you said, right? The fundamental question, I think, from a compliance perspective is determining really whether or not you are a fiduciary or you're a processor. It's a complicated one for a couple of reasons, not just because of the impact that it has, where the whole host of obligations to ensure compliance with the law is with the fiduciary and not really with the processor, but also a complicated one because this determination is not an absolute one that you make. It's processing activity specific. And obviously it's data and processing activity specific, right? So the same organization for a particular purpose could be a data fiduciary, for a completely different purpose could be a data processor, and figuring out at what point do you wear, which hat is it that you're wearing? And then therefore, what is the scope of obligations that's going to attract you, I think for us is really the fundamental question. Because if you are a processor, you want to ring fence as much as possible the fact that you are a processor and not, trip into being a fiduciary where you're then subject to everything that the law is telling you.
Yeah, I mean, I think it's one that you need to do a lot of internal assessment on. And also I feel that if you are in a way, if you feel you're in a violation of it, how do you really determine that? And how do you really decide which bucket you fall into? Because I think there's no clarity yet around how will this get operationalized. And so I think a lot of the questions have been mostly around that. I think for us at Truecaller, we've been spending a lot of time obviously doing internal assessments on where we are. Also just looking at our processes, both what we have with our users, but also more broadly with what we have with our vendors and partners, and what does that data processing look like, and where are really the obligations for us. And so I think I feel like there's going to be a lot of for some time, a lot of ambiguity, and everyone's going to be pointing at the other person or the other industry saying they are the ones and we are not. And I think somewhere there you need a lot of clarification so that this gray area in some ways puts everyone at ease on which category they're in, and then they can really start focusing on complying as opposed to just figuring out what category you're in.
Okay, I'm going to just park an extension of this question, because a lot of the discussions we are seeing, they're not even about wearing different hats. Okay, it's very straightforward. I mean, in the payment context, for example, you are, you've got an acquiring bank or an issuing bank. There's a certain set of data they have, which includes identity, PII, etc. Then there is a network or a processor. Well, and I won't use word processor here because that has a specific context, but there's a network, and the network is clearly determining why certain, and there is very intense, very deep data analytics out there. There is AI, ML, there is fraud, there's a fraud score. So they have to decide what data is to be collected, why it is to be collected, how it is to be processed, where it is to be processed. Data localization norms are to be adhered with. Okay, in this one simple context, we are seeing so much of confusion, or maybe that confusion is partly because, you'd like to think that, hey, we are not a fiduciary, we are a processor. Maybe it's coming to that. So I want to just park that question, but I want to just, extend the same question to you. What do you see as the top challenge ahead when now that compliance has actually become the reality ahead and not a debate about what it should be?
I think that's a great question to start with, especially for this panel. The biggest challenge, what we will see, is how do we humanize this law? Because when you want to build compliant systems for this particular law, you have to humanize it to an engineer, to a product manager, to a user. Because till date, I mean, this is an exceptional piece of legislation which has come in. But till date, this right was something which was known in certain other circles for certain other purposes under certain other laws. What does it mean for us where a user is giving consent for a certain set of data and it has to be used for a certain purpose? What does it mean for the user? So there is a big task not only for fiduciaries to figure out how to make these obligations come alive, but you will also have to, I think civil society and the government also has a huge task here to make this law a real law, because this is something everyone has been demanding, everyone has had an eye for. Now, how do you make this law real for a user? What does it mean for a person sitting in a tier 3 city who is accessing internet for the first time? So that's where a system building will be, I think, necessary, and it will be also figured out according to that. A general observation is also that, like I think I heard previous panels, we are looking towards West for interpretation of an Indian law. I think the Indian judiciary has its own certain sets of interpretive laws, and we all already have certain jurisprudence in place in terms of how a word even has to be interpreted. So I think how this law is to be read will have to be looked in from that angle. I think the third thing, which everyone in the panel also knows very well, figure out where the data is coming from. Do I require consent for it? Is it personal data? Is it sensitive data? Is it critical data? Figuring out all of that and creating systems which have like a user interface basis and background systems as well. Those things will take time. I think it's a learning process for everyone who is creating implementation systems for the Indian law. I think eventually there'll be a bit of clarity when the rules come in and when the implementation cycles are finished, when there are certain clarificatory notifications also which are brought in, then I think we will be in a place to say, okay, obligations have been met with.
Okay, great. Interesting. You started with saying it's an exceptional law. I'd ask you further, maybe offline, what all you mean by exceptional, including the fact that most of it has been left to rules ahead. So maybe it's exceptional from that point of view. Varun, what are your thoughts on this? And also, I think we were talking about guidance earlier. Is this a starting area on the clarifications, guidance, FAQs, etc.? Like who's a fiduciary? What are the? Obviously, it's a very complex. I mean, there's so many examples of places where the second order or downstream processor has a fiduciary responsibility. But clearly, it's going to be a huge area of confusion, no? And especially if there's a starting assumption that I'm not a fiduciary, and so therefore I'm not going to put in place anything. So that's going to be a real starting stumbling block for compliance.
Yeah, so thanks, Prashanto. And just so we were talking about this earlier, but we've been at NASSCOM, we've been basically discussing with several industry players across multiple segments about what they now think about the fact that they have to implement the law, right? And one big common theme that's come out is that there is no privacy advocate kind of role contemplated for either of the authorities under the Act. So the Data Protection Board doesn't have any formal function of issuing advisory or guidance. And then it seems like that isn't also specifically something assigned to the central government either, right? So this becomes a challenge because of multiple reasons. And I think your question about just the controller processor relationship is one example of why this is a challenge, right? So I think everybody's been talking about who's a fiduciary, who's a processor, but the definition of a fiduciary also says that you can be a fiduciary with other fiduciaries. So you can like jointly determine purpose and means with more than one entity, right? So that idea of joint controllership, joint fiduciaryship is something that is being evolved and detailed out by the European Data Protection Board through guidance, right? And this is where, Tamogan, I will vary a little bit from you in the sense of like, yeah, it makes sense obviously for us to defer to our courts finally for the interpretation of our law. but the terms and the concepts that we've taken from other laws and literally imported directly should benefit from that wealth of knowledge that's abroad, right? So controller and processor is something that is just generally well understood in the European context and has equivalent meanings under other laws. You have the Singaporean law where also like it's not the same term, but the idea of an organization is similar to that of a controller, right? So when we think about what guidance can do here, guidance can make that definition of data fiduciary and the idea of joint fiduciaryship anchored in real world examples. It can also give clarity on how the central government, which will be the one making references to the board with complaints, is interpreting the law itself, which has a function in the market of setting a baseline for compliance that then everybody can look towards. I think the problem that we foresee, rather we want to avoid, is a scenario where the act is only interpreted in an enforcement action. So somebody has to burn their fingers for everybody else to figure out how not to burn their fingers. And that seems to be an inefficient, costly way of arriving at clarity that can be brought about through just having good guidance out there that's developed in a consultative manner and that has some level of authority and some level of certainty for people to rely on. And this is not just for fiduciaries, it's also for processors and for data principles as well. I just want to conclude this point with the example that we have from Turkey, right? So this is not a hypothetical example. In 2016, Turkey updated its data protection laws to try and start complying with the Data Protection Directive, the predecessor of the GDPR. And what Turkey ended up doing was that they were trying to import principles from a fairly long law into 33 articles in their law. And so they ended up with a very short law themselves. And the original couple of years, their data protection authority spent a lot of time focusing on enforcement and didn't actually think about creating guidelines and guidance. So because of state capacity, obviously, there's only so much enforcement they could do. And the rest of industry was left in confusion, wondering about what particular term means. The excellent example of this is technical and organizational measures, which is there in our law, which under the GDPR has been interpreted to give you a basis for, confidently introducing security controls, using ISO standards, doing pseudonymization. That all comes from as part of your technical and organizational measures. In Turkey, the confidence only came to industry in 2018 when first guidelines came out on technical and organizational measures. So according to me, the starting point, the first challenge that we need to be thinking about is that how do we build reasonable guidance that people can do, and how do we have a privacy advocate role be developed in our enforcement structure. So yeah.
Okay, great point. And I think if we can maybe take up as an extension of this question, the V and the building of the guidance. Now, for example, this joint fiduciary thing you mentioned, it's fairly obvious, right? I mean, this payments example and many other examples, when you have downstream data being handed from one to the other, there are specific sectoral regulatory responsibilities which are there, for example, here in the payment sector, which each person, I mean, and that is not in the context of the DPDP Act, that's in the context of RBI Act and various other acts. So they have to, for instance, be responsible for a certain part of that process, the anti-money laundering part, etc. So clearly there are 3 or 4 entities which are jointly determining the purpose and means of processing that user data. So there's no question about it. There are multiple fiduciaries in the chain, and there's a joint fiduciary structure here. In this sort of an example, I mean, when you say that the V, and I'll put this to everybody, I think the suggestion here is that guidance is required on this. Now, in the financial regulation space, we see a lot of stuff coming up subsequently through FAQs that the RBI issues, which is another set of pains in itself, because your primary rule is so vast and it doesn't have clarity. But in this case, what can the industry do maybe to fast forward this, and maybe NASSCOM and others? Will it help to actually build up these cases and give these examples, and for these examples actually put out sort of preliminary guidance, as it were, from our side, from the industry side, saying that, yes, we believe in this case, these are fiduciaries and there'll be fiduciary responsibility. And maybe that can be internally challenged or whatever. Is there a way to fast forward this? Because we don't see the fast forwarding happening on the lawmaking, on the policy making side. Anybody? Neha, you want to start? Varun?
So yeah, Prashant, I couldn't agree more. Absolutely. And I think Singapore is another great example of a jurisdiction that actually does this really well, including just the way it's presented, even on the Privacy Commissioner's website, right? There's the guidance that you're expecting from the government, it doesn't have to be government-led, government-driven. And I think one of the things that they do really well is also tell you where it is that so they've got separate categorizations of industry-led guidances, government consultation papers, how the law has evolved as a result of directions that the Privacy Commissioner's Office has come up with. Codes of practice are treated differently. So it's not going to be one single thing, that gives us any kind of clarity in the next 4 or 5 years, right? It's going to evolve by the time we set up a board. Because even in the way that our sort of act is structured, you've got at least 3 different sort of 2 different government stakeholders, and then the individuals, and then the companies, etc. Right? So you've got the central government playing a distinct role, and you've got the data protection board playing a distinct role in different kinds of guidance. Even there, once the law comes into effect, we can expect different kinds of guidance coming in from different people. Rules will be framed by the central government, but if you have to rely on sort of interpretation that we were talking about earlier, that kind of guidance you're going to get from the DPB. So I actually don't think it hurts us in any way to get a little bit ahead of that and say, why don't we attempt to make sense of the words that we're talking about? Just to pick up from where Varun left off, what would we like to see when we say technical and organizational measures? Do we want something in the rules that says, if I implement, this ISO standard, I get a check that says, yes, you have implemented satisfactory technical and technical measures, these 5 things if you do organizational measures? So yeah, I actually don't think that that's a bad thing at all.
Yeah, great point. Great example to Singapore, also Australia. And Australia, in fact, relies on this, industry drafted legislation in a big way. And in this sort of an example, the rules would probably be left to the industry to come forward, draft, propose, and then be accepted by the government. Varun?
Yeah, so I just also wanted to point out that we already have initiatives in the country that do perform this function, right? After the SPDI rules came out, Data Security Council of India was set up. That essentially was responsible for helping with DPO certification, with creating, an ecosystem around privacy in the country, right? So that's just one prominent example that I as NASCOM can point out. But I think that the key point that I want to take away from Neha's comment is that you will require guidance on multiple subjects, and guidance should come out from multiple different sources as long as stakeholders agree that that particular guidance is reliable. So for example, maybe on technical and organizational measures, it makes sense for the existing industry associations and industry initiatives to take the lead. But on things like, for example, what should be the way in which, you implement security safeguards, maybe you also want to then look at the cybersecurity community that have experience with that as well. So, or if you want to think about what can apply, for example, there's a requirement underneath the act around, ensuring that you, if you're a government entity, you can rely on subsidies and benefits, and those subsidies and benefits will be defined in rules. So maybe supporting guidance can come out on how exactly that ground would work. So that may make more sense from your e-governance stakeholders in the country as well, right? So as long as guidance is authoritative, it should have buy-in from everybody. That should be sufficient, but the need for guidance is fairly clear.
Okay, great. So Pragya Tamogna, if I can, make this a little more specific in your context, what 1 or 2 areas would you actually like to see such guidance, whether it's something that is industry association led, whatever? What are the 1 or 2 areas that require immediate clarification for you for compliance?
Yeah, no, I think we're not looking for any immediate clarification, so to say, but I think just to add to what Neha and Varun had said, I think the Act itself has a few examples and use cases where they've tried to showcase this is what we really mean, and this is the use case in terms of how we see this getting operationalized. But I think a lot more of that is required so that to Varun's point, where you only don't get to know what the government really means by it when it's under litigation. And we've seen that in the past where some private companies have taken, the government to court on those things. And then everyone's woken up and said, oh, really, is that how you meant to write it? And that's how it's really needs to be interpreted. And so I think we shouldn't wait for that. And hopefully, if we can create at least for the majority use cases, the large use cases which are already existing, and I think Truecaller falls under that, with 250 million users in India. And what does that really look like from a caller identification point of view? Because I think a lot has been said, in the social media world and the messaging, and also now fintech. But really, what does that look like for a platform which is not pushing content for virality, but simply for making digital communication safer, because it's giving you some context on who's trying to call you, and also playing a very important role in prevention of fraud and spam in its own way, and also impersonation and various other factors that we are really dealing with, from loss of money from that point of view. And I think the third thing is, I always find that, if we can also come together and, like, Varun and Neha was saying, but really provide solutions as well. I think we're very good at saying this is not great. But then what next? If that's not great, if the current act is not, we don't understand it well, or it's not been executed well, what are the ideas that we have for the government to make it better? Because I think more often than not, when I've had these conversations with them, they're fairly open. But I think, at least even in my case, so many times, I also don't have a better answer. And I go back and I'll be like, I'll think about it and I'll get back. And I never get back either. So I think if we can just maybe get together and maybe also think about this more constructively, I think it'll help all around.
Okay, that's a thought. Although I must say they've been very open over the last 5 or 6 years, but so many of the suggestions have not found its way into the next draft and the next draft, right?
I agree with that. I'm not saying everything, will show up, but I'm saying at least lately, I find there is an openness to at least have a conversation and engage, which I think is a good step.
Sure.
Just to add on to what everyone has expressed, I guess best practices can be something which can be brought about. It may not be in the form of a rule notification or an FAQ, but a government entity always puts up on their websites, okay, hey, these are the best practices that you can follow. Because as we were talking about the rulemaking process and everything else, the sections in the law are providing certain rights. How these rights are to be applied, the compliance may look very different for Pragya, the compliance may look very different for me, and the compliance may look for NASSCOM's different members as well. But each one of them can be shown, hey, this is the best practice that you can follow. What Neha said, ISO 27001, that is provided in the SPDI rules, which is kind of a best practice, but it's prescribed in the rules, rather because the technology is going to develop, because there will be changes in, let's say, security standards, security aspects, put it as a best practice. And then from there on, industry can also confer with the government, industry can have conversations and mutually develop these solutions. Because as I think we are all agreeing that this is a humongous task at hand. Also just wanted to let Varun know in terms of interpretations, English law has 5 types of mortgages. India has not applied any one of them, even though contract law does follow English law. So just there will be interpretations which will be very specific to the Indian Act, even though there are words that we are taking. There are sentiments that we are taking from other jurisdictions, but the law in India is very specific to A, who the user is, B, what the words say. So those things will have to be kept in mind while devising compliance structures. So that's where I was coming from.
I think the another point that I'd like to add also is, I think, the compliance cost of this is eventually going to be so high that it should not, whatever we're complying to, at least in India, and specifically for Indian companies as well, should not act as a handicap when you want to now start making your business global. I think a lot of us, like for us, we're already following EU GDPR and there's a baseline. So, we're of course doing analysis on what more we need to do if we need to comply with the DPDP, which of course we have full intentions of. But, what does that look like really on the ground and what more we need to do? But if I was to just flip that and say, for Indian companies who are now looking to enter in newer markets, just what they're complying to here should not act as a handicap for them.
Will you have a point?
I have a couple of questions.
Sure, go ahead.
I know, Pragya, those questions are based on what you just said. So I'm just curious about whether there are things that you're not allowed to do under the GDPR that as a company you can do here after the DPDP bill, if it gets operationalized, whatever the rules might be. Secondly, there used to be something that we used to call the true caller problem about 4 or 5 years ago, when the discussion around privacy, around the privacy bill started, which is that there is data that is been taken without the consent of the person whose data it is, right? Because someone else's phone book, they are uploading to Truecaller, and then it's a useful service. How do you intend to deal with the consent problem there? Because let's say, I know you have a situation, you have a page where someone can delist, and that option has been there for a very long time. But could it also be a legal problem for you if someone were to challenge you on how you've collected the data without consent?
And I just wanted to add to that. And the first thing he was asking is also the question I had, but also in terms of this baseline, I've been hearing this often that if we are GDPR compliant, we have easier time of this. I don't know if somebody's done a study of that what is the delta between GDPR and compliance here? And is it really very low so that
I think it's also going to be use case based, right? I don't think you can have a blanket delta. I don't think it works that way.
Yeah, and especially because many of the rules are still emerging here. So you don't know exactly what the delta is maybe, but I would love an answer on that. And you want to take up Nikhil's question?
Yeah, sure. So I think the 4-5 years ago problem around what you're saying around phone book upload, doesn't really, it's not that prevalent now, because if you're downloading Truecaller from the Google Play Store and the Apple Store, then just the, uploading a phone book as a consent, it does not get asked, because if you do that, then you are violating basically the policies of Google Play Store. If you're downloading Truecaller from other sources, then we very clearly ask you for consent to upload phone book data. And there you can say no and move on and also continue to use the platform. I mean, use the services that Truecaller provides you. To your specific point around...
So it becomes someone else's problem that they're the ones who are uploading the data in a sense?
No, I think in the current context, I agree. The way the act has been put out, are we really thinking about what that looks like for India? Honestly, it's not going to change our operations or even our hit rates to a very large extent, because we've been now in India for quite a few years. And so I think we're okay there. We feel pretty confident. But to your point on you're giving consent of some other person's private information to be then used by Truecaller, I think those are things that we're still working out. What does that look like? What is it that we can do to solve for that? But I don't really have a clear answer, only because we're also seeing how does this the specific clauses really get operationalized? What do the rules look like? And we'll have a much clearer answer then. But it's something that we are certainly thinking about day in and day out and figuring out what that looks like. But does that impact our business, or does that impact how Truecaller services are provided? Not too much.
And this came up a couple of weeks ago at a data discussion we were having in Bangalore as well, right? And we were talking about this being a vicarious consent problem. Can I give consent on behalf of somebody else? And in all fairness, this is not just a Truecaller problem, right? This will arise for all of us, say in the employment context. I have I can rely, say as an employer, I can rely on this exception to process employee data. But if I'm asking you to give me emergency contact numbers, names, addresses of 3 other people that I can reach out to in case of an emergency, right? Now, does that exemption also extend to me processing their personal data, or does it extend to only me processing your personal data if you are my employee? So that's one. Second is, in this case also, it's basically if you're relying on consent and not on the exemption, it's again a vicarious consent problem, right? You have to tell me as the organization that I have taken consent from 3 other people to share their personal information with you. Otherwise, I as the organization have to go and contact these 3 people into 8,000 employees that I might employ in the country and go and take consent from everybody. So this vicarious consent problem, I think, is something that we're going to encounter at several times and in several sort of situations, not just in a Truecaller.
So pretty much a national scale.
Yeah. And this is just one thing, right? Like there could be many situations in which you've got this kind of vicarious consent type thing.
Yeah, I think yesterday the example of a gift, which is a surprise gift, was this thing that you are, right?
Yeah.
And I think GDPR requires that that person's consent be sought finally before processing that data.
Like if I want to, I want to ship something to you, right? I want to gift you something. I have to enter your name and address on my e-commerce platform of choice and send it, right? But if I take your consent, then the surprise is ruined. So,
Yeah. Okay. On the GDPR question, anybody?
Yeah. So just 2 things that we know that are different from the GDPR and do require you to think differently. The first one and the most obvious one is obviously the Indian language requirement, right? So the fact that you need to provide options of notices and requests for consent in multiple languages is unique to India. But the other big thing that I think is also, you can't just copy paste your GDPR compliance and bring it to India, is because our legal bases are different. Our grounds for processing are not the same as they are under the GDPR context. And which means that when you as a company, even if you're GDPR compliant for your operations that are covered by the GDPR, when you come here and try to think about how to then prepare compliance for your India operations, how you do data mapping and how you basically map personal data and purposes to different bases has to be a exercise you start afresh. And that is time taking. That is something that will require even a GDPR compliant organization to figure out. It'll require guidance also on what different grounds mean. And so I feel like, it makes sense that organizations that have complied with foreign data protection laws to be better placed than those that haven't, but it's not like it's a cakewalk for them as well.
Okay, so I want to just quickly bring up this thing on around breaches, and then maybe just open up for some questions. There are a few other questions we have. But on the breach side, do you see challenges? Now, clearly, there are different sectoral regulators and there are different requirements on the breach side. Now, just as an example, RBI did have the 6 hours thing for bank, then CERT took it up. So, but sectorally, if the RBI's thing were at 4 hours, that would still override the CERT requirement as far as financial services providers were concerned. So between the sectoral and this, I think that part is reasonably clear, but there are a number of other questions which have been raised around, breaches when it's a government data fiduciary and there is a, there's a data processor which is processing that data, and there is obviously a contract, and a lot depends on the contract. So do you see any challenges on the breach reporting part of it as brought up in the DPDP Act?
I just wanted to make 2 points here, just coming from the experience with the security incident reporting regime under certain. So there are a couple of things that are different between how we as industry currently navigate security incident reporting and what this law now requires. The first thing is that obviously here for the first time, we have to think about reporting personal data breaches, not just to an authority, but also to affected data principals, which means that like there's a additional scale and dimension to breach reporting that has to be brought out. I think the second thing that is a challenge that many people would like for India to learn from other jurisdictions is that, and this is a larger point around the law and all the obligations are designed generally, is that, but breach reporting is a good example of this, that data protection law globally under most jurisdictions adopts a risk-based approach. This can be not just in how you have to report data breaches, but also in terms of how you do data protection impact assessments or how you design security safeguards, right? So we would love to see that in your breach reporting rules, how can you adopt a risk-based approach where you don't treat all breaches on equivalent ground and you can scale accordingly. So like reporting obligations should be staggered in accordance to the proportionality of a breach to the risk that it poses. So the example that I am giving right now is because I've looked at it is the Singaporean data breach reporting regime. So the difference between our law and their law is that in the law itself, it says that only certain breaches are notifiable if they are causing a significant harm to an individual because they lead to the disclosure of some kind of information that is particularly sensitive to that individual. I think over there it's identifiers. And here, the other kind of notifiable data breach is something that is impacts at significant scale. So in the rules, they've clarified that it impacts more than 500 people, which obviously makes sense for Singapore because it's a city, but you would want to see a differentiation based on risk in the breach reporting requirement to come out. And then there is already in the Act some reference to risk, like in how basically monetary penalties are supposed to be computed. There is that standard that is pretty much taken from the GDPR standard on penalties for monetary penalties to be proportionate, dissuasive, and effective. But the key word here is proportionate, right? So why isn't proportionate also a word that factors into rule design and into your approach to designing privacy compliance programs as well? So I think breach reporting needs to bring that in.
So on this, on especially the point of breach reporting to data principals. So Tamogna Pragya, would like your thoughts on, coming from the company's point of view. Now, if you take a lot of sectors, financial services is a case in point, they're very hesitant to report breaches to end users and customers because panic, it'll bring down the share price. And that has happened in so many cases when there have been major breaches. Obviously, there is a very likely impact on share price, etc. So the proclivity and the tendency is to not really report breaches. minor breaches, yes, we don't want to just go ahead and report everything if it's really minor. Major breaches, we don't want to do that because it will cause panic and whatever. So how do you see it from the company's point of view? This has not been, this is, I think, work in progress in terms of the timelines.
Yes, and in terms of rulemaking as well.
In terms of rulemaking, yes, it's open to the rules.
So I agree with what Varun is saying, that this needs to be a harm-based approach. I mean, for principally aligned that we owe the user a duty if any kind of data is being leaked from a data fiduciary. Now, what kind of data and what harm is being caused is something we will have to figure out. Something as simple as what an example that you gave, if it's a credit card number, it is being leaked. A user's credit card number being leaked should be notified to the user, because otherwise their money may be in jeopardy, something which is hard earned, which belongs to them. That is the basic principle what this act or any other privacy act is trying to figure out. Now, if it is something which is where I was coming from, where we are trying to figure out internationally, let's say something like an advertising identifier. Now, if you, I'm getting a bit technical here. If you look at an advertising identifier, it may be PII, it may not be PII, because I can say 30-year-old man in Delhi likes shopping for shoes. I'll add the name Varun. Just giving an example. Okay, I'll add the name Varun here. Now here, when I add the name Varun, it becomes PII because there are certain identifiable factors which are being given in. Now, these advertising identifiers have been within litigation in various other jurisdictions as well. In India, how it will be looked at, I don't know. Now, if that is a data breach, then do I notify or not? Because if Varun is shoe shopping, is that a cybersecurity incident?
No, I hear you on this. I think, there's obviously multiple views on this. And if you get to specific examples, I mean, I could argue that card numbers are irrelevant. My card number is happily available in various places because you have so many, your second factor, etc. On the other hand, when usernames and passwords are leaked, what companies tend to do is simply force a change of password, okay, and not notify. But the problem is that people tend to reuse those usernames and password in many places, and that's why they are at risk. And so, so you have such where your first example was financial, and I know, but the thing is, financial has second factor, third factor authentication, whereas this one, which is not reported anywhere, you go into this, have you been pawned, and you put in, you'll see 19 places where your username and password have probably been leaked.
Can I add one thing?
Yes,
here?
please.
It's a very interesting thing that I saw. So on some international credit cards, there is no two-factor authentication, because of which most number of frauds do happen through that. So if there is a data leak for those kind of cards, it is always essential. I would not like you to lose your money in that space. So that from those perspectives I'm talking about, obviously if there are enough security considerations, then you see if there is harm or no harm. That is what we need to eventually figure out.
Okay, so I'm going to come back to this if you have any thoughts on this, but I want to
we
just
need to move to questions. But
yes,
just you started on the advertising and profiling part. I'm just wondering about how this is going to change cookie management, which is something that's being discussed globally right now. There are Apple's banned third-party cookies. And let's speak realistic about this. Most advertising agencies in this country are completely oblivious to what's happened with the data protection bill, at least at an operating advertising planners level, right? So do you see any implications from an advertising ecosystem perspective, both as an advertiser as well as a carrier of advertising, maybe?
As I said earlier, it will depend on how these rules will be formulated in terms of we are all trying to figure out, okay, this is PII and this is not PII. Because at the end of the day, personal data, the definition is quite wide enough, which can be a catch-all. but it will again depend on how the rules are formulated for us to understand even that if this is particularly can be said that it is this identifying a person or not, because advertising at the end of the day depends on that. What you rightly said, that if it is an advertiser who's targeting certain users on the basis of their preferences, it will is a preference personal information or not, because it is masked behind anonymized data also in a lot of cases.
So you would want to look at harms based rather than, the rules. I mean, the rules may or may not frame it this way, but you'd really want to look at the possible harms emerging from this, right?
Eventually, the rules, what I believe, eventually, when we're talking about a collaborative aspect of, rule making also, that's why I said it's an exceptional act, because when it was passed, it has left a lot of space for us to negotiate as an industry and as citizens of India to figure out how this act will be built out further.
So one quick answer from each of you, including Prasanto maybe. What's an ideal way of provide for a data fiduciary to provide or to ascertain verifiable consent? We'll start with Neha.
There is no ideal way. There is really no ideal way. Nor would I, actually, in all seriousness, nor would I want there to be one ideal way, right? Because for verifiable, and there's a conversation.
Correct. So of all the myriad ways of verifying, pick one.
I can't, because
Pick five.
you have to do three things. No,
Pick five.
Can't. How do you do that?
Yeah.
What works for you will
I
not
think,
work for me, will not work for him.
Absolutely. And like we were discussing yesterday, a lot of it is going to come around to the smartphone. And the problem with the smartphone, I mean, multiple problems are known, including the fact that families share smartphones. Kids are using the smartphone more.
Okay,
The kids have more agency over the smartphone than the parents. Yeah.
Give me one. So one mechanism that you think might work. So nobody knows how verifiable consent can be done in a manner.
Right, but like it's not. There is
there
is no one gold standard, Nikhil. I don't think anybody will give you one gold standard.
I think give me five. Not
Somebody was
high
saying
five, but
self-attestation.
sorry. Questions?
Yeah, go ahead.
Okay,
Please.
right at the
You
back.
had your hand up at the back.
First, let's go to Jagan. He has the mic.
Hi, good evening. Well, very nice panel discussion. I have two parts to this. If I may add the difference between GDPR and DPDP, a few points. One is there's no processor obligations, right? Two is the nomination. DSR rights nomination exists in DPDP. Three is the fiduciaries are accountable for everything. DPB don't have rights to call out any rules, right? DPB only is a regulatory body. And you will have data scraping allowed, I mean, which is publicly available, dangerous thing. And employee data processing. I thought I'll just add to what the panelist said. Well, my question is fiduciaries, all right? Since there are no obligations on data processors, right? What are your suggestions on how fiduciaries can accommodate this? Because one is it's only via contract. I mean, that's how DPDP calls it out. But contract will not suffice, right? Because if it's at the end of the day, if the fiduciary is obligated to everything, and fiduciaries, especially in India, are going to be working with smaller processors, large processors, and the smaller processors may not even understand the law. And second thing is, how do you even force them to align with the law? Because as a fiduciary, you're obligated to ensure everything. You're accountable for everything. If a data breach happens with the processor, you're accountable. So it should not end up in a situation.
So great point. I'll bring the question to the panel, but just one quick point that, if you take again certain sectors, financial services is a great example always, because it's, it has very stringent rules, including very stringent contracts with processors. Okay, examples we were discussing earlier, SBI cards used to be handled completely by G Money. The kind of contracts which were in place were intense. I mean, if anything happened even at SBI cards internally, G Money was responsible as a processor. I mean, that overrides everything else. And this is also true, of course, of, when the entire IT services industry is processing financial data of global customers. Extremely stringent contracts, which have very severe penalties, which far exceed what DPDP Act has. Anyone like to add on?
So I just want to bring out one nuance about this entire act applying obligations on data processors issue. I just want to point out that in section 4, it says that a person may process the personal data of a data principal only in accordance with this act. It doesn't say a data fiduciary. So it says a person which can theoretically apply to any organization, any type of organization, like without taking into consideration what context you are currently serving in that processing operation, right? So, and it also says that that processing has to be for a lawful purpose. So if we take that as the starting point, I think what we will have to see come out through industry practice and over time also, like through, let's say, like as in how the board ultimately interprets this, is that you're going to end up seeing the fact that even data processors still need to ensure that they are meeting this requirement within the bounds of the instructions that the data controller gives them. So that flavor will play out in how exactly your contracts with your data fiduciaries are structured. How this has to happen, I think, like as in, is not something anybody can answer right now. But just wanted to point out that that section doesn't say a data fiduciary. It says a person, and we need to think about what can that mean in practice.
Yeah, including situations where the government fiduciary is actually exempt from certain rules under the DP Act, but there is a processor who's processing data, and the contract may be very stringent about liability and responsibility and accountability of the data processor, even though that fiduciary is technically exempted.
Do you want, so I actually think that the way this will play out in practice is very strong back-to-back contractual arrangements, and I completely agree with you. I also think that sectoral regulators will have a role to play here, because you will have maybe some guidance coming in through sector-specific regulations in terms of how stringent or not the obligation should be, financial sector being one classic example. But a couple of specific clauses that we do see in controller processor contracts say audit rights, right? Starting, obviously, you want very strong reps and warranties coming in from vendors, processors that you're working in. At the very least, they have to tell you, yes, we are compliant. But you want to get as much information at the due diligence stage as possible. What are the organizational measures you have in place? What kind of technical safeguards do you have in place? What kind of standards do you use for a cybersecurity, et cetera, point of view? Then coming into, sort of how you're going to implement all of this. Audit rights is something that we try and see, but again, it's very hard to negotiate. It'll really depend on how strong the party is. Maybe we've seen in some situations people landing somewhere in the middle, where maybe you've got a neutral third-party auditor who will, verify whether or not your systems are safe or not, even if you don't want to give me visibility. Very strong indemnity, type clauses. Basically, if I'm on the hook, then you're on the hook together with me. And we've seen essentially those kind of very strong language built in. All of it gets negotiated depending on whether the controller is more powerful or the processor is really more powerful. Right? So,
I think, just one extension of that we have 6 or 7 critical infrastructure areas now. Some of them are really badly off in terms of the data related laws. Healthcare is one of them. The DPDP Act now brings up everybody, hopefully, to a certain level. But some of them, like financial services, are far above in terms of stringency of contract and so on. So that's what
we have 4 minutes left.
Okay,
So
go ahead.
Let's take both the questions together and quick answers, please.
My name is Akshit. My question is, how expensive or not expensive is it for companies to fulfill obligations of data fiduciaries? If you can give us some numbers, that would be great in terms of per user cost of user verification or total cost of availing a service. So can you give us any idea or context on how, what are the cost expenses looking like for data fiduciaries?
Yeah, and just going back to the discussion around notification of data breaches, I'm just curious to know whether the Act actually allows any latitude to not report some kinds of breaches to the board and the principal.
Okay, you want to take the second question first? Any latitude to not report a breach?
I don't think the latitude is, and I didn't mean to also intend that the latitude is that you can't report something. I think it's a question of form and manner of reporting. And so you can differentiate between high risk and low risk. So you could have summary reports for low risk that like come out, at like longer intervals, and high risk ones are the ones that you need to report upfront. So obviously, like as in this requires probably an entire panel discussion on its own. But I don't think that the idea is to say that you will not report something. That's not what the Act intends. But that is also not what a risk-based approach would also entail, right? Like there clearly is a way to differentiate between breaches based on harm or impact.
Okay, the first question on the cost of compliance, with any examples like cost of verification, anybody has Truecaller, your cost of verification for a user, do you have a cost?
And just before that, just to help, like, I don't think it's also possible to compute the cost
is,
of
I
anything
agree.
before the rules are out. So like, as in, this is also literally crystal ball gazing at some stage, but anybody wants to do that?
Yeah.
After you say that, no.
Like-
But that's exactly what I was going to say. It's too early to say. Too early to really.
Any last question? We still have a couple of minutes. Okay.
No? Okay. All right. Great. Thanks. We've had a pretty good discussion with, a few takeaways, including, I think, the industry coming together, maybe for some joint guidance to fill in the void of guidance, which may be there at the other side. Thank you very much. And yeah, forward.
Thank you.
Thank you. So last sessions on the data protection board. I'll let Aarti take it from here.
So thank you so much, everyone, for staying to the last session. Today, we're going to be speaking, the last session today will be looking at the elephant in the room in practically every other discussion we've had over the last 2 days, which is the Data Protection Board of India. I'd like to invite the panelists and the moderator to the board. We have Meghna Bal from the SIA Center, Anirudh Burman from Carnegie, India, Arya Tripathi from PSA, and S. Chandrasekhar from KNS DigiProtect. And Alok Prasanna Kumar from the Vidhi Center for Legal Policy will be joining us online as well.
Some people sleeping who will attend.
Hi, everyone. Can you hear me? I hope. As the disembodied voice joining from Bangalore.
Hi, Alok, we can hear you.
Perfect. Sounds good.
We'll wait for 30 seconds exactly for people to settle down if that's needed, because we had quite some heavy duty discussions around the data fiduciaries. Welcome, everyone. My name is Arya Tripathi, and we would be, as Aarti mentioned, literally speaking about the elephant in the room. Just to set out the context, often when we discuss what is the first provision, if the DPDP Act were to give in an incremental sort of approach for implementation, what is it that is going to be absolutely critical to be implemented in the first instance? And quite a resonating response from many people that I have interacted is that the provisions concerning the Data Protection Board of India. So we are talking about a new regulator that would be in charge of implementing the seminal law, which is Digital Personal Data Protection Act. And without further delving into it, I mean, a substantial portion of the statute talks about what is the Data Protection Board of India in maybe a full-fledged 100% manner or maybe not. And that is exactly where this panel is very relevant, because it's a very common mindset that what if I don't comply? Who is going to watch? Who is going to notice? And what are the consequences? As a lawyer, of course, we need to give a realistic assessment of, okay, fine, you're non-compliant with the Digital Personal Data Protection Act. And now what? Is the Data Protection Board of India does it have enough teeth to catch hold of you and impose a steep penalty? Or is there more to it? With that, I think we'll start with the first critical aspect here, which is the composition of the Data Protection Board of India. We know that there will be a chairperson and there would be certain members. Prescribed and or notified is the operative word that has been used throughout the act when they're talking about what Data Protection Board of India would look like. And there you would notice, if you pay a little bit of attention, that substantial degree of watering down has happened over the years, how it started to look to where we are finally. Where now we have a very vague sort of a approach where we have stated that, okay, some of the qualifications could be technology, data, but we'll make sure that we will have one person with the background knowledge of law. And then we have certain very problematic, at least to me, problematic propositions, because we talk about the Data Protection Board of India being an independent regulator. But at the same time, we also do see a large degree of intervention that possibly the central government, which is also going to be the largest data fiduciary in this country, have in the Data Protection Board of India. So my first question is to Meghna, that do you agree that it has been watered down? And if you do you think this is going to be the whole absence of maybe a separate degree or of independence is going to lead to a constitutional challenge when the act is implemented on the constitution and composition of the Data Protection Board of India?
Yeah, thank you. So I guess I'll play devil's advocate here, because I've seen what let's say a very active and so-called independent regulator is like in action with the TRAI. Part of my background is in broadcasting. And there you have a regulator which has issued something like 17 regulations across 17 years, perhaps more, actually more. And each of those has been challenged and gone to litigation. And then, and it does it within 6 months of, it brings out new regulation every 6 or 7 months. It's extremely active. So I think from that standpoint, a neutered or slightly diluted regulator is not a bad thing. The strange thing about this board is that I feel like they thought about the copyright board in some sense when they envisioned it, because it's a very limited role that it plays. The copyright board was mainly looking at, resolving tariff disputes between service providers. But in this context, of course, it is constructed in a way that it doesn't have any suo motu power of its own, so it can't look into anything itself. It can only operate on complaints. And in that sense, then one can begin to question the pragmatism of this. And actually, it's an interesting, if you look at it more broadly and kind of step away from, let's say, the structure of the board and everything, it really speaks to the way, taking an analog from India and trade policy, the way that India tries to balance pragmatism with some sort of value-based moralism. And unfortunately or fortunately, or however you want to take it, that pragmatism is taken with a lot of suspicion, because the state has done very little to imbue confidence in the public and, kind of build a relationship of trust with them. So in that context, yeah, there's a lot of uncertainty with how this board will operate, and there's a lot of suspicion and I would say trepidation about what it's going to ultimately be used for. Is it going to, on the one hand, be fining people who may have some legitimate concerns, and on the other hand, entertaining inquiries from vested interests? And that is a legitimate concern because it happens in courts all the time. The other thing, just speaking a little bit about the composition of the board, and again, going back to the example of the copyright board basically became defunct because there wasn't a technical member. Now, if you look at the composition of this board and you consider it against another quasi-judicial body, which is the I'm sorry. If you juxtapose it against another quasi-judicial body, which is the CCI, lots of aspects of regulatory design are similar. And if you ask anyone, on paper, an IAS officer, an economist, and a judicial member is kind of an ideal troika in the context of a regulatory body. But over here, given that it is quasi-judicial and there's only one legal member, doesn't even have to be a judge, that is again somewhat questionable. So yeah, that's where I'll leave it.
And I'll take it a little ahead from here to even add that if someone were to look at the fact that the alleged violation is perhaps by the central government in its capacity as a data fiduciary, in terms of actual composition, how significant it would be that the role that central government really plays in deciding what the composition is, or how informally it has an ability to sway the direction in which the Data Protection Board of India is going to operate, should be enough of a concern when we evaluate the entire law from a constitutional validity perspective. And this is a perfect segue to actually take a look at the powers of the Data Protection Board of India. Meghna, you have absolutely on point that there is absolutely no suo motu power. Our earlier panel was very correct that one of the important parts of advocacy and awareness around this important law, which intersperses every individual's life in this country, that is missing. And if just for the benefit of everyone here, what does the Data Protection Board of India what is the power? The power is basically a power to conduct an inquiry, and that inquiry can be initiated through a complaint or a reference or a direction, not suo motu. And once that inquiry moves in, you are going to evaluate certain grounds, take into account certain factors to determine whether there is a prima facie case of the breach of the law in question, after which you will go ahead with a full-fledged inquiry proceedings to decide whether there's a significant harm, and if there is, then what is the amount of penalty. So this is just the broad framework. Of course, the devil lies in the details. But in this scope of power of the DPBI, what is concerning is that the ability of the central government to actually make a reference to trigger the mechanism of Data Protection Board of India. And Alok, I would like to pick your thoughts on this. How do you think this is going to pan out in real life? So is the central government going to write down a reference, a direction saying that, okay, I want you to look at this particular incident concerning a particular data fiduciary?
So let me just sort of start with one conceptual clarification. I wouldn't call the Data Protection Board a regulator. A regulator, strictly speaking, will have legislative, executive, and judicial powers. You may call it quasi-judicial or whatever, but they have some combination of the three. At best, this board has certain judicial powers. Keeping that in mind, in terms of the reference, I would think the basis for a provision like this is that, let's say something comes to the light of the government, and no individual who's personally affected may be in a position to challenge this, right? Or maybe in a position to approach the court, or maybe in a position, it is, to use another legal term, it's a sort of parents patriae kind of jurisdiction, right? Like what was done in the Bhopal gas tragedy case, where the government took up claims on behalf of people. Like it's some sort of a situation where the government, it may not be it cannot be affected by itself. It's just, this is not a law to deal with government data breaches, it's to deal with the violation of data, personal data of individuals. Government may, on behalf of such individuals who may not be in a position to approach the DPB, or maybe to diffuse a number to act coherently, may say, we make a reference like such and such data fiduciary has committed a violation of the, or we think they have committed a violation of the act. Please undertake an inquiry. Problem is, this is not a very, so let me just clarify two things about the legal process. Now, in one, there's an investigation, which is what the police does, which is also what the CCI does, for instance. They go out, they find out the facts, and they undertake the exercise. An inquiry requires you to come before that authority and place the facts before them, right? So what happens in court after an investigation is done is an inquiry where somebody says, okay, police has said this, we believe them, therefore this, or we don't believe them, therefore this. Even if the government makes a reference, is the government going to be a party? Is the government going to do the investigation? If so, which wing of the government? If so, will it be Government of India versus such and such body? What are the capacity? I mean, are you just going to passively sit there as a data protection board and let two parties decide this issue? I mean, provide the evidence and the arguments and decide this issue passively? I think that is what is not clear. And Unlike with, say, a reference made by the president to the Supreme Court, which is purely on issues of law. And the Supreme Court has consciously said in the past, we will not go into questions of fact in a constitutional reference made by the president. Here you are asked to go into facts. But who will discover these facts? Who is carrying out the investigation? Who will amass the evidence necessary to make out a case one way? Because obviously the company is going to present its evidence on the other side. Is the government equipped? Is the government able? Is the government, who is the government? Which part of the government is going to undertake this? Is this meaty? Is it not? We don't know. And I think, in a sense, this reference, I'm not even sure if the government is going to use it as much, because now it's taking upon itself the burden of doing what an individual is required to do in this case, which is to show there has been some violation of their rights. Now, the government may not be in a position to say, okay, we can do all this investigation and produce it, because where is that legal framework which says this part of the government will investigate, this is how they will present, like you have in the Code of Criminal Procedure on how investigation takes place and how a case moves forward? You don't have any of that. So it's a nice provision. I'm not so sure if it will be invoked that often by the government.
And that's a fair point that it may be not right to call it a regulator, but if we call it or classify it as a quasi-judicial body for which enough statutory provisions are there in the Act, the immediate thing that I am concerned about is how does it really, the orders of the DPBI, how does it get enforced? And Anirudh, if you could take that up.
Thank you for that question. And I think there is a serious problem with the enforcement capability here, because actually there is nothing about the enforcement in the law, right? There is no provision which says what happens if you fail to pay the penalty, what happens if you do not comply with some direction. Yes, you can go, the DPB can open an inquiry, but suppose you refuse to then comply with the result of the order of the DPB, right? So if you look at most regulatory authorities, most quasi-judicial bodies, there are consequences for violating the order of the regulatory agency or the quasi-judicial body. So the simple answer is there is very little here, and I mean there's a gap here, and it's almost as if you're relying on the good graces of the firm to actually comply with the order of the DPB, right? So, and yes, you will have a particular category of firms who will comply, because I mean, it just looks bad. They're required by, maybe if you're a foreign firm, then you're required by your home country regulator to actually comply with domestic law in other countries and so on and so forth. But there will be another category of firms who will actually might not want to comply with this, and there's very little the DPB will be able to do, right? So then you again have to go to a civil court and try and enforce the order of the DPB through the civil court mechanism, which makes the whole point of coming to the DPB kind of pointless, right? And I think there are other problems here that make that entire process pretty problematic. For example, is the DPB going to sit as a board for every single matter? Or are there going to be individual members of the board who are going to handle matters separately, right? So if it is the latter, then it's very different from the CCI kind of structure that Meghna was talking about, right? And then there are entire process-related issues about inquiries, about investigations. And even as a quasi-judicial body, if you compare it to, say, the provisions for inquiry, for investigation given to the SEBI or to a TRAI or to any other financial regulator, the provisions here are pretty sparse, right? So it's basically, you come there, you make a presentation, you have an inquiry, and then you just go, right? So there is a huge gap in how we are thinking about how this entire process is going to flow. And it also leads back to the part that, okay, if you have only individual members who are going to pass orders, right? Shouldn't then every member be qualified in a certain way so as to be able to pass orders? Or, I mean, because the point of a board works where the entire board collectively sits in on a decision and passes an order. And there are some legal members or some quote unquote judicial members and some members who are technical experts, right? But if you're going to have a system where the chairperson can basically depute saying, you take up these categories of matters and I'm going to handle these categories of matters, then that entire rationale for having that board breaks down and that variety in qualifications and expertise breaks down.
Yeah, and even to discharge the functions of a civil court, or for that matter, knowing when to ask the investigating agency to really help the Data Protection Board of India in its investigation process becomes even more difficult. But then now I would like to ask Chandrasekharji. So the appeals, DPDP Act actually states that TDSAT is going to look into appeals, and an appeal is open for even the Data Protection Board of India. So the situation would be that I didn't pay a fine, so DPBI can actually go and appeal to the TDSAT. And there is a small minuscule provision there which says that TDSAT's orders can be enforced in a certain manner. So in your point of view, do you think that it is only when an appeal has been adjudged that enforcement would be likely, or do you see any silver lining in the rules that nobody knows of?
Yeah, I mean, I haven't gone into this part in great detail, but I think when it goes to the TDSAT, I mean, I would probably pass this question because I haven't given it a thought. Yeah. Yeah.
Meghna, would you like to take that up? My question is that when it goes to TDSAT, there's a small provision which says that this is how it is going to be enforced. The same way as Compact states that it's going to be enforced as an income tax arrear matter, or for employment dues as a land revenue arrear matter. So that's only there for the TDSAT. Does this mean that statutorily we are looking that you necessarily need to go in appeal if somebody fails to pay, and then TDSAT can really require the enforcement?
Yeah, so I mean, I think more broadly, there's a problem putting a telecom appellate tribunal on top of some data protection, which again, they are likely to not have any subject matter expertise. If you look at the TRAI Act, TDSAT looks at disputes between licensees, consumers and licensees, and licensor and licensees in telecom and broadcasting. I know that cyber stuff has also come to them, and now this has as well. So, I mean, yeah, again, just the question of capacity, I think, overrides most considerations, because one is, I don't know how they're going to find a technical member for the board itself. I'm assuming they'll want one. And then to Anirudh's point, if they're going to divide and conquer, I'm not sure if they're going to do that, but if they do that, it's going to lead to a lot of, I would say, inconsistency in outcomes. And then depending on how the TDSAT looks at it, or what kind of capacity the TDSAT goes on to build, that's one consideration. But then ultimately, and I think that's a problem you have with most regulators in this country, right? There's no legitimate testing of their decisions. Here, I guess, yeah, you can't call the DPBI a regulator really, because it's a very limited ambit that it has. But even in the context of TRAI, you have the TDSAT, but then you also have the High Court in the context of, the TDSAT can't look at disputes between TRAI and licensees in broadcasting or telecom, and that they have to take their matters to the High Court, where you have non-specialized judges dealing with highly technical matters. And it usually results in the regulator having its way, because they say, oh, there's presumption of constitutionality, there is presumption, we have expertise in the subject, blah, blah, blah. And they usually do pretty well in courts, or courts are generally loath to get into the technicalities of regulation. So, I mean, considering all of that, yeah, I think it's going to be quite uncertain. It's going to take time to settle, if at all.
I had a question for Shekhar, actually, and maybe Alok can also jump in. I'm just curious, and Shekhar, you've been in government. Where do you see choke points in this entire regulatory framework around the DPB? So what sort of capacity would a data protection board need? What sort of a capacity would, let's say, MeitY need to make rules? TDSAT very clearly, with its limited number of members, is already an existing and a massive choke point.
But even before it gets to TV side, where do you see the choke points?
Yeah, so there are plenty of choke points. It starts right from the structure. So I would not even call this a data protection board. I would rather call it a data protection administrator, because very less powers have been given. They are basically going to administer. Government is going to decide everything. Government is going to tell the rules. They are only going to probably ratify it or ensure its administration. So the first choke point starts at the structure itself. The next choke point will be the capacity. So like, for example, one of the previous panelists said that a lot of investigation has to be done. In the case of CCI, you have a DG investigation, a particular office who does investigation and then brings things to the CCI. The third thing is that with such a large country, with so many data fiduciaries, millions, billions of data, capacity will be very limited. So it's a very new area, a very new domain. So the number of people who will be eligible. The fourth thing is that they have kept the tenure only 2 years. So it's such a complex topic, a complex subject, that by the time they build their capacity, they would be out and then somebody else would come. So probably the tenure should be lengthened. And the fifth thing is probably they should have a bigger board, or maybe some kind of a regional board, or some kind of gradation, so that they'll be able to handle the huge number of penalties. So going forward, I see a lot of choke points which need to be thought through. Otherwise, there is a possibility of this mechanism having a lot of teething troubles at the initial stages.
Just to add another angle to for
Sorry,
Alok.
before yeah, go ahead.
I want to add one more angle, Alok,
Sure,
because
sure.
I remember you talking specifically about the need for state level regulators, I think, once upon a time.
Yeah.
And that's something which Dr. Amar Patnaik also asked for many, many times. What are the choke points that you're seeing?
So, if I could also add in the mix the fact that there has to be a reasonable attempt to set up the DPBI as a digital office. Could you just even shed light on that piece?
So 3 things. Number 1, there is one more choke point that I see, which is this training in law does not necessarily mean you're trained in adjudication. This is something which lawyers have realized when they've gotten elevated to the High Court, that simply knowing the law well doesn't mean I have that temperament, ability, and training on how to decide. So nowhere does this say somebody with some experience in adjudication, knowledge of law is not enough. The government thinks somebody who's been a member, a minister, a secretary in the law department is good enough to be a judicial member. That's not true. There have been some members who have been good judicial members, but you need that training in adjudication. These are complex areas. You can't just simply sort of say, I know everything about this, so I will decide. That's not possible. Second point about the state level regulators. See, it's going to be, and it's somewhat linked, I think, to what Arya you were saying. It's going to get overwhelmed very quickly, because the ease in filing, if you say digi-filing, that's great. Everyone will file complaints. This body will suddenly have 30,000 cases on day 1. Right? Not going to be able to function, not going to be able to figure out how to do it. There is one more kind of choke point which we have not exactly highlighted here, which is this preliminary inquiry. My fear is that the board may be, listen, you haven't done enough homework to prepare this case. We are not going to do it for you. Dismiss it. Right? So it'll just become another, practically a post office, where somebody with good intention comes to file a complaint, but because the body does not really know how to go about with this case, says, okay, you haven't made out a prima facie case, and throws it out. So this is where I think, and one advantage of a state level regulator is, like, look at the information commissions, right? You have state information commissions and central information commissions. They're handling tons and tons of work, and even then they have like a huge backlog. It's not as if there's a small elite of 3 million people in this country whose data is being collected. Probably 1 billion people whose data is being collected. Even if a fraction of them, less than 1%, like 0.1%, have some grievance about it, and they file a case, that's about 1 million cases already into the system, right? So this is not a credibly designed body that even if you implement it, you are going to overwhelm it and reduce it to be non-functional on day one.
Just on the existence of multiple boards or quasi-judicial regulators, or however you want to call it. So in Europe, they have that, where you have a data protection authority or supervisor in every country, in every member state, and within that state, within every state. So Germany has 16 states, but one state has 2, and they have one at the federal level as well. So they have about 19 data protection supervisors. And it's both a good thing and a bad thing, because these data protection supervisors don't agree with each other. So there's no consensus on how to implement the law. So there's varying opinions on how far you have to go or how not far you have to go in terms of implementation and what you have to do. So, I mean, yeah, on the other hand, of course, the converse is that this law says that you have to provide consent notices in the 22 languages that are under schedule of the Constitution. At the same time, will this data protection board have the capacity to respond to disputes in those many languages?
Or
So,
even conduct the proceedings in all the 22 languages.
Yeah.
And that is a perfect segue for something that is very interesting called the alternative dispute resolution mechanism. So there is a breach of the data protection law, and but still the DPBI has a power that if in its opinion, it could be settled, please go outside and settle it. How do you think this is going to work? And this is a question for all the panelists.
I think it's a very pragmatic way to resolve the problems. So corporates, for instance, would be very happy not to go through a very long adjudication process. Their first preference would be alternate dispute resolution. And I suspect that most of the cases will be resolved at the grievance officer level itself. And if it goes to the next level, it will be resolved. I think it's a very practical way of doing things, because there is also a tendency to go after the large MNCs with frivolous kind of complaints just to make money, or the possibility of making money. So this will avoid this kind of thing. So I think it's a very pragmatic step.
Yeah, I mean, I agree with him.
Yeah, I would agree with the comment. I think there is a concern that there'll be many complaints, but I think a lot of them will be handled at the grievance redress stage within the company itself. And I think so that kind of ameliorates the capacity question a little bit as well.
And Alok, maybe you could just consider the fact that that would also mean a lot of leakage of fine amount that could be augmenting the capacity of DPBI and enforcement of this law in turn. So the moment it goes to alternative resolution, we are looking at another penalty gone away.
So I'm going to be that horrible lawyer and point out that what will kill this clause is by such mediator as the parties may mutually agree upon. You're already in a conflict relationship. How are you ever going to agree on who's going to be the mediator? I mean, it's possible, and I don't dispute it. Usually, there is some like reference to an institution, right? You refer to institutional mediation, the institution picks up the mediator, or the court or the body appoints a mediator and says, we vouch for this person will be good. This like takes the problematic part of arbitration, where everyone thinks if they chose the arbitrator, that arbitrator has to work for them. And on the other hand, it sort of says this is how mediation will take place. You're already upset at this MNC, or for good or bad reason. How will you ever agree on who will be the mediator for this, right? And who are the pool of people from whom you're going to pick a mediator? It can't be the entire population of the country. It has to be a trained mediator. There has to be certain certification. And there are courses, there are strict rules about this in a lot of places. There has to be certain set of rules which guide a mediation. Mediation cannot be so open-ended that we'll take the next 15 years to decide this mediation without letting you go forward with this case. I mean, this is not it's not a clause which is designed to be realistic or applicable, or even provide a sufficiently effective alternate dispute resolution.
And you had some points?
Yeah, I just wanted to make a small point that
I
penalties
just
are
wanted to make a
actually.
point. Sorry, I just wanted to make a point. Mediation, unlike arbitration, the outcome is not necessarily that I'll participate. Anybody can walk out at any point of time. So it does not mean that if something is referred to mediation, it will lead to one way or the other. Unlike arbitration, where the arbitrator will give an award, either allow or disallow the claim. So mediation makes, and there's a 6 months guideline. You have to close the complaint in 6 months. So whatever reference is made to mediation probably will be with a reference that you must close it in a time-bound period. That's all I want to say.
Yeah, I agree with what you were saying, and I wanted to make a slightly different point about the point you were making about penalties. So this law says that penalties will actually go to the Consolidated Fund of India, which is a good thing because agency should not have the incentive to keep imposing penalties to enrich itself, right? So that's a good thing. But having said that, this law also does not have any provision for the agency, for the board to collect fees. Okay. It also does not have any provision in the law for the central government to make grants to the board for its functioning, for salaries and expenses. Okay. So let me explain this a little bit. So when you set up a new board or an agency which is supposed to be at arm's length, you are worried about three things. One is independence, the other is accountability, and the third is whether the agency will function properly, right? So you are worried about the finances from all 3 points of view. So what you typically do for a regulatory agency, and again, this is not a typical regulatory agency, it's an independent body, right? You typically create a separate fund, which is a bank account, where all the money collected by the regulatory agency gets deposited and it's used for meeting the expenses of the agency. In addition, if the central government wants to give money to the agency to support it financially, because not all regulatory boards are financially viable on their own, the central government can make a grant, right? All of this is usually written down in the law very, very clearly and specifically, that the central government can make grants to the body for salaries, expenses, blah, blah, blah. The regulatory body can collect fees and other charges for meeting its expenses, and so on and so forth. There is nothing like that in this law.
But it can be in the rules.
Yes, it can
But
be.
even the rules have to be guided by the law, right? You cannot create a rule unless there's no legal provision enabling you to write the rule, right? I mean,
sorry, just to add to that, constitutionally, you cannot appropriate money on the basis of rules. It has to be something that Parliament has to vote on. So it's not like the pass a rule saying we'll take X amount of money.
Who's going to fund this body then?
see, the central government can fund it anyway, but the point
if
is,
the law
if you
doesn't allow for it, then how would it fund?
right, so it'll have to find some other mechanism, right? But typically you actually need an enabling clause in the law to be able
So
to
if
fund
the
an
enabling
independent
clause
agency.
doesn't exist, there will be no funding for this body, so it can't recruit.
Yeah.
So the board basically will not exist.
Yeah.
Unless the law is amended now.
Yeah.
Alok?
No, sorry, just to clarify two things. One thing is, what I was saying was in the context of appropriating the money that it gets for a certain thing, the government may make an appropriation bill, doesn't have to amend this law. It will have to pass a separate appropriations bill where it says we're going to give X amount of money to the DPBI, right? So that will bring the money in. This will, there is no provision here, and that was what I was sort of talking about, was mandating that the government spend a certain amount or give a certain amount to this particular body. So each year, this body will be at the mercy of what will be the amount that the government will give us, how much they will allow us to function, and so on and so forth. It is not like, say, courts, their budgets are basically charged to the Consolidated Fund of India. It's just Parliament which sort of says, okay, fine, thanks, and approves of it. This board will be dependent on the government passing an appropriations bill, saying this amount is going to go to the DPBI or that particular ministry, which I think is going to be METI, saying this amount of money will be given to DPBI.
So if the government is not happy with the board,
they can choke it. No, it's going to be a line item in the METI budget. It's a small board. It's I don't think financing will be a problem at all. One good point which I thought will come into the Indian law is, I'm told in the UK, the Privacy Commissioner's Office they get a lot of their funding through approvals, penalties, everything. It goes into the Privacy Commissioner's office. But here it's going directly to the Consolidated Fund of India. So METI is going to fund this body.
Also, just on penalties and accrual of penalties, even if it did go to the board, it will take a long time for the realization of any penalties, given that you have so many stages of appeal. Again, taking the example of the CCI, where it's been a collection of penalties is a problem, takes about 10 years for a case to reach its conclusion.
And we'll open it up for questions. I'm sure I can see a lot of hands.
Hi, my name is Gangesh. I'm with Seraphim Partners. Thank you for this discussion. I was wondering, would the panel want to react on Section 37, the blocking powers that the board somewhat has to approach the central government to say, I've imposed monetary penalty twice. Now, even if they have paid it, I see that there is some risk to general public and very vague words in that entire provision. But what do you think this is? Does it actually empower the board, or is it just really creating a threat to some large data fiduciaries who are on intermediaries' control?
I think the first and only issue is this is not a data protection provision. It should not be in this law.
And if it is a speech provision, then it violates, it's anti-constitutional there as well, because it talks about public interest, which can't be read in as a restriction on a permissible restriction on speech. So yeah, I think perhaps the rationale behind it was to have a 3 strikes policies for non-content businesses, because they don't have it in, or it's a gray area under 69A, which is typically supposed to be for content, but is used for non-content businesses. Could be argued that any website is a content business technically. But for instance, in the case of loan apps, or in the case of the 59 apps that were taken down, there is no specific provision that enables government to block apps on that is not under the grounds under 19.2. Technically, you would need something under the grounds of 19.6, which includes public interest, which is why this kind of reads that way. I don't know if that was the intention. It seems like that. But again, it's a misplaced provision. It should be under the Digital India Act or the IT Act and not here.
Yeah, and just to sort of clarify the procedure for 37, reference starts from the board. Central government then gives an opportunity of hearing to the data fiduciary, has to record its satisfaction in writing before it says please block, right? So I'm assuming, like we have so far, that here central government also basically means METI. So this is, yeah, I would agree with Meghna, but the difference here is actually this is a much more procedurally fair provision than what is there today in the Information Technology Act. It actually gives you an opportunity for hearing, recording of reasons in writing. So which is possibly why it does not directly relate to the kinds of speech restrictions under 19.2 of the Constitution. These are more in the nature of ensuring compliance with the laws, but it's going to come down to this. This is not there are no criminal consequences. You're not sort of saying that these people have violated the law. You've said that they violated the law, yes, but at best it's a civil penalty, and this is not recovering that civil penalty. It's like some other consequence that we're imposing. You don't actually even need to intimates the. You don't even need to actually say that they are like refusing to pay or something like that. It's just that two penalties have been imposed on them, and they can therefore take action. So in a sense, broadly, blocking should all be under one common procedure, which is clearly understood for everyone and exercise power in a different way. But in that sense, this is a much more complicated thing. And again, I'm not so sure how it will be, enforced by and put into practice by the government, because it might just be easier for the government to invoke its powers under the IT Act or whatever future Digital India Act comes into place and just block them instead of giving them opportunity to hear, give satisfaction, note down satisfaction in writings, etc., etc., etc.
They do have an internal SOP for it, though, 69A, though it's not.
Yeah, it's not public. Yeah.
Yeah, so I'm just speculating. It might be a case of repeat violation or delays in paying, or there could be many such use cases where the last resort could be blocking. It need not be something like an intermediary or something as serious as what is invoked in 69A, but some person or some company which is having repeat violations and it is creating a lot of nuisance. And so there were like some companies in the intermediary, I don't want to name the companies, who are repeatedly challenging the government and saying that we won't follow this, we won't follow this, we won't follow this. So if I think for cases like that, blocking might work. I mean, I'm just speculating. It could be for that.
We have two questions, Neha and then Dhruv.
Thank you. Hi, my name is Neha. I'm with Ikigai. And Alok, this is a follow-up to the last thing that you said. And I'm not entirely sure that I agree with you when you say that this is a fairish provision. 37, there's nothing in the Act that envisages an appeal from an order passed under 37. So if I am an aggrieved intermediary, I file a writ against the central government order. That's scenario one. Scenario two is, hopefully I get to appeal the reference that the board has made to the central government. Maybe I appeal that reference to the appellate body, assuming that the government tells me that this is a reference, or it gets, one of the earlier panels was talking about how this should be made, this reference should be made publicly available, etc., etc. But I mean, I can't, there's no way for me to appeal this action of the central government. I have to either appeal the reference and then hopefully this process of blocking doesn't take place at all, or I have to file a writ. That's how I'm reading this, but this is a question, Alok.
Yeah. So correct. So just in the sense, just to clarify, the reference is not an order of the DPBI. It is a reference, and no one can be
correct. Sorry, but just to pause you.
No, just to complete that thought. So you can't be aggrieved by it in order to file an appeal before the app.
It's order/direction.
Correct. This is not an order or correct. This is not an order or a direction. Number one. Number two, you are not aggrieved by it. In a sense, aggrieved has a very specific legal connotation in the context of appeal, which is that some civil right of yours may have been affected. It cannot be that you cannot be aggrieved by just someone starting legal proceedings against you. Only the completion of some sort of legal proceedings can cause you to be, again, legally aggrieved. I'm not saying in a general sense, in a legal sense. That's number one. Number two, the fair part to me is that today, if a website is blocked, I have to go running around to figure out who has caused what, where, how, and why. To me, this makes my job of filing a writ petition so much easier because one, I've been given a hearing, I've been given a chance to raise my grounds. The government records an order in writing. I have an order which I can challenge, and I may win or lose. But to me, I know very clearly what has happened to me and why, and I can come to court, to the High Court, let's say, for remedy, as opposed to the situation under the IT Act where a 69A order is passed, suddenly I don't have access to my account or my website is taken down or people aren't able to access my website and I have to go running around to figure out what has happened, who, why, in what way. And some of this kind of was made clear in the submissions that Twitter has made in the Karnataka High Court case, which is currently pending before the division bench. And their point is, our users come after us saying, why have you blocked me? Why have you blocked me? And then I have to say, no, I have received this order from the government. And then they like give us the order and they say, no, the government has said we can't share this order with you. So again, that's another different Kafkaesque nightmare. Compared to that, I would still say there is an element of fairness here where you at least know, okay, government wants to take this action. You tell the government beforehand, please don't do this because of ABC reason. Government may agree or disagree. They may disagree with me and give a reasoned order. I can still challenge it before court in a manner which I know, okay, these are my concerns and I can actually put them forward because I have a order in writing which I can challenge.
But Neha, you've made it there to state that the central government's procedure, where they obviously as an administrative process need to follow natural justice, and then I don't think there's any remedy under the DPDP Act. You will need to then go to the conventional judicial process. We have one last question before, okay, we have three last questions. Dhruv and then
sorry,
everybody else.
Hi, I'm Dhruv from PSA. I just wanted to touch base on the mediation piece once again. The Act obviously doesn't provide for compensation to data principals for any breach. The mediation provision says that any complaint can be referred to mediation, and if there's an out-of-court settlement, of course, that's going to be honored. Do you see this mechanism enabling some form of compensation to be given, to start sort of to come into the picture where data principals are compensated for breaches just so that there's an out-of-court settlement?
Before all of you decide who wants to answer this, you're right that this compensation provision where, an individual aggrieved data principal could have been awarded a compensation has been taken out, and really the jurisdiction of other courts have been barred. So what is the crux of this alternative resolution when it comes to data principal? Will there be a compensation?
Yeah, in my view, the way I look at it, definitely it will lead to some kind of compensation. Would be monetary, could be apology, could be a publication or something like that, but definitely compensation will be there.
I'll go next. Dhruv stole half my question, so I don't want to give him a steal the other half.
Nikhil, you have some thoughts on this.
There is no compensation. There is no, in the Act, there is absolutely no compensation for the data principal. All penalties go to the government, etc. But when there is a adjudication happening between a service provider and a customer on a data privacy issue, it is between the customer and this. It is between the customer and the service provider what will satisfy the customer. It could be one TV, it could be Amazon vouchers, it could be money or whatever.
I mean, the
So
out-of-court settlement, the mediation is likely to have some consideration. And yes, that's the only way actually the data principal could say that I need X amount of money because you breached my rights, but there is otherwise no statutory way of getting it.
So I just want to clarify, there is no right to be compensated for the harm done. As a tort, if data breaches happen, it's an injury under law of tort, common law of tort, and there's no remedy as a matter of right which can be enforced. It's at the mercy of the, okay, my legal cost is going to be more than,
exactly,
so I'll pay you
exactly.
so much.
That is why I said that it is a pragmatic provision which is likely to lead to this. There is no right, there is no mention in any of in the Act.
Any thoughts on the lack of criminal liability? I mean, my favorite sort of argument used to be that it'll take for someone to go to jail for this law to be made better by courts. That seems to be out the window now.
Yeah, so I think this really a welcome step. Bad news for the lawyers and bad news for people like us, because implementation, nobody's taking it seriously because nobody's going to be jailed. But from ease of doing business, from the way multinational companies look at it, from the way India is positioned as a destination, I think it is a really welcome step, because there was a lot of fear and terror how it will be used.
And there's an increasing tendency to even pick existing laws and decriminalize provisions. So
I know, but I'm saying this is the violation.
But Mr. Chandrasekhar, lawyers may perversely see that as a challenge. What you just said. No. But let me just come to the criminal part of it. It may not be in this legislation, but if somebody is determined enough, my guess would be they will invoke criminal breach of trust. And it's not about getting a conviction at the end of the day. The power of a criminal court issuing notice to directors to come to court and answer the allegations is enough in a lot of instances. So, or a police turning up at your office saying criminal breach of trust against your company, they'll be like, how? They'll say data breach. Sure, raise all your arguments, get your lawyer, but that may be a scare. So again, I'm again using that horrid lawyer hat of mine, but it's possible. This law may not provide for it, but do not put it past some clever member of my fraternity say, actually, I think criminal law is possible to invoke against. But I just want to keep that thought with it.
Okay, what I wanted to ask was, it says monitoring, I mean, the DPB is responsible for monitoring compliance with the law, but it also says when it receives a communication. So does it restrict it to then only if somebody complaints or anything of that kind, or will they actually go and monitor proactively if companies are actually following the law? I think it should be the latter from my perspective. Otherwise, it's only on data breaches you'll be reacting.
Yeah, they don't have any suo moto power. Even the directions that they can issue has to be on the basis of a complaint or a reference.
Yeah.
So,
right. So you don't see that coming out in the rules.
Yeah, so this is unlike some other regulators like Competition Commission and all that, who have suo moto powers to investigate and to look into. Here, nothing like that is mentioned in the Act.
Because the power needs to be statutorily vested, can't be subject matter of delegated legislation. So we'll have to live with the fact that there's only a limited way through which DPBI is actually going to exercise its powers.
Got it. Thanks.
I think just to add to that, and this is actually a big problem with the law and the way the DPB is set up, because if you think about it, the consumer has a very high threshold for coming to the DPB in the first place, because A, it's very hard to understand what's happening with my data, right? Unless I hear about a huge data breach and I take the pain of figuring it out and I go to the company and ask for information and so on and so forth, right? B, there is no compensation at the end of the process that I'm entitled to, right? So it's a huge barrier for someone to come to the DPB in the first place unless you're sufficiently motivated, right? Then you add to that the problem that the board has no suo moto powers of its own, right? So you're actually not creating enough systems through which data protection can be effectively enforced through this law, mainly because A, you have no suo moto powers, and B, the threshold for the consumer to approach the board is actually fairly high.
We'll take one last question.
Actually, most of my question was already addressed. I'm just wondering whether there's any scope for the board to award compensation under Section 27, subsection 2, which says that the board can issue directions that it considers fit. And I think the second part of what I was going to ask is what you answered, in the sense that I think it'll impose it'll stop a flood of cases to come in if the possibility of compensation does not exist.
yeah, I mean, they can't award compensation through direction. And yes, as Anirudh already said, it'll stop. I mean, I think the idea is to kind of disincentivize frivolous complaints, though I don't think it really will, because the people who are motivated to make those complaints for the sake of harassment are not going to be deterred by a 10,000 rupee penalty. The other thing, I know that we said that we wouldn't talk about missed opportunities, but I think it's something that, although I'm always in favor of not a super active regulator in this country, I think something that was missed is what, again, looking at the European Data Protection Supervisor, it has advisory powers. So it provides a lot of clarification about the implementation of the Act and how you can adhere to it. And not only that, it provides clarification on, emerging technologies that may have certain constructs that are kind of diametrically opposed or directly conflicting with the principles of data protection. You wouldn't understand what to do. Like in the case of Web3, where the right to be forgotten becomes virtually impossible, et cetera, et cetera. And so they can issue opinions, and that is missing over here. And I think that is a huge missed opportunity, because I don't know who's going to fill that role. Even in the context of standard contractual clauses, again, the EDPS can do that over there, where they can give you a template of how to kind of draft your agreements, etc. Over here, there's no such clarification that is going to take place. So I'm assuming that people will just model their agreements or their frameworks against what is already in the market. But yeah, I think that's a big missed opportunity.
Yeah, just to add on the criminal liability topic we were talking about for privacy violations, although there are no provisions of that nature in the DPDP Act, however, there is a rather dormant clause in the IT Act, which is Section 72A, which still survives. It's section 43A, which is being repealed under the DPDP, but the section 72A, which prescribes punishment of up to 3 years, which means it's a which means a cognizable offense, and on violation of a lawful contract for breach of personal information by intermediary or any person. So I think that dormant section under IT Act will get triggered after complaints and after people become literate about these particular sections in future.
So you're saying there might be a window between
Correct.
the Data Protection Bill and the Digital India Act, which
Yes.
for someone to file a criminal case.
Yes.
Fair enough. That's all we have time for today. Thank you everyone for a fantastic panel. Thanks Alok, Shekhar, Meghna, Anirudh, Arya. Thank you for a great panel. Thank you all for being here right till the end. It's been a hectic day and a half, and we'll have coverage of this up on MediaNama through next week, and videos are already up on YouTube in case you wish to revisit anything or something that you may have missed. Thank you, and I'd like to thank PhonePe, Salesforce, Meta, and Google for the sponsorship for this discussion, and so Center for Communications Governance at the National Law University and Kutch International for the support. We will be back probably in December unless there's any regulation that necessitates a discussion on the consultation. I think around the December 14th or 15th, we're looking to do something on the impending Digital India Act. So save the date. We'll be in touch. Thanks, everyone. There is tea in case anyone wants. Thank you.
And please do the next one in Bangalore.
Alok, you and I have to have a conversation about Bangalore. Everything is so I used to measure. It used to be 8 hours for I just right now I'm exactly correct. So what I'm doing the thing is we have to not really yeah.